Good morning, everyone. Showtime. Let's see what we got. What we got? Click play button to start. I click play button to start. Trumpy Anderson had this thing circle a long time. Come on. Live oral argument. Live oral argument. I assume nothing's happening. I don't think that circle is me. I think that's just because there's nothing playing. It's scary, though, because I'm like, I don't want to miss the oh, yay, oh, yay. That's my favorite part. My favorite part. I can't get locals chat up. Thank you for reminding me. Thought I'd done that. Good call. And that is done. Locals chat is up at goodlogic.locals.com. Oh, come on. Oh, come on. Should I try it again? I didn't think the court's going to be late at all. I thought this was going to go like clockwork. Like clockwork. Morning from Maui. Wow, in Maui, where it's like 5 in the morning. Right? You're like 5 hours behind. All right, you're spinning too? All right. I left my... give me 1 second. Okay, my beat. We've got something. Late and gay. Late and trying to figure out what a woman is. What is a woman? Show that. Actually. La 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 la. In case you're unfamiliar with what this case is, might be a while since you heard about this case, since you watched me cover the hearings in Colorado. So let's do a little reminder while we're waiting for the court feed to actually start playing. What you're watching there is the oral argument from the Supreme Court feed. I'm assuming that when there's some audio to be played, that circle is going to stop circling, and we'll just hear it playing. So, in case you forgot, the state of Colorado, along with many other states, petitioners, some sleazy folks, some of them, at least one of them is, he's facing all sorts of issues, but I don't want to get into that. That's diversionary. So in the state of Colorado, as well as in Maine and several other states, petitioners brought an action saying that under Section 3 of the 14th Amendment, which says that, well, let's actually bring it up, which was a post-Civil War amendment that was enacted for the purposes of trying to keep out those people who they deemed to be insurrectionists from serving in Congress. So there was the drafters of the 14th Amendment said that if someone had taken a constitutional oath, and then after it's constitutional oath to, well, I'm going to get the language. It's been a while since I looked at it. I don't want to misstate this because every word of this amendment is important. 14th Amendment. Let me pull it up here. There it is. Here you are. Moving slowly. It's loading slowly. I don't think it's going to be stupidity. I actually think it's going to be entertaining. I think it's going to be good argument. I'm going to try this again just because let's hit it all over again. See, I was worried about this. Now it's not doing that. This is live. Volume is up. You don't hear anything, neither do I. But at least it's not circling. I think this is good. Volume is up. Don't worry. If you don't hear anything, you're not supposed to. I don't hear anything either. So, but that means I think this is better than the circle. All right. Where was I? Oh, yeah, I was talking about the 14th Amendment. So, it will start playing, even though I'm covering it now. Don't worry. You'll hear it. I'm not going to miss a second of this thing. So, the 14th Amendment, Section 3 says, no person shall be a senator or representative in Congress or elector, president, vice president, hold any office, civil, military on the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of the state legislature or as an executive or a judicial officer of any state, to support the Constitution of the United States. So that person who has done all that, you can't become a senator or representative. You can't become a senator or representative or one of these other people if you were in any of these positions. You cannot become any of these whether it's federal or state, if you previously took an oath as a member of Congress or as an officer of the United States, member of any state legislature or executive, etc. And what was the oath? To support the Constitution of the United States. Whether that has to be a language literally to say the words to support the Constitution, which is not the presidential oath, or something else, that's an issue which is coming up today. And then shall have engaged in insurrection or rebellion. So some of the issues that the Supreme Court is likely to be addressing is the question of when it says no person shall be a senator, representative of Congress, doesn't it seem to list president, right? So the question is whether it's considered holding an office under the United States, because under the United States, a lot of people who are arguing for President Trump that this does not apply to the president would say that's not under the United States. Under the United States, an officer holding the office under the United States or being an officer of the United States is not language that the Constitution tends to use in referring to president. They actually say that the president appoints people who are an officer under the officer of the United States. He's the one who designates. An officer is not of the United States, is not elected. So it makes sense that would say a senator or a representative in Congress or anyone appointed by the president. You cannot be appointed by the president if you swore an oath to support the Constitution and then you engage in insurrection. Remember, this was post-Civil War. Now, a lot of people would say, well, why would you apply that only to something? You want to punish these people who basically ignored their oath. You said you're going to support the Constitution. You ignored your oath, engaged in insurrection. So if it's going to apply to a lower office, obviously you want to punish those people. Obviously, you would think it would apply to the president. So that's why they want to interpret that officer of the United States includes president. That's what the petitioners want to claim. Trump, however, responds that no, this is an elected office. If the people of the United States all say this is the person we want, then that's their giving a pass to him. Also, they argue it doesn't make much sense to say that right after the...
We'll hear argument this morning in case 23-719, Trump versus Anderson. Mr. Mitchell.
Mr. Chief Justice, and
some of you guys hear this.
The Colorado Supreme Court held that President Donald J. Trump is constitutionally disqualified from serving as president under Section 3 of the 14th Amendment. The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons. The first reason is that President Trump is not covered by Section 3 because the president is not an officer of the United States, as that term is used throughout the Constitution. Officer of the United States refers only to appointed officials, and it does not encompass elected individuals, such as the president, or members of Congress. This is clear from the Commissions Clause, the Impeachment Clause, and the Appointments Clause, each of which uses officers of the United States to refer only to appointed and not elected officials.
This is as loud as I
The
can get
second
it.
reason is that Section 3 cannot be used to exclude a presidential candidate from the ballot, even if that candidate is disqualified from serving as president under Section 3, because Congress can lift that disability after the candidate is elected, but before he takes office. A state cannot exclude any candidate for federal office from the ballot on account of Section 3, and any state that does so is violating the holding of term limits by altering the Constitution's qualifications for federal office. The Colorado Supreme Court's decision is no different from a state residency law that requires members of Congress to inhabit the state prior to Election Day, when the Constitution requires only that members of Congress inhabit the state that they represent when elected. In both situations, a state is accelerating the deadline to meet a constitutionally imposed qualification and is thereby violating the holding of term limits. And in this situation, a ruling from this court that affirms the decision below would not only violate term limits, but take away the votes of potentially tens of millions of Americans. I welcome the court's questions.
Mr. Mitchell, would you, you didn't
Clarence
spend
Thomas.
much time on your argument with respect to whether or not Section 3 is self-executing. So would you address that? And in doing that, your argument is that it's not self-executing, but then in that case, what would the role of the state be? Or is it entirely up to Congress to implement the disqualification in Section 3?
It is entirely up to Congress, Justice Thomas, and our argument goes beyond actually saying that Section 3 is non-self-executing. We need to say something more than that, because a non-self-executing treaty or a non-self-executing constitutional provision normally can still be enforced by a state if it chooses to enact legislation. The holding of Griffin's case goes beyond even that by saying that a state is not allowed to implement or enforce Section 3 of the 14th Amendment unless and until Congress enacts implementing legislation allowing it to do so. So under Griffin's case, which we believe is correctly decided, the Anderson litigants disagree with us on that point. But if this court were to adhere to the holding of Griffin's case, there would not be any role for the states in enforcing Section 3 unless Congress were to enact a statute that gives them that authority.
Counsel, what if somebody came into a state Secretary of State's
Justice
office
Roberts.
and said, I took the oath specified in Section 3, I participated in an insurrection, and I want to be on the ballot. Does the Secretary of State have the authority in that situation to say, no, you're disqualified?
No, the Secretary of State could not do that consistent with term limits, because even if the candidate is an admitted insurrectionist, Section 3 still allows the candidate to run for office and even win election to office, and then see whether Congress lifts that disability after the election. This happened frequently in the wake of the 14th Amendment, where Confederate insurrectionists were elected to Congress, and sometimes they obtained a waiver, sometimes they did not, and each house would determine for itself whether to seat that elected insurrectionist, because each house is the sole judge of the qualifications of its members. So if a state banned even an admitted insurrectionist from the ballot, it would be adding to and altering the Constitution's qualifications for office, because under Section 3, the candidate need only qualify during the time the candidate holds the office to which he's been elected. And under Your Honor's hypothetical, the Secretary of State would be demanding essentially that the candidate obtain a waiver from Congress earlier than the candidate needs to obtain that waiver.
Well, even though it's pretty unlikely, or at least would be difficult for an individual who says, you know, I am an insurrectionist and I had taken the oath, that would require 2/3 of votes in Congress, right?
Correct.
Well, this is a pretty unlikely scenario.
It may be unlikely, but no Secretary of State is permitted to predict the likelihood of a waiver.
That's
because
correct.
in doing so,
Good argument.
they're adding a new qualification to the ability to run for Congress. And the proper analogy, Mr. Chief Justice, is to state residency laws, because the Constitution says that a member of Congress must inhabit the state that he represents when elected. And the lower courts have all held, in reliance on term limits, that a state election official cannot move that deadline any earlier by requiring the candidate for Congress to inhabit the state.
So even
before
if
the date of
somebody
election.
comes in and says, I'm a resident of, into the Secretary of State's office in Illinois and says, I'm a resident of Indiana, I have been all my life, I want to run for office in Illinois, the Secretary of State can't say, no, you can't?
Well, the question would be, is that person going to inhabit the state when the election is held? So if the candidate makes clear, perhaps through a sworn declaration or through his own statements, that he has no intention of relocating to that state before Election Day, then the Secretary of State would be enforcing an extant constitutional qualification rather than enforcing a new state-imposed qualification. And that's the key under term limits. Is the state in any way altering the criteria for a federal office, either for Congress or for the presidency? And in this situation, the Colorado Supreme Court is going slightly beyond what Section 3 requires, because Section 3, on its face, bans an insurrectionist only from holding office.
Counsel, can I stop you a moment
Ms.
and
Kagan,
back up a minute? You admitted that the concept of self-executing does generally permit states to provide a cause of action for breaches of a constitutional provision.
Correct.
In fact, they do it frequently for takings clauses. There's no debate that Colorado has provided that cause of action. You want to go a step further and say that this, like the treaty clause, requires implementing legislation to permit the state to disqualify an insurrectionist
That's correct. So
under Section 3.
that's right.
So history proves a lot to me
Mhm.
and to my colleagues generally. But there's a whole lot of examples of states relying on Section 3 to disqualify insurrectionists for state offices. And you're basically telling us that you want us to go 2 steps further. You want to, maybe 3. You want us to say that self-execution doesn't mean what it generally
Kagan's
means.
telling us where she is.
You want us now to say it means that Congress must permit states or require states to stop insurrectionists from taking state office.
Mhm.
And so this is a complete preemption in a way that's very rare, isn't
It's a
it?
different
Well,
issue.
the only thing I would
It's
disagree.
rare under the 14th Amendment.
Oh, of course it's rare. This is a one-off situation. And Your Honor, the only thing I
Well,
would,
it is one-off. I don't disagree with you, but it's not with respect to how we've defined self-executing.
we're not asking this court to redefine the concept of non-self-execution. We were careful in our brief not to rely on that phrase. And Griffin's
Right,
case
you
doesn't-
are because it's not.
That's right. And
Okay,
Griffin's
so
case,
now the question is a very different one in my mind. I understand what you're relying on, Griffin. Let's just be very clear.
Right.
Griffin was not a precedential Supreme Court
that's
decision.
correct.
All right, it was a circuit court decision by a justice who, when he becomes a justice, writes in the Davies case,
Yeah, this is Sotomayor, I think. I think you're correct.
he assumed that Jefferson Davis would be ineligible to hold any office, particularly the presidency, and treated, and this is his words, Section 3 as executing itself, needing no legislation on the part of Congress to give it effect. So you're relying on a non-presidential case by a justice who later takes back what he said.
But the key point with Griffin's case and why it's an important precedent, despite everything Your Honor said, it is not a precedent of this court. But Griffin's case provided the backdrop against which Congress legislated the Enforcement Act of 1870 when it first provided an enforcement mechanism for
Yeah, and
Section 3.
it did away with it later.
It did away with it later, but
But that has nothing to say with respect to what Section 3 means. Can we get to the issue, which is, I think, one that I go back to that I started with? And very briefly, what sense does it say that states can't enforce Section 3 against their own officials? I mean, I think logically, those are 2 separate issues in my mind. Can states enforce the insurrection clause against their own office holders? Or can they enforce it against federal officials? Or can they enforce it against the president? Those are all 3 different questions in my mind.
And the answer to all 3 of those questions turns on whether this court agrees with the holding of Griffin's case. If Griffin's case
You're going to just
is the
reject
proper
Griffin,
enunciation of the law,
pretend that's not
then the
anything.
state cannot do
not
any of the things
influential.
Your Honor suggested unless Congress gives it authority to do so.
So a
through implementing
non-presidential
legislation.
decision that relies on policy
Yeah, this is the
doesn't
case of first
look at the
impressions,
language,
Sotomayor.
doesn't look at the history, doesn't analyze anything than the disruption that such a suit would bring, you want us to credit as precedential.
Because Congress relied on Griffin's case when it enacted the Enforcement Act of 1870 and established.
So, Mr. Mitchell, if I may interrupt, but just to clarify, I mean,
is
this
Kagan.
sounds like your reply brief, where it sounds like you're not making a constitutional argument. You're really making a statutory preemption argument. And is that what you're doing here? You're not saying that the Constitution gives you this rule. It's the kind of combination of Griffin's case plus the way Congress acted after Griffin's case
Yes.
that gives you the rule?
That's exactly right, Justice Kagan, because we have implementing legislation. Congress took up the invitation provided by Griffin's case and established writs of quo warranto in the 1870 Enforcement Act, later repealed them. The only enforcement legislation that's currently on the books is the insurrection criminal statute, Section
2383. Yep.
And when Congress made all of these decisions, the initial enactment of the Enforcement Act in 1870, the repeal of the quo warranto provisions in 1948, all of those were made with Griffin's case as the backdrop.
Please.
Well, the understanding was that these congressionally established remedies would be exclusive of state court remedies. So there's not an express statement of preemption in these statutes, but there didn't need to be because Griffin's case provided the backdrop.
And if I could just understand the argument a little bit better, suppose that we took all of that away. You know, suppose there were no Griffin's case and there were no subsequent congressional enactment. What do you then think the rule would be?
So just as a matter of first principles without Griffin's case, it's a much harder argument for us to make because normally, I mean, every other provision of the 14th Amendment has been treated as self-executing. What we would argue in that hypothetical that Your Honor has suggested is that there are practical considerations unique to Section 3 that counsel in favor of a rule similar to what Chief Justice Chase spelled out in Griffin's case. And it goes to, I think, the policy concerns he talks about, where this was a case, Griffin's case involved a convicted criminal who was seeking a writ of habeas corpus on the ground that the judge who tried his case was an insurrectionist disqualified under Section 3. And Chief Justice Chase realizes that if he enforces Section 3 in this situation, it would nullify every official act taken not only by this particular judge, but by anyone who is an insurrectionist or arguably an insurrectionist under Section 3.
Well,
And that was
why do you need those consequential
This is
concerns,
Barrett.
though? I mean, it kind of seems to me that what Justice Kagan is getting at is why don't you have an argument that the Constitution of its own force, that Section 3 of its own force preempts the state's ability, not necessarily, I think not, to enforce Section 3 against its own officers, but against federal officers, like in a Tarbell's case kind of way.
So there could also be an argument that's more limited. You're suggesting there may be a barrier under the Constitution to a state legislating an enforcement mechanism for Section 3 specific to federal officers.
That's where I
You
would've
could rely
gone.
on precedents such as McClung that says that state courts lack the authority to issue mandamus relief against federal officials.
Well,
and
why
extend that
aren't you
principles
making those
here.
arguments?
Yeah.
Because that doesn't get us, that Griffin's
That
case
only
goes-
gets you out of state court, doesn't get you out of federal.
Right. And also the holding of Griffin's case went well beyond that because Chief Justice Chase said in this opinion, which again provided the backdrop for the congressional enforcement legislation, that states had no role in enforcing Section 3 unless Congress was to give them that authority through a statute that they passed pursuant to their
But your
powers.
arguments,
No, please, go ahead.
I was just going to add one last thing. I think your argument's a little broader than that because I think if we accept your position that disqualifying someone from the ballot is adding a qualification, really your position is that Congress can't enact a statute that would allow Colorado to do what it's done either, because then Congress would be adding a qualification, which it can't do either.
No, I don't agree with that, Justice Barrett. Congress is not bound by the holding of term limits. Term
Matt
limits only
Damus.
prohibits the states from adding additional qualifications or altering the Constitution's qualifications for federal office. It does not purport to restrain Congress. So if Congress were to enact implementing legislation that authorized the states to exclude insurrectionists from the ballot, we believe that would be valid enforcement legislation under Section 3, with an important caveat. There has to be congruence and proportionality under this court's precedent. So
Why
Congress-
would that be why would that be permissible? Because Section 3 refers to the
Alito.
holding of office, not running for office. And so if a state or Congress were to go further and say that you can't run for the office, you can't compete in a primary, wouldn't that be adding an additional qualification?
Alito is
Serving
saying,
for president,
just
you must have been
jump there.
free from this disqualification at an
Tell me
earlier
where to
point
go.
in time than Section 3 specifies.
I think the answer to your question, Justice Alito, depends on how you interpret the word enforce in Section 5. And some members of this court, such as Justice Scalia, thought that enforce means you can do nothing more than enact legislation that mirrors the 14th Amendment's self-executing requirements, and you can't go an inch beyond that. That's not the current jurisprudence of this
No,
court.
well,
Court
all right, you have
allows-
to decide whether it's congruent and proportional, and we would get into the question of whether that would be congruent and proportional. Well, let me shift gear a little bit. I take you to argue, and I think this is right, that the term self-executing is a misnomer as applied here.
Yes, it
Very
is.
often, when we use the term, what we're referring to is the proposition that a particular provision of the Constitution or a statute in and of itself creates a private right of action. That's not what the issue is here.
No, that's not the issue here. And sometimes the phrase self-executing is used that way. The only thing I would add is sometimes it's used in a different sense. With self-executing treaties or non-self-executing treaties, the issue is whether that treaty has any force as domestic law whatsoever.
Right. But I don't see what is gained by using this term, which is used in different contexts, rather than directly addressing what's involved here, which is the question of who can enforce Section 3 with respect to a presidential candidate. The consequences of what the Colorado Supreme Court did, some people claim, would be quite severe. Would it not permit,
There's a softball question
would it
coming.
not lead to the possibility that other states would
Yes.
say, using their choice of law rules and their rules on collateral estoppel, that there's non-mutual collateral estoppel against former President Trump? And so the decision of the Colorado Supreme Court could effectively decide this question for many other states, perhaps all other states. Could it not lead to that consequence?
I don't think so, because Colorado law does not recognize non-mutual collateral estoppel. And I believe the preclusive effect of the decision would be determined by Colorado law rather than the law of another state. But I think your question, Justice Alito, gives rise to an even greater concern, because if this decision does not have preclusive effect in other lawsuits, it opens the possibility that a different factual record could be developed in some of the litigation that occurs in other states, and different factual findings could be entered by state trial court judges. They might conclude that, as a matter of fact, that President Trump did not have any intent to engage in incitement, or make some other finding that differs from what this trial court judge found.
Yeah, exactly. So in this decision, the trial court in Colorado thought that it was proper to admit the January 6th report. And it also admitted the testimony of an expert who testified about the meaning of certain
Experts.
words and phrases to
Not
people who communicate with and among extremists, right? Another state court could reach an opposite conclusion on both of those questions.
Certainly. Other states could conclude that the January 6th report is admissible hearsay.
There'd be
They might also
chaos,
conclude that
basically.
statements within the January 6th report were hearsay, even if the report itself is not. And they could certainly reach a different conclusion with respect to the expert testimony of Professor Simi. Perhaps in another state, we would have time to produce our own sociology expert who would contradict Professor
Yeah,
Simi.
Should
Come back to this.
these considerations be dismissed as simply consequentialist arguments, or do they support a structural argument that supports the position that
Structural.
you're taking here?
I think they all mutually reinforce each other. We have an argument, we believe, that is sufficient to dispose of this case just based on the meaning of officer of the United States, as well as the
He
argument.
fed
we're
you
making based on
structural. Go
criminal
with
rights. But
structural.
All of the consequentialist considerations that Your Honor has suggested are additional
like the way he's
reasons
answering
to
these
reverse the
questions.
Colorado Supreme Court, although we don't think it's necessary to get into consequences because the law is clearly on our
Can
side.
you keep saying term limits. There are other
Sotomayor.
presidential qualifications in the Constitution: age,
Yes.
citizenship. There's a separate amendment, the 22nd Amendment, that doesn't permit anyone to run for a second term. We have a history of states disqualifying, not all, but some, of disqualifying candidates who won't be of age if elected. We have a history of at least one state disqualifying someone who wasn't a U.S. citizen.
Right.
Are your arguments limited to Section 3?
Not quite. The question, Justice Sotomayor, is whether the state is violating term limits by adding to or altering the extant qualifications for the presidency in the Constitution. Now,
So you want us to say, I'm wondering why the term limits qualification is important to you.
because
Are you setting up so that if some president runs for a third term, that a state can't disqualify him from the ballot?
of course a state can disqualify him from the ballot, because that is a qualification that is categorical. It's not defeasible by Congress. So a state is enforcing the Constitution when it says you can't appear on our ballot if you've already served 2 terms as president. The
The same if they're underage when elected, and the same if they're not a U.S. citizen.
The same if they're not, well, the same if they're not a U.S. citizen for sure. The age is a little more nuanced, because you can imagine a scenario where the person is 34 years old at the time of the election, but he turns 35 before inauguration.
Well,
The
then that
state
would
cannot-
come up, that would probably come up to us at some point. The state would make a decision and say he's ineligible, and we would have to decide that question then. But my point is, so what, adding qualifications to what term limit is your argument based on?
You're
I'm
changing.
just confused.
Okay, with respect to the, maybe
question's
I'll start with the
confusing.
age example.
Mhm.
If a state like Colorado says you can't appear on our presidential ballot unless you are 35 years old on the day of the election, that would be a violation of term limits, because there could be a 34-year-old on the day of the election who turns 35 before inauguration day. What Colorado has done here, what their Supreme Court has done, is similar, because under Section 3, President Trump needs to qualify during the time that he would hold office. And the Colorado Supreme Court is saying to President Trump, you have to show that you would qualify under Section 3 now, at the time of the election, or at the time that we, the state Supreme
Now
Court.
I understand.
So what?
Now, I just a point of clarification, so we're all on the same page. When you say term limits, you mean our decision in the term limits case?
Yes,
not
I'm
the
sorry.
constitutional provision governing term limits.
Yes, U.S. term limits against Thornton. Maybe I should call it Thornton instead of term
That
limits.
would
I'm
be
sorry.
easier
Does it
for
have
you.
some-
I was
So
confused.
does it have something to do with the fact that the particular circumstance that you're talking about can
Brown
change?
Jackson.
Is that what you mean? I'm trying to understand
Yeah.
the distinction between the provision in the Constitution that relates to disqualification on the basis of insurrection behavior
Mhm.
and these other provisions that Justice Sotomayor points out. They all seem to me to be extant constitutional requirements. So, but you're drawing a distinction.
Right, I'm drawing a distinction because some of them are categorical.
What do you mean
Such
by
as-
categorical? Whether or not you are an insurrectionist is or is not categorical?
It is not categorical
No.
because Congress can lift the disability by a 2/3 vote. And there's,
But why does that change the initial determination of whether or not you fall into the category? I don't understand the fact that you can be excused from having been in the category.
Because at
Why
election
does that
day,
not
you don't
make
know
it a
what's going to happen
categorical,
before
determination?
holding
because we
office.
don't know whether President Trump will be excused before he's sworn in, if he wins the election
so
on
bad.
January 20th,
You suck, Biden, for
2025.
putting that woman in
And
here.
a court that is saying that President Trump has to show now, today, that he would qualify under Section 3 is accelerating the deadline that the Constitution provides for him to obtain a waiver from Congress.
But that's by virtue of the hold, right? Hold office. This is
Correct.
uh,
Yeah, Section 3
Yeah,
bans him
that's
only
the
from
language of the
holding
that's the
office.
language of the
Can I ask
amendments.
you- I'm just, now that I have the floor.
Yes.
Can I ask you to address your first argument, which is the officer point? Oh, sorry.
Yeah, why don't we?
Can we,
Oh,
They're all like, "What the hell are you doing, Brown
If we do this
Jackson?"
and then we go to
sure,
that?
sure.
You know, but will there be an opportunity to do officer stuff, or should we?
Absolutely, absolutely.
I just want to understand, so on this theory, what is
Like
the
newbie.
sum total of ways that that Section 3 can be enforced? That somebody out there can say, yes, there's been a former president who engaged or led or participated in an insurrection, and so should be disqualified from office, putting aside the officer argument.
Right.
What is the sum total of ways that enforcement can happen?
So the answer to that question is going to depend on what Your Honor thinks of Griffin's case. So if this court were to affirm the rationale of Griffin's case, then the only way Section 3 could be enforced is through congressional legislation that creates a remedy. So Congress could reinstate the quo warranto provisions that they initially had in the 1870s.
Is that your position?
Yes, because we believe Griffin's case is correctly decided and should followed.
And how does that fit with a lot of the answers to the questions that we've been given? You said, well, Congress has to have the ability by a 2/3 vote to lift the disqualification.
Right.
But so too, I would think that provision would be in some tension with what you just said.
There is some,
Because if Congress has the ability to lift the vote by a 2/3 majority, then surely it can't be right that one house of Congress can do the exact same thing by a simple majority.
Yeah, there certainly is some tension, Justice Kagan, and some commentators have pointed this out. Professor Bode and Professor Paulson criticized Griffin's
Then I
case
must
very
be
sharply.
right.
Well, we don't think this problem is fatal, because to us, the 2/3 provision that allows Congress to lift a disability is something akin to a pardon power, where Congress, through enforcement legislation, creates a mechanism by which the insurrectionist issue is to be determined by some entity. It could be the legislature. In the case of an elected member of Congress, each house has the ability to judge the qualifications of their members. Or if it's outside the situation of Congress, it would be whatever Congress enacts. So when it was the writs of quo warranto, each federal prosecutor had the authority to bring a quo warranto writ against an incumbent official and seek his ouster from office under Section 3, but it was still subject to that amnesty provision in Section 3 of the 14th Amendment. So we do acknowledge the tension, but we don't think that's an insurmountable obstacle.
I don't even see why
Griffin's
there's
case.
a tension. If you analogize the lifting by Congress of the disqualification by a
Of course it-
2/3 vote to a pardon, then surely one would not argue that the fact that the president or governor can
Gorsuch or
pardon
Kavanaugh.
someone from a criminal
Kavanaugh.
conviction or
It's
a
Kavanaugh.
criminal offense means that the person couldn't be prosecuted in the first place for the criminal offense,
That's right.
right?
Yes.
So I don't see what the tension is. They're two separate things. Did the
Yes.
person engage in this activity, which is prohibited? And second, even if the person did engage in the activity, are there reasons why the disqualification or should be lifted or the pardon should be granted?
That's right. I mean, if the court accepts the holding of Griffin's case, that's exactly the regime that we would have.
Yeah, I don't see there's
Right.
tension,
Because I
but
don't-
also there's a limit on what one can infer from the mere fact that Congress can lift the disqualification. You can't infer from that it is impermissible to have a prior determination that the person did engage in the insurrection. You can't
Yeah,
make
if
that
you-
inference.
okay.
It's not
Well,
logical.
but
Yet,
I think
isn't that
what's,
what you're
what's,
doing?
what's intention is that you would have the exact same actor and say, look, that actor can lift
Right.
the disqualification by a 2/3 vote. But you're saying only that actor can put the disqualification into effect in the first place. And it can do that by far less than 2/3. It can do that just by a simple majority of one house.
Or it could do that by doing nothing at all, if the holding of Griffin's case is correct, because just
Yes,
congressional
exactly.
inaction would
But that
effectively
means that
act
there
as
will be, the only thing it
Yeah.
takes to have no action
Right.
is, half plus one saying we don't feel like it.
But that's why we tried to characterize our Griffin's case argument the way we did, where we rely on preemption doctrines as well. So we
Well,
have.
don't
Why
you
don't
think
we-
Griffin's case is also relevant to trying to figure out what the original
That's
public
Kavanaugh.
meaning of Section 3 of the 14th Amendment is? It's by the Chief Justice of the United States a year after the 14th Amendment. That seems to
Yes.
me highly probative of what the meaning or understanding
Oh, that's a good
of that
sign.
language.
That's a good
otherwise
sign right
use of
there.
Language is.
I do think it's probative. Justice
Kavanaugh.
We didn't rely too heavily on the point that you're making, partly because we have this other opinion from Justice Chase in the Jefferson Davis case. So that argument could potentially boomerang on us. Which
That's
is why we didn't
Kavanaugh
push it very
saying,
hard
I'm a vote in your
in our
favor.
briefing. But I think
Thank
Your
you.
Honor is right. This is
Why don't you finish your sentence?
just,
and then
it is,
we'll
it
move
is
on.
relevant and probative for sure. But I think there is other evidence too that might perhaps undercut the usefulness of trying to characterize Griffin's case as completely emblematic of the original understanding.
Now, why don't we move on to the officer point?
Certainly.
And Justice Jackson, I think you.
Yeah, so I had a question about it because you're making a textualist argument.
Mhm.
And as I look at Section 3, I see two parts of the first sentence of Section 3. The first is a list of offices that a disqualified person is barred from holding.
By the way,
And the
this is all
second
one sentence,
are
not three
specific
sentences.
circumstances that give rise to disqualification. So first, am I right about seeing that there are two different things happening in the first sentence of
Yes.
section? Okay.
For sure.
So are you arguing both in this case or just one? Are you arguing both that the office of the presidency should not be considered one of the barred offices and that a person who previously took the presidential oath is not subject to disqualification?
We are arguing both, Your Honor.
I don't see that in your brief. I
Well-
see a lot of focus on the second, but not on the first.
There is definitely more focus on the second, and we acknowledge that we have a somewhat heavier lift on the first point.
Why? It seems to me that you have a list and president is not on it.
That's certainly an argument in our favor, but they're also, with respect to officer of the United States, that's used repeatedly in the Constitution, in the Commissions Clause, in the Appointments Clause, and also in the Impeachment Clause. And every time it appears, it's used in a way that clearly excludes.
No, I understand, but that's
So
the
we don't-
second argument. So the
That is.
first
And the-
argument
Mhm.
is we have a list of offices
Yes,
that a person is barred from holding, right?
Yes.
Under your theory or under the language
Mhm.
of, and we see it begins with senator, representative, elector of
Elector.
president and vice president, and all other civil or military officers.
well, offices under the United States.
Offices under the United States.
How
But
it's
the
phrased.
word president or vice president does not appear specifically
That's
in
right.
that list. So I guess I'm trying to understand, are you giving up that argument? And
No.
if so, why?
No, we're not giving it up at all. You're right, the president and the vice president are not specifically listed. But the Anderson litigants claim that they are encompassed within the meaning of the phrase office under the United States.
And do you
that-
agree that the framers would have put such a high and significant and important office, sort of smuggled it in through that catch-all phrase?
We don't agree at all. That's why we're still making the argument that the presidency is excluded.
KBJ
from
may
the
come
covered
along.
Offices that are listed at the beginning of section
I'm
3.
sorry, your brief says you didn't take a position.
You were just
on-
asking
on that
him.
point.
She was just asked by
I'm sorry.
And
KBJ.
your brief said.
Sotomayor. You're so
I don't have
terrible,
the site.
Sotomayor.
I apologize. You don't affirmatively argue that point, I think is what your brief said.
In the blue brief?
Yes.
Well, we certainly argued it in the reply brief, and I'll have to look at how we phrased it. But we did point out in our opening brief that there are potential issues if this court were to rule on office under, because that phrase appears in other parts of the Constitution, including the Emoluments Clause, the Impeachment Disqualification Clause.
Would we
and the
necessarily
Compatibility
have to
Clause.
say, I mean, I thought the point was that Section 3 was unique, that there was something happening with Section 3 that could explain why certain offices were left off
There
or
is.
whatnot.
Perhaps, but there are also implications from other parts of the Constitution,
Oh my
which
gosh,
really
he keeps
help us
coming
on
back
the
to text,
officer of the United
as
States
opposed to-
argument in
as-
that second part of Section 3.
as opposed to
That's somewhat
originalism.
cut against us when it comes to office under the United States. And the Anderson litigants point this out in footnote 9 in the red brief, where they say, if this court were to say the presidency is an excluded office under the United States, that could imply, for example, the president is not covered by the emoluments.
Mr. Mitchell,
Yes.
you're stepping back on this.
Mhm.
A lot hinges on the difference between, in your argument,
This is
between
Gorsuch.
the term office and officer.
Yes.
And I guess I'm wondering, what theory do you have from an original understanding or a textualist perspective,
Mhm.
why those two terms so closely related would carry such different weight?
Because it's clear from the constitutional text that there are officers that do not hold offices under the United States. For example, the Speaker of the House and the President pro tempore, they're described as
He's so
officers
fixated
in
on
Article
text rather
1
than
who are
originalism.
chosen by the
Stupid.
legislature. They also have to be officers if they're able to be covered by the Presidential
explain that
Succession
later.
Act, because under the Constitution, only officers can serve when there's a vacancy in both the presidency and the vice presidency. So they're officers, but they're not offices under the United States because of the Incompatibility Clause, which says that if you're a member of Congress, you cannot simultaneously hold an office under the United States. So that provision of the Constitution clearly demonstrates that members of Congress can't hold offices.
I appreciate that
Yes.
response. Is there anything in the original drafting, history, discussion?
Hit the
that you think
originalism!
illuminates Why
Jesus!
that distinction would carry such profound weight?
Not of which we're aware.
What are
these
you
just
talking about,
emphases
you
that were drawn
idiots?
From
Oh,
constitutional structure,
God.
intratextualist analysis.
Yeah.
But we aren't relying necessarily
Yes,
on the
there
thought
is.
processes of the people who drafted these provisions because
Stupid.
they're unknowable. But even if
Stupid.
they were knowable, we're not sure they would be relevant in any manner because this language, especially in Section 3, was enacted as a compromise. There were certainly radical Republicans who wanted to go much further.
It
If you
was
look
to
at some of
strip
earlier
the states
drafts
of
that were
these
proposed,
powers
Some people wanted to ban all insurrectionists
and make this a
from
federal
holding office,
decision.
regardless of whether they previously swore an oath. Some people wanted to go further and ban them even from voting.
It was to say the
Thank
federal
you.
government
Thank
has
you,
the
counsel.
power.
I just have
That's
one
the originalist
very
argument.
technical
Why?
question.
I
The
can't
statute
see
in
it.
1870, if it were still in effect, would require you to modify your arguments slightly. It was repealed, as you say, in 1948. I tried to find it, but I couldn't. Do you know why it was repealed?
No, we don't know why. It looks like it was done as part of a reorganization of the U.S. Code. So it doesn't appear there was any policy motivation behind that decision. I think a lot of things got repealed during this 1948 decisions that were made.
Okay. Justice Thomas, anything further? Justice Alito?
Is there any history of states using Section 3 as a way to bar federal office holders?
Not that I'm aware of, Justice Alito, because of Griffin's case. I mean, Griffin's case has been the law. I shouldn't say that's been the law because it was just a circuit court decision, but that has been the settled understanding of Section 3 since 1870 when it was decided.
Thank you.
Justice Sotomayor?
Pin down your principal argument on Section 3. You argue that even though the president may or may not qualify, presidency may or may not qualify as an office under the United States, your principal argument is that the president is not an officer of the United States, correct?
Yeah, I
Such
would
a
say it a
stupid
little
argument.
more forcefully than what Your Honor just described. We believe the
Such a
presidency
stupid
is
argument.
excluded from office under the United States. But the
This is
argument we
terrible.
have that he's excluded the president as an officer of the United States is the stronger of the two textually and has fewer implications for other constitutions.
Bit of a gerrymandered rule, isn't it?
It is.
Designed to
It
benefit
is.
only your client?
I certainly wouldn't call it gerrymander. That implies nefarious
Well,
intent. We're
you
just-
didn't make it up. I know some scholars have been discussing it, but just so we're clear, under that reading, only the petitioner is disqualified because virtually every other president except Washington has taken an oath to support the Constitution, correct?
That's right. Every president, to our knowledge, every other president. John Adams might also be excluded because he took the oath as a vice president, which is not an officer. But yes, President Biden would certainly be covered. He took the oath as a member of Congress, and that's true of every previous president.
Would that be true if we were to hold more narrowly in a reversal, that it's not Section 3 that's at issue, but Thornton and others as to whether Section 3 can be enforced by states against the president?
That would extend to every presidential candidate, not
Exactly,
just our
not
client.
just
That's
to
correct.
yours.
Yes.
Okay, thank you.
Justice Kagan?
And if I could just understand, I mean, given that you say you don't have a lot of evidence that the founding or the generation that we're looking at is really thinking about office versus officer of the United States, I mean, it would suggest that we should ask, is that a rule a sensible one? You know, if they had thought about it, what reason would they have given for that rule? And it does seem as though there's no particular reason, and you can think of lots of reasons for the contrary.
Right.
I can
to
think
say
of
that
lots
the
of
only
reasons.
people who have engaged in insurrection who are not disqualified.
There are a
from
lot of
office
reasons.
Are presidents who have not held high office before. Why would that rule exist?
God.
I don't think there is a good rationale.
Yes,
given
there
that this was
is.
compromise legislation. And sometimes this happens with statutory compromises and even constitutional compromises. There's an agreed upon set of words.
He's
that can
elected,
pass
chosen
both
by the
houses of
entire
Congress.
country as opposed to
But
by
different
one state.
legislators may
That's
have had
why.
goals and motivations. They didn't all get their way. In a compromise, everyone goes away miserable. But this was the text that was settled upon. And
This guy's
it does seem
terrible.
odd that President Trump
Terrible.
would fall
Terrible.
through the cracks in a sense.
Terrible.
But if officer of the United States means appointed officials, there's just no way he can be covered under
This guy's
Section 3.
so
The court
bad
will
at
have to
this.
reject our
This is
officer
the
argument to
this
get
is-
to that point.
what the
And
hell's
is
wrong
there
with
any
this
better
guy?
reason if you go to the office argument that Justice Jackson was suggesting? Is there any better reason for saying that an insurrectionist cannot hold the whole panoply of offices in the United States, but we're perfectly fine with that insurrectionist being president?
I think that's an even tougher argument for us to make as a policy matter.
What
because
is
when we
wrong
think
with you? It's not tougher at
of all
all.
offices, the presidency would be the one you'd want to keep out the Confederate
It's a pardon from the entire
insurrectionists,
country
and the chief of
if
the army.
you get elected
So,
president.
Again,
As opposed
that's
to
why
a
we're
pardon
leaning
from the state
more
of
on
South
the officer
Carolina that
of
we don't want that
argument
you engage
than
in
the office under. We're not
insurrection.
conceding office under.
Idiots.
But we definitely have the stronger textual case and structural case on
Wrong,
officer of the
wrong,
United States.
wrong, wrong.
you.
It's not stronger.
Justice
It's weaker.
Gorsuch?
They just showed you how it's weaker.
Respond
Idiot.
to some of the specific textual arguments on the officer of with respect to the appointments clause, the impeachment clause, and some of the others.
Yeah, so the way, let's start with, well, I'll start with the
The
commission's
ball has
clause.
been bouncing
Yeah.
on that back and forth, and I wanted to see where you landed today.
There's three different textual
Of course
inferences that
it's-
can be drawn from each of those provisions Your Honor just mentioned. But the commission's clause, I think, is the strongest because it says the president shall, commission all the officers of the United States. Shall is mandatory, all is all encompassing. And the president doesn't commission himself, and he can't commission himself. So that's one of the first problems. I think the Anderson litigants are trying to say, there's somehow an implied exception there because the president obviously can't commission himself, so we should construe that to mean all officers of the United States besides the president. But you also have members of Congress who are not commissioned by the president, and that's because they're not officers of the United States. So the only sensible distinction that we can see, given the language of the Commission's Clause, is that officers of the United States are appointed officials, and elected officials, such as members of Congress, and the president and the vice president are not.
A textualist
And the impeachment
argument,
clause reinforces
absent
that. The president,
logic
the vice
of
president,
originalism
and
that
all civil
you're ignoring
officers of the United States
is very
shall
weak.
be removed from office upon impeachment
Stupid.
for and conviction of
This is
all
so stupid.
high crimes and misdemeanors. The president and the vice president are listed separately from officers of the United States. And then, of
So
course, the Appointments
stupid.
Clause, we know the president is not appointed pursuant to Article 2, neither is the vice president, neither are members of Congress, so they can't be officers either.
And how does Article 1, Section 6 fit into this discussion?
And this is about officers being
Come back to this.
in the line of succession.
Yes, exactly.
Right, so you have to be an officer to be in the line of succession. We have a federal statute that puts the speaker and the president pro tempore in the line of succession. They are officers, but they're not officers of the United States because they're not subject to impeachment. They're not commissioned by the president, and they're not appointed pursuant to Article 2. So there is this gap between the term officer and the phrase officers of the United States, reinforcing the idea that officers of the United States is a term of art that doesn't refer just to federal office holders, which is what the Anderson litigants are claiming, but refers only to those who are appointed, not to those who are elected.
Thank you.
Justice Kavanaugh?
And just make sure I understand how you're using Griffin's case again. Section 3 refers to insurrection and raises questions about who decides what processes are to be used. That's ratified in 1868. The next year, Chief Justice Chase opines that states do not have the authority, that only Congress has the authority to enforce that. That could be evidence, as you say, of the original public meaning, at least some evidence. It's a precedent, although not binding. But your point then is it's reinforced because Congress itself relies on that precedent in the Enforcement Act of 1870 and forms the backdrop against which Congress does legislate. And then, as Justice Alito says, the historical practice for 155 years has been that that's the way it's gone. There haven't been state attempts to enforce disqualification under Section 3 against federal officers in the years since. So whether that's a Federalist 37 liquidation argument, it all reinforces what happened back in 1868, 1869, and 1870.
Right.
You want to add to that, alter that?
No, I think that's exactly right. And the last part you mentioned, Your Honor, is crucial to our argument, that Congress relied on Griffin's case. It provided the backdrop against which they legislated, which is why we should read these extant enforcement mechanisms, and right now the only one left is the federal insurrection statute 2383 as exclusive of state court remedies. It's a form of implied preemption.
I'll explain
almost
this later.
clamors implicit preemption of other remedies because Congress made these decisions in explicit reliance on Griffin's case.
And if we agree with you on Griffin's case and what you've elaborated on there, that's the end of the case, right?
It should be, yes, unless Congress decides to enact a statute, which we can't rule out
A
the
new
possibility.
statute in addition to 2383. And just to be clear, under 2383, you agree that someone could be prosecuted for insurrection by federal prosecutors, and if convicted, could be or shall be disqualified then from office.
Yes, but the only caveat that I would add is that our client is arguing that he has presidential immunity. So we would not.
Just
concede
don't
that
bring
he
it to
can be
Trump.
prosecuted for
Don't bring it to
anything
Trump.
under
You don't need to
Section
bring it to Trump.
2383.
Understood. Asking a question about the theory of 2383.
Yeah, he's just
Thank
in
you.
the theory, not the application to
Justice
Trump.
Barrett?
So Griffin's case was a collateral proceeding, so it's habeas relief.
Yes.
Could Griffin have, so even if Section 3 is not a basis for collateral relief in habeas, which was new at the time, could Griffin have raised at his trial or in direct appeal the argument that Judge Sheffy, you can't legitimately sit or constitutionally sit on my case because you're an insurrectionist and you're disqualified? Could he have won then?
No.
Why?
Not if Griffin's case is correct. So a court would have to reject the rationale of Griffin's case to accept what Your Honor was suggesting.
Well, why? Like I said, Griffin's case, I think there's some language that might be a little bit broad, but at bottom, Griffin's case is about a collateral habeas proceeding. And Griffin had brought his case after the fact. He needed a cause of action. Why wouldn't it work in a trial for him to challenge Sheffy's constitutional ability to adjudicate his case?
But what Griffin's case holds is that only Congress can provide the means of enforcing Section 3. And under Your Honor's hypothetical, Congress has not enacted any such statute that would give Mr. Griffin the right to
would have
raise
done
those
better.
types of arguments at his trial. So he would have to await legislation from Congress.
Okay, let's assume that I disagree with you about the officer argument. So Section 3 covers President Trump. Let's say that Congress enacts a quo warranto provision that would allow a state, or I guess it doesn't really matter for this purpose, even a federal prosecutor, to bring such an action against him, to remove him from office in the quo warranto way. Wouldn't that be in some tension with impeachment? He would be extracted from office outside of the process of impeachment. Couldn't then
That's not the only way to
President
remove
Trump
him.
simply
from
say,
this
well, the only way to
impeachment.
get me out of office is the impeachment process and
While
not
he's sitting?
this quo warranto action?
So I don't know how that would play out, because the quo warranto actions that were brought, that I'm aware of, under the 1870 Enforcement Act, were brought against state officials. And Your Honor's impeachment hypothetical would apply not only to the president, but any federal
I know.
officer of the United States.
I know.
So I don't know how that played out in the courts and whether anyone ever tried to argue that impeachment was the exclusive remedy for.
Well, I don't think anybody did argue it. I guess what I'm asking is, you said it's Congress's exclusive province. And you
Yes.
also said that it has to apply, after one is holding office, is elected. And I'm asking whether then the implication of your argument is that Congress could not enact such a provision that applied against federal office holders that were covered by Section 3 as opposed to state ones.
I believe they could. And the impeachment clause says that the president, the vice president,
This is
and all
very
civil
theoretical.
officers of the United States shall be removed from office upon impeachment and conviction. But it doesn't say that's the only way you can remove them. I mean, Congress can defund a position, and effectively, it's not quite the same as
No, they
formal
can't.
removal. But the other relevant precedent is Stewart against Laird, when the Jeffersonians repealed the Midnight Judges Act and abolished all of these positions for federal judges. And some people thought that was unconstitutional because they thought the only way you could eliminate federal judges was through impeachment.
Me too.
But Chief Justice Marshall upheld that
Me
statute.
too.
So that, to me, is a relevant precedent showing that impeachment is not the only way to get rid of a federal official.
Okay, let me just ask one question, and this is just a point of clarification. Does President Trump have any kind of due process right here? I mean, I'm wondering, this kind of goes not to the cause of action point or the preemption point, but
The
more to the
insurrection.
question of what procedures he might have been entitled
to
to. You don't
determine
make the
that he's in
argument that he was
insurrection.
entitled to any, nor did I see the argument that he had any kind of constitutionally protected right to ballot access, so that he was, and constitutionally entitled to an opportunity to be heard. Is that right? He had no due process right?
We made that argument below. We did not make that in our briefs to this court for several reasons. I mean, Your Honor's, I think, suggesting, and this is correct, that the proceedings below, to put it charitably, were highly irregular.
Well, I wasn't suggesting that. I was
I'm
just
sorry.
asking.
The question
yeah.
seems to suggest that there might be due process issues, but we didn't develop that argument in this court for several reasons. Winning on due process doesn't really do as much for our client as the other arguments that we've made, because that would be a ruling specific to this particular proceeding in the state of Colorado and would leave the door open for Colorado to continue on remand
Right.
to
Maine
exclude
or
from the
anywhere
ballot.
else. Right.
Okay, thank you.
Justice Jackson?
That's a good answer. That's a good
To
point.
whether the presidency is one of the barred offices. I guess I'm a little surprised at your response
Abandoning.
to Justice Kagan, because I thought that the history of the 14th Amendment actually provides the reason.
She understands it better than you do. Ketanji Brown Jackson
And by
understands
that
it better
I
than you
mean,
do.
I didn't see any evidence that the presidency was top of mind for the framers when they were drafting
They're not
Section
framers, they're
3, because they were
drafters.
actually dealing with a different issue. The pressing concern, at least as I see the historical record, was actually what was going on at lower levels of the government. The possible infiltration and embedding of insurrectionists
KBJ would
into
do
the
this better
state
than this lawyer
government
did.
apparatus, and the real risk that former Confederates might return to power in the South via state-level elections, either in
Yes.
local offices or as
Yes.
representatives
Yes.
of the states in Congress.
Embrace.
And that's
Say
a very
yes, you're
different
right, I
lens.
was
Your
wrong.
concern is trying to make sure that these people don't come back through the state apparatus and control the government in that direction.
Pathetic that
seems to me
KBJ
very
is making a
different
better argument
than
for
the
Trump
worry
than his
that an
lawyers are.
insurrectionist will seize control of the entire national government through the presidency. And so I just am surprised that you would, given the text of the provision and the historical context that seems to demonstrate that their concern or their focus was not about the presidency, I just don't understand why you're giving that argument up.
No one
There is
does.
some evidence to suggest that.
Not some.
Is there any evidence to
tons of
suggest that the
evidence.
presidency
It's much
was
stronger.
what they were focused on?
There is some evidence of that. There were people saying we don't want Jefferson Davis to be elected president. And there was also one of the drafts of Section 3 specifically
They would
mentioned the
bend.
presidency and the vice presidency.
But it wasn't
as an office.
but it wasn't the final.
It wasn't the final,
enactment, so
it
where do we-
wasn't, yes,
Right.
I'm sorry, it wasn't the final enactment, but it does show that there was some concern by some people about Confederate insurrectionists ascending to the presidency. And we didn't want to make a law office history type argument where we just look at the historical evidence and pick the evidence that we like and interpret it tendentiously, because the other side can come back with us and throw this countervailing evidence back in our face. So we wanted to focus more on the text of the Constitution because this was ultimately a compromise provision that was enacted in Section 3.
All right, let
And-
me ask you another question about the states, because you have forcefully made an argument about the states not being able to enforce Section 3. So if we agree with you on that, what happens next? I mean, I thought you also wanted us to end the litigation. So is there a possibility that this case continues in federal court if that's our conclusion?
I don't see how it could unless Congress were to enact a statute in response to this court's
So
decision.
your point is that we would have to say congressional enacting legislation is necessary for either state or federal enforcement.
That's correct.
All right, final question. The Colorado Supreme Court concluded that the violent attempts of the petitioner supporters in this case to halt the count on January 6th qualified as an insurrection as defined by Section 3. And I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized.
I'm going to talk
All
about
right,
this
so why would
after
this not be an
arguments are
what is
over.
your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
That's one of many reasons, but for an insurrection, there needs to be an organized, concerted effort
Now we're getting to
to
the
overthrow
insurrection
the government of
arguments.
the United States through violence. And this
And so your
riot
point is that a
occurred-
chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson, right? None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection as that term is used in Section 3.
Thank you.
Because, thanks.
Thank you, Counselor.
I think KBJ is going to be voting with Trump from what we see so far. I think she's going to be the seventh one.
Mr. Murray?
Mr. Chief Justice, and may it please the court. We are here because for the first time since the War of 1812,
Oh, God.
our nation's capital came under violent assault. For the first time in history, the attack was incited by
Down
a
below, I
sitting
say who's-
president of the United States
shut up.
to disrupt the
God,
peaceful transfer of presidential power. By engaging in insurrection against the Constitution, President Trump disqualified himself from public office. As we heard earlier, President Trump's main argument is that this court should create a special exemption to Section 3 that would apply to him and to him alone. He says Section 3 disqualifies all oath-breaking insurrectionists, except a former president who never before held other state or federal office. There is no possible rationale for such an exemption, and the court should reject the claim that the framers made an extraordinary mistake. Section 3 uses deliberately broad language to cover all positions of federal power requiring an oath to the Constitution. My friend relies on a claimed difference between an office under and an officer of the United States, but this case does not come down to mere prepositions. The two phrases are two sides of the same coin, referring to any federal office or to anyone who holds one. President Trump's other arguments for reversal
too
ignore
early
the
to know.
constitutional role of the states in running presidential elections. Under Article 2 and the 10th Amendment, states have the power to ensure that their citizens' electoral votes are not wasted on a candidate who is constitutionally barred from holding office. States are allowed to safeguard their ballots by excluding those who are underage, foreign-born, running for a third presidential term, or as here, those who have engaged in insurrection against the Constitution in violation of their oath. I welcome the court's questions.
Now the questions
Do you
calls for
have
this. Dwayne.
contemporaneous examples? And by contemporaneous, I mean shortly after the adoption of the 14th Amendment,
Thank you.
where the states disqualified national candidates, not its own candidates, but national candidates.
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots. So the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified, unlike the processes that we have now that states have created under their Article 1 and Article 2 powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it seemed that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting.
So what's the
federal
purpose
officer.
of what was the purpose of Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states
I
considering
understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s. And by the 1890s, everyone had received amnesty and these issues had become moot. So I don't think the history tells us.
Sort of look at Justice Thomas's questions.
This is
from the
Roberts.
30,000 foot level. I mean, the whole point of the 14th Amendment was to restrict state power, right? States
Thank you. Originalism.
Religious immunity. They
Yes.
won't deprive people of property
Yes.
without due process.
Why does
They
Thank
won't
you.
deny
Yes.
equal protection. And on the other hand, it augmented federal power under Section 5.
Mhm.
Congress has the power to enforce
limited
it.
state power?
So wouldn't that be the last place that you'd look for authorization for the states, including Confederate states,
Bam.
to implicitly authorize, to enforce the presidential election process? That seems to be a position that is at war with the whole thrust of the 14th Amendment and very
Imagine South
ahistorical.
Carolina saying Ulysses
No, Your
Grant
Honor.
can't run
First,
for president
we
under the
would
14th
locate
Amendment.
the state's authority to run presidential elections not in the 14th Amendment, but in Article 2. And that power is nearly plenary to
Yeah,
determine.
but you're
the means.
relying on, you have no reliance on Section 3, is that what you're saying?
No, Your Honor, certainly we have reliance on Section 3 insofar as Article 2 gives states this broad power to determine how their electors are selected, and that broad power implies the narrower power to enforce federal constitutional qualifications.
Well, but the
like Section
narrower
3.
power you're looking for is the power of disqualification, right? That is a very specific power in the 14th Amendment. And you're saying that was implicitly extended to the states under a clause that doesn't address that at all.
We would say that nothing in the 14th Amendment takes away from the states their broad and nearly plenary power to determine the manner of selecting their electors in the manner that they see fit. As this court said in Chiafalo, that power is nearly plenary unless something in the Constitution tells states they can't do it. And the structure of the 14th Amendment certainly was intended to expand federal power and certainly to restrict state power in some ways. But states are bound to enforce and apply, for example, Section 1 of the 14th Amendment. And so it's hard to see why states wouldn't be similarly bound or at least authorized.
That's not greater includes the lesser argument. The states have the power, the legislature has the power to choose electors, granted. But just because there's one authorized means in the Constitution to a particular end does not mean that there's any means to that end. And so I think you're taking that electors
Kavanaugh's saying
argument
you
and
lose.
bringing it into
That's what
Section
he's saying
3,
here.
where, as the Chief Justice says, there's just no, and Justice Thomas, there's no historical evidence to support the theory of Section 3, nor the overall, to explain the overall structure of the 14th Amendment.
We certainly have a long history in this country of states using their power to determine the manner of selecting presidential electors to enforce other qualifications in the Constitution.
Deflect,
I don't think
deflect,
that there's a great
deflect,
debate
deflect.
about whether or not states are allowed to exclude underage or foreign-born candidates, or if President Bush or Obama wanted to run for a third term, that they could be excluded under that broad Article 2 power. I don't see why Section 3 should be treated any differently. So
There's a
Section
lot of
3
reasons
speaks
why it
in
should be
the
treated
same
differently.
Well, when you look
mandatory
at Section
terms.
3, the term insurrection jumps out. And the questions are, what does that mean? How do you define it? Who decides? Who decides whether someone engaged in it? What processes, as Justice Barrett alluded to, what processes are appropriate for figuring out whether someone did engage in that? And that's all what Chief Justice Chase focused on a year after the 14th Amendment to say, these are difficult questions, and you look right at Section 5 of the 14th Amendment, as the Chief Justice said, and that tells you Congress has the primary role here. I think what's different is the processes, the definition, who decides questions really jump out at you when you look at Section 3. Your response to that?
Well, certainly, Justice Kavanaugh, there has to be some process for determining those questions. And then the question becomes, does anything in the 14th Amendment say that only Congress can create that process? And Section 5 very clearly is not an exclusive
It seems
provision.
ridiculous
It
to
says
have 50
Congress
different
shall have
processes.
But maybe
And-
put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president
Sotomayor.
of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that
Why would it be
questions
this
of
court's?
national importance come up.
Well, I
through a
suppose
particular
this
state.
court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other
For
states,
everyone?
if this court affirms
If
the
there was
decision
40
below,
people,
determining that President Trump is
this court's supposed to
ineligible
serve for everyone?
to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well,
in
I
terms
mean,
of ballot
if
access.
we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding, and it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck, the first mover state here, Colorado, we're stuck with that record. And, I don't want to get into whether the
How
record,
crappy the record was.
Maybe the record is great, but what if the record wasn't? I mean, what if it wasn't
Like
a
this
fulsome
one.
record? What if, the hearsay rules are,
Stupidly
one-offs? Or
decided.
what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, that we made with
That was
Mr. Mitchell
Kagan.
too, that it just doesn't seem like a state call?
3 points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for clear error, but President Trump made the point in his reply brief that sometimes on constitutional questions that require a uniform resolution, this court can do something more like a Bose Corp style independent review of the factual record. And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts,
the only
essentially de
time we
novo,
know.
you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact finding? That's unusual.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief. He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case.
That's not the
And again,
point.
the essence of our case
pretty
is his
stupid.
own statements, and in particular,
Which is a
his
stupid-
own videotaped
that's very
statements
weak.
on the ellipse.
Mr. Murray, just to circle back to, I'm sorry to interrupt, but I wanted to, before we left,
That
I
wasn't.
wanted to circle
And that's
back
not
to where
true
Justice
even what
Kagan,
happened.
uh,
They relied on his
was.
tweets. They relied on a million things.
Do you agree that the state's powers here over its ballot for a federal officer election have to come from some constitutional authority?
This is Gorsuch.
Members of this court have disagreed about that.
I'm asking you.
The majority of this court has said that those powers come from Article 2, but we think that the result is the same whether the court locates it in Article 2 or in a reserved power under the 10th Amendment.
But you accept that this court has held. You're not contesting this or asking us to revisit that decision in Thornton or term limits or whatever you want to call it, that it has to come from some federal constitutional authority.
No, we are not, Your Honor.
Okay. And here we're not talking about the qualifications clause, right? Nobody's talking about whether he's 35 years old or a natural born, whatever, right? Not an issue, okay? We're talking about something under the 14th Amendment and Section 3. So that's where you have to find your authority, right?
We find our authority in Article 2, in states' plenary power to run their elections.
Federal election, but this is for a federal office. It has to come from the Constitution, and you're seeking to enforce Section 3.
We're suggesting that in their broad power to determine them, to select presidential electors in any manner they see fit, they can take account of Section 3 and apply Section 3.
Could they do it without Section 3? Could they disqualify somebody for, on whatever basis they wanted outside of the qualifications clause?
That would run into term limits,
Yeah, I would
Your
think
Honor.
so, right? So it has to come back to Section 3. And if that's true, how does that work, given that Section 3 speaks about holding office, not who may run for office? It was a point Mr. Mitchell was making earlier, and I just wanted to give you a chance to respond to it, because it seems to me that you're asking to enforce in an election context a provision of the Constitution that speaks to holding office. So it's different than the qualifications clause, which is all about who can run and then serve. Yeah.
I don't know that it is different.
Okay.
Other qualifications for office similarly talk about eligibility for the office. There's nothing unconstitutional about a 30-year-old trying to get on the ballot.
Except for this disability can be removed, right, under Section 3. That's what's different about it. So thoughts on that?
Well, the fact that there's an extraordinary provision for removing the disability does not negate the fact that the disability exists today, and it's existed since January 6, 2021.
When would it be removed? Only
insurrection against the Constitution.
So were his actions after that date, before he left office, ultra vires? Is that where your theory leads?
Well, that would raise the separate question of whether one can collaterally attack the actions of a de facto officer. And that may be the one place in Griffin's case at the very end where we would agree, which is when Justice Chase said, I've talked to my Supreme Court colleagues and we unanimously agree that you can't collaterally attack all official actions of an officer who's in fact holding the position.
All right,
under
but
Section.
just circle back to where we started, right? That this is Section 3, your authority has to come from there, and it's about holding office, and it's a particular kind of disability that can be removed by Congress, and it's the only one like that, right? They can't remove age or citizenship. How should that inform our thoughts about a state's efforts?
Of course, it's just
to
answering your
make the ballot
question,
for
Robin.
Federal office.
The colloquy that my friend had with Justice Alito earlier, I think, is illustrative here. The
You just
fact
answered
that
your
Congress
question.
has an extraordinary removal power does not negate that the disability exists today and exists indefinitely into the future, much like the fact that the president can pardon somebody for criminal conviction doesn't make that conviction somehow contingent. And I would note that if President Trump were appointed to an office today, if he were appointed as a state judge, he could not hold that office, which shows that the disability exists now. And the fact that Congress has a power to remove the disability doesn't negate the present qualification, nor does it implicitly bestow on President Trump a constitutional right to run for offices that he cannot hold in violation of state law and state procedure under Article 2.
In fact, there was a congressional action to permit Confederate officers or people who supported the Confederacy to hold office before the 14th Amendment, correct? So there must have been a thought that there was a pre-existing disqualification.
That's absolutely right. There were a flood of amnesty requests even before Section 3 went into effect, because everybody understood at the time that those people would be disqualified the moment that Section 3 was enacted forever unless they received amnesty.
Counselor, what do you do with
the banner on the bottom?
What seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report
different
won't be
standards of
accepted in others
insurrection
because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others for the Republican
Mrs.
candidate,
Roberts,
you're off the ballot. And it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty
retarded
consequence.
Pretty retarded consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no,
not frivolous.
I mean, you might think they're frivolous, but probably the people who are bringing them may not.
We think you're frivolous. We think this is frivolous.
Insurrection is a broad broad term. And if there's some debate about it, I suppose that will go into the decision. And then eventually what we would be deciding whether there
On a
was an
case every
insurrection
time?
when one president did something as opposed to
We're gonna have
when
a whole
somebody
hearing
else
about
did
whether there's
something
insurrection
else. And
every
what do we
time
do?
there's a
Do we
claim.
wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't
Because it's
seen
stupid.
anything like January 6th.
Not relevant. No,
since
because it's not
Reconstruction.
relevant.
Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other
Nice.
states may
Get
have
him,
different
Roberts.
views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it was right. And we'd have to develop rules for what constitutes an insurrection.
Which sounds
Yes,
like
Your Honor,
judicial
just like this court
legislation.
interprets other constitutional provisions, this court can make clear that an insurrection against the Constitution is something extraordinary. And in particular, it really requires a concerted
still ducking.
group effort to resist through violence, not some ordinary application of state or federal law, but the functions mandated by the Constitution.
On your point
itself.
that it's been dormant for 155 years, I
Kavanaugh.
think the other side would say the reason for that is Chief Justice Chase's opinion in 1869 in
The Griffin
Griffin's
case.
to start, which says that Congress has the authority here, not the states. That's followed up by the Enforcement Act of 1870, in which Congress acts upon that understanding, which is followed, and there's no history contrary in that period, as Justice Thomas pointed out. There's no history contrary in all the years leading up to this of states exercising such authority. I think the reason it's been dormant is because there's been a settled understanding that Chief Justice Chase, even if not right in every detail, was essentially right, and the
I'll link you.
branches of the government have acted under that settled understanding for 155 years, and Congress can change that. And Congress does have Section 2383, of course, the Insurrection Act criminal statute, but Congress could change it, but they have not in the 155 years in relevant respects.
I said
for
I'm
what
going to link
want
you.
here today, at least.
No, Justice Kavanaugh. The reason why it's been dormant is because by 1876, essentially all former Confederates had received amnesty. And we haven't seen anything like an insurrection.
But what about other
since then.
insurrectionists? They
I'd like
thought
to
it would
address
never
your
happen
point.
again?
Well, you
Can I
know,
go to
we
that
didn't-
point?
After the,
So they didn't mean for it to apply to
I don't
anything
know
but
how
the
much
Civil
we
War?
can infer from the fact that we haven't seen anything like this before, and therefore conclude that we're not going to see something in the future.
Thank you.
From the time
You
of the
asked my
impeachment
question.
of President Johnson until the impeachment of President Clinton, more than 100 years later, there were no impeachments of presidents. And in fairly short order over the last couple of decades, we've had 3. So I don't know how much you can infer from that.
Certainly, but if this court affirms, this court can write an opinion that emphasizes how extraordinary insurrection
This is
against
at
the
least 7-2.
Constitution is and how rare that is, because it requires an assault not just on the application of law, but on constitutionally mandated functions themselves, like we saw on January 6th, a coordinated attempt to
The Whiskey
disrupt a
Rebellion?
function
There's lots of
mandated
insurrections.
by the 12th Amendment and essential to constitutional
Supposedly.
transfer
Let
of
me ask you a
presidential
question
power.
about whether the power that you've described as plenary really is plenary. Suppose that the outcome of an election for president comes down to the vote of a single state, how the electors of the vote of a single state are going to vote. And suppose that candidate A gets a majority of the votes in that state, but the legislature really doesn't like candidate A, thinks candidate A is an insurrectionist. So the legislature then passes a law ordering its electors to vote for the other candidate. Do you think the state has that power?
I do.
Maybe principles that come into play in terms of after the
Little hot.
people have voted, that the state can't change the rules midstream. I'm not sure because I'm not aware of this court addressing it. And certainly as
Well, let's change it so that it's not after the election. It's 3 days before the election based on the fact that the polls in that state look bad. Can they do it?
I think they probably could under this court's decision in Chafalo, where this court emphasized that for much of American history, state legislatures picked their own electors and assigned their own electors themselves. But of course, that would be much more extraordinary than what we have here, which is simple application of normal state ballot access principles to say that we're only going to put on the ballot an individual who is qualified to assume the office.
Could I ask you again the question that Justice Gorsuch asked, and to which you responded by citing the de facto officer doctrine? But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?
I'm not sure that anything gives military officers the authority to adjudicate effectively the legality of the presidency.
Why not? Because you say he's disqualified from the moment it happens. Now, I understand the de facto officer doctrine might be used to prohibit people from seeking judicial remedies for decisions that take place after the date he was disqualified. But if he's in fact disqualified from that moment, why would anybody have to obey a direction from him?
Well, ultimately, there still has to be some kind of procedure in place to adjudicate the disqualification. Certainly, Congress could
50 different
impeach a sitting
procedures according to
president,
you.
but that's the only remedy I'm aware of that exists for removal or otherwise negating the authority of a sitting president.
Why?
Well,
On what theory? Because the Section 3 speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless,
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment. Self-executing, done. And I would think that a person who would receive a direction from that person, the president, former president, in your view, would be free to act as he or she wishes without regard to that individual.
Nice.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is
no de facto. That doesn't work, Mr. Murphy. De facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review.
Nice.
Put that aside. I'm not going to say it again. Put it aside.
I'm going to explain de facto later.
I think Justice Alito's asking a very different question,
I'll explain it
a
after it's over.
a more difficult one for you. I understand, but I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was, a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
No, we're talking about Section 3. Please don't change the hypothetical.
Dang!
Okay? Please don't change the hypothetical.
He's
I know
crushing
I like
him.
doing it too, but please don't do it. Okay?
Well, the point I'm trying to make is
He's disqualified from the moment he committed an insurrection, whoever it is, whichever party. That happens. Boom. It happened. What would compel, I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
because ultimately we have statutes and rules requiring change of command. The person is in the office, and even if they don't have the authority to hold the office, the only way to get someone out of the office of the presidency is impeachment. And so I think if you interpreted section,
that's not what you said,
in light of other provisions in the Constitution like impeachment, while they hold office, impeachment's the only way to validate that they don't have the ability to hold that office and should be removed.
Mr. Murray, can I just ask you about something Justice Kagan brought up earlier, which
Kenji
is
Brown Jackson.
The concern about uniformity and the lack thereof.
I think she's going to join.
Are permitted
right
to enforce Section 3 in presidential elections, and I guess I didn't really understand your argument or your response to her about that.
Well, certainly, if Congress is concerned about uniformity, they can provide for legislation and they can preempt state legislation.
Yes, but you say that's not necessary.
But it's not necessary. In the absence of federal enforcement legislation, these questions come up to this court in the same way that other federal questions come up to this court, which is that a state adjudicates them. If the state hasn't provided sufficient process to comport with due process, a notice, an opportunity to be heard, one can make those challenges. But assuming, as here, we have a full evidentiary record, an opportunity to present evidence.
So I understand that we could resolve it so that we have a uniform ultimate ruling on it. I guess my question is why the framers would have designed a system
Where we
that
have to decide.
could result in interim disuniformity in this way, where we have elections pending and different states suddenly saying you're eligible, you're not, on the basis of this kind of thing.
She has a lot of
Well, what they
problems
were
with
concerned
petitioners.
most about was ensuring that insurrectionists and rebels don't hold office. And so once one understands the sort of imperative that they had to ensure that oath breakers wouldn't take office, it would be a little bit odd to say that states can't enforce it, that only the federal government can enforce it, and that Congress can essentially rip the heart out of Section 3 by a simple majority just by failing to pass enforcement legislation. Federalism creates redundancy. And here, the fact that states have the ability to enforce it as well, absent federal preemption, provides an additional layer of safeguards around what really Section 3.
Yeah, and I'll ask you about the history when I get a chance again. Thank you.
Thank you, counsel.
She made that mistake earlier
Justice Alito?
of jumping to the next topic.
And
And the
suppose
other
there's a
justices were
country
like, we don't do that here.
proclaims again and again and again that the United States is its biggest enemy. And suppose that the president of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country. Could a state determine that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This court has never interpreted the aid and comfort language, which also is present in the treason clause. But commentators have suggested, it's been rarely applied because treason prosecutions are so rare, but commentators have suggested that, first of all, that aid and comfort really only applies in the context of a declared war, or at least an adversarial relationship where there is, in fact, a war between two countries. And second, the intent standard would do a lot of work there, because under Section 3, whatever the underlying conduct is, engaging in insurrection or aid and comfort has to be done with the intent to further the unlawful purpose of the insurrection or to aid the enemies in their pursuit of war against the United States.
Now, let me come back to the question of what we would do if different states had adjudicated the question of whether former President Trump is an insurrectionist using a different record, different rulings on the admissibility of evidence, perhaps different standards of proof, then what would we do?
Ultimately, this court would, first of all, if there were deficiencies in the record, the court could either refuse to hear the case or it could decide on the basis of deficiencies of the record.
Well, what would we have to decide? What is the appropriate rule of evidence that should be applied in this case? Would we have to decide what is the appropriate standard of proof? Would we give any deference to these findings by state court judges, some of whom may be elected? Would we have to have our own trial?
No, Your Honor. This court takes the evidentiary record as it's given, and here we have an evidentiary record that all the parties agree is sufficient for a decision in this case. And then, as I discussed earlier, there's a possibility of a Bose Corp independent review of the facts. But ultimately, what we have here is an insurrection that was incited in plain sight.
You're really not answering my question. It's not helpful if you don't do that. Suppose we have two different records, two different bodies of evidence, two different rulings on questions of admissibility, two different standards.
Yeah, when two states could be
two different
conclusions.
sets of fact findings by two different judges, or maybe multiple judges in multiple states, then what do we do?
First, this court would set the legal standard, and then it would decide which view of the record was correct, I think, under that. If this court had two cases,
which view of what record? Which record?
If this court had two cases before it, and both of the records were sufficient insofar as both sides had the opportunity to present their case and the essential facts in the record that everyone agreed was sufficient for decision, then this court would have to look at the evidence presented and decide which holding was correct, and then decide that issue for the country. And certainly here, when there is a complete record, Lower courts then will be applying that decision, and I think it's unlikely that any court would say, we're going to reach a different decision than the U.S. Supreme Court did, particularly if the court relies on the facts, the indisputable facts of what President Trump said on video and in his Twitter feed, which is really the essence of our case here.
Well, you had an expert, let's just take that example, had an expert testify about the meaning of what President Trump said. But do you think it's possible that a different state court would apply Daubert differently and say that
You ain't no
this
stinking
person
expert,
should
you
not be
jackass.
allowed to express an expert opinion on that question? You think that's beyond the realm of imagination?
Not at all, Your Honor. 2 points on that. Number one, President Trump didn't appeal the admission of that evidence in this case. But number two, the second point is that Professor Simi really, he didn't opine on the meaning of President Trump's words. He opined on the effect that those words had on violent extremists. And the essence of his testimony was built around videotaped statements of President Trump.
What's the difference?
Encouraging, inciting, and praising
question is
political
whether
violence.
Well, I'm not taking a position one way or the other about whether the expert's testimony should have been admitted or anything like that, or the meaning of President Trump's words. I'm just trying to get you to grapple with what some people have seen as the consequences of the argument that you're advancing, which is that there will be conflicts in decisions among the states, that different states will disqualify different candidates. But I'm not getting a whole lot of help from you about
They're hating on him.
This would not be an unmanageable situation.
If this court writes an opinion affirming on the basis of the indisputable facts of what President Trump said on January 6th and in the weeks leading up to it, and his virtual confession on Twitter after the fact, then it would be reversible error for any other state to conclude otherwise on that question of federal law. Or at the very least, this court could address that when those issues come up, but it seems unlikely.
Justice Sotomayor?
There's two sides to the other side's position. The first is that it's not self-executing. I want to put that aside. Deal with if we were to hold that states don't have the right to enforce or create a cause of action in this situation. They want the flip to say that no, but even Congress can't do it because they need implementing legislation. Address that argument.
She's trying to help him.
Assume we rule that states don't have it. What would you have us say for the other side of the argument? One of my colleagues says you need, or not then Chief Justice, but Circuit Court Justice Chase said, which is that somehow you need implementing legislation like the 1870 Act.
Well, that makes you question whether this still
You
applies
seem to
anymore.
say that's not true because they could decide not to seat seat a candidate, et cetera. So I don't know that legislation's necessary.
And certainly there are historical examples of members of Congress under Congress's Article 1 power to judge the qualifications of its members, of members of Congress refusing to seat ineligible candidates under Section 3 who have won election. In the context of the presidency, I think it would create a number of really difficult issues if the court says there's no procedure for determining President Trump's eligibility.
She's desperately trying to give him a softball and couldn't figure out how to word it.
And then what happens when members of Congress on January 6th, when they count the electoral votes, say we're not going to count electoral votes cast for President Trump because he's disqualified under Section 3 under the Electoral Count Reform Act. A number of the amicus briefs, such as those of Professor Ginsburg, Hassan, and Foley, have made the point that that is kind of a disenfranchisement and constitutional crisis in the making, and is all the more reason to address those issues now in a judicial process on a full evidentiary record so that everybody can have certainty on those issues before they go to the polls.
Justice Kagan?
Mr. Murray, you relied on the state's extensive powers under the Electors Clause. You talked about the states having a role in enacting, typical ballot access provisions. I guess, it strikes me that we've put some limits on that, and I'll just give you Anderson versus Celebrezzi as an example of that, where we said, in fact, states are limited in who they can take off a ballot. And that was a case about minor party candidates. But the reason was that one state's decision to take a candidate off the ballot affects everybody else's rights. And we talked about the pervasive national interest in the selection of candidates for national office. We talked about how an individual state's decision would have an impact beyond its own borders. So if that goes for minor political party candidates, why doesn't it go a fortiori for the situation in this case?
Well, certainly constitutional principles like Section 3 apply to everybody, but in Calabresi, the issue there was a First Amendment question. And certainly there's no doubt that states' exercise of their power under Article 2 is constrained by First Amendment principles. And in that case, the state law deadline
She's the smartest of the
minor
leftists.
party candidate got on the
The
ballot.
left
I agree,
side.
100%.
Assumed to be reactive to what major parties had done and therefore risk disenfranchising people who were disillusioned with who the major parties had picked. And it raised First Amendment problems. Here, there's no real First Amendment problem, and a state is just trying to enforce an existing qualification that's baked into our constitutional fabric.
Yeah, I guess, it did come up in the First Amendment, but there's a broader principle there, and it's a broader principle about who has power over certain things in our federal system. And, within our federal system, states have great power over many different areas, but that there's some broader principle about that there are certain national questions where states are not the repository of authority. And I took a lot, First Amendment, not First Amendment, a lot of Anderson's reasoning is really about that. Like, what's a state doing deciding who gets to, who other citizens get to vote for president?
Colorado is not deciding who other states get to vote for
course they
president.
are.
It's deciding how to assign its own electors under its Article 2 power. And the Constitution grants them that broad
Well, but the
power
effect
as-
of that is obvious, yes?
No, Your Honor, because different states can have different procedures. Some states may allow insurrectionists to be on the ballot. They may say,
That
we're not
does make
looking
sense.
past the papers. We're not going to look into federal constitutional questions. It's the sort of this, I mean, even in this election cycle, there are candidates who are on the ballot in some states, even though they're not natural-born citizens, and off the ballot in other states. And that's just a function of states' power to enforce, to preserve their own electors and avoid disenfranchisement of their own citizens.
Thank you.
Justice Gorsuch?
I
Might
had
be
a chance
8-1.
to talk about the officer point, and I just want to give you an opportunity to do that. Mr. Mitchell makes the argument that, particularly in the commissions clause, for example, all officers are to be commissioned by the president. Seems to be all-encompassing, that language. And I'm curious your response to that. And along the way, if you would, I poked a little bit at the difference between office and officer in the earlier discussion, you may recall. But I think one point your friends on the other side would make is, well, that's just how the Constitution uses those terms. So, for example, we know that the president pro tem of the Senate and the Speaker of the House are officers of the United States because the Constitution says they are. But we also know that they don't hold an office under the United States because of the incompatibility clause that says they can't. So maybe the Constitution to us today, to a lay reader, might look a little odd in distinguishing between office and officer, not prepositions, nouns, a distinction. But maybe that's exactly how it works. Thoughts?
Well, I'd start with the idea that the meaning of officer in the 1780s was the same meaning that it has today, which is a person who holds an office. And certainly in particular contexts like the commissions clause, it appears that that's referring, that is referring to a narrower class of officers, because we know that there are.
Except it says all.
Well, we know that there are classes of officers, like the president pro tem, who don't get their commissions from the president.
Well, that's because the Constitution elsewhere says that.
We know that the appointments clause refers to a class of officers who get their appointment from the Constitution itself, rather than from presidential appointment. People who get their commissions from the president himself are not commissioned
I sent
by
you
the
a link.
president. And so if you read the appointments
Thanks
clause
for the
in
raid,
line
brother.
with the commissions clause,
You rock.
then the commissions clause is really talking about the president's power. If one needs a commission, it's the president who grants it. But I think it's important to bring us back to Section 3 in particular, because that was 80
But
years.
before we get to that, though, just the distinction between office and officer, do you agree that the Constitution does make that distinction, particularly with respect to the Speaker and President pro tem?
The Constitution makes that distinction, but at least in Section 3, an officer of the United States is a person who swears an oath and holds an office. Now, the President pro tem and the Speaker of the House, they don't swear a constitutional oath in that capacity. They swear a constitutional oath if they are a senator or representative in Congress in that official
What's
capacity.
up? Hey, Karen. Hey, Joe.
You're a little hot.
You agree they are officers who don't hold an office?
They're officers who may hold an office but don't swear an oath under Article 6 in that official capacity.
Well, how can they hold an office under the incompatibility clause? It says they can't.
Well, I think that's a fair point, and I think that may be an exception to the general rule, and one might consider them perhaps officers of the House and Senate because they are appointed by those bodies and preside over those bodies.
Well, the Constitution says they're officers of the United States. So there are some instances when you have an officer but not an office.
Those may be an exceptional circumstance, but I would...
Thank you.
You're welcome.
Justice Kavanaugh?
The concerns of some question have been the states having such power over a national office. Other questions about the different states having different standards of proof. And they seem underscored by this case, at least the dissenting opinion below. Justice Samore said, I've been involved, quote, I've been involved in the justice system for 33 years now, and what took place here doesn't resemble anything I've seen in a courtroom, end quote. And then added, quote, what transpired in this litigation fell woefully short of what due process demands, end quote. Now, I don't know whether I agree or not. I'm not going to take a position on that. But the fact that someone's complaining not about the bottom line conclusion, but about the very processes that were used in the state would seem to, and that would be permitted, seems to underscore the concerns that have been raised about state power. Just wanted to give you a chance to address that because that was powerful language. Again, not disagreeing about the conclusion, but about the very fairness of the process.
Yes, Your Honor, but that language was, with respect to Justice Samore, just not correct. President Trump had a 5-day trial in this case. He had the opportunity to call any witnesses that he wanted. He had the opportunity to cross-examine our witnesses. He had the opportunity to testify if he wanted to testify. And of course, the process was expedited because ballot access decisions are always on a fast schedule. But in this whole case,
he's under federal prosecution. He had an opportunity to testify.
President Trump has never identified a single process other than expert depositions that he wanted to have that he didn't get. He had the opportunity for fact witness depositions. He had the opportunity to call witnesses remotely. He didn't use all of his time at trial. There was ample process here.
That's a lie.
Determinations in election cases are decided all the time.
Okay. Second question. Some of the rhetoric of your position, I don't think it is your position, but some of the rhetoric of your position seems to suggest unless the states can do this, no one can prevent insurrectionists from holding federal office. But obviously Congress has enacted statutes, including one still in effect, Section 2383 of Title 18 prohibits insurrection. It's a federal criminal statute. And if you're convicted of that, you are, it says, shall be disqualified from holding any office. And so there is a federal statute on the books, but President Trump has not been charged with that. So what are we to make of that?
Two things, Your Honor. Section 2383 was initially enacted about 6 years before Section 3. It wasn't meant as implementing legislation related to Section 3. And I would emphasize that by the time that Section 3 was ratified, most Confederates had already received criminal pardons.
I guess the question's a little bit different, which is if the concern you have, which I understand, is that insurrectionists should not be able to hold federal office, there is a tool to ensure that that does not happen, namely federal prosecution of insurrectionists. And if convicted, Congress made clear you are automatically barred from holding a federal office. That tool exists, you agree, and could be used, but has not, could be used against someone who committed insurrection. You agree with that?
That's absolutely right, Your Honor. But I would just make the point that the framers of Section 3 clearly understood that criminal prosecutions weren't sufficient because oftentimes insurrectionists go unpunished, as was the case in the Civil War. And that the least we can do is impose a civil disqualification penalty so that even if we don't have the stomach to throw someone in jail.
Well, they had the quo warranto provision that was in effect then from 1870 until 1948, but then obviously that dropped out and hasn't been seen as necessary since then. Last question, in trying to figure
Mrs.
out
Kavanaugh.
what Section 3 means, and to the extent it's elusive language or vague language, what about the idea that we should think about democracy, think about the right of the people to elect candidates of their choice, of letting the people decide, because your position has the effect of disenfranchising voters to a significant degree. And
Nice.
should that be something, does that come in when we think about, should we read Section 3 this way or read it that way? What about the background principle, if you agree, of democracy?
Or that there'll be
I'd like to make
riots in the
3 points
streets.
on that, Justice Kavanaugh. The first is that constitutional safeguards are for the purpose of safeguarding our democracy, not just for the next
Very
election
safeguarding.
cycle, but for generations to come. And second, Section 3 is designed to protect our democracy in that very way.
No, it's
The
not.
framers of Section 3 knew from
No, it's
painful
not. It's to punish.
experience that those who had violently broken their oaths to the Constitution couldn't be trusted to hold power again because they could dismantle our constitutional democracy from within. And so they created a democratic safety valve.
We're stealing
President
your
Trump can go
democracy
ask
for your own
Congress to
good
give
to
him
keep you
amnesty by a
safe.
2/3 vote. But unless he does that, our Constitution protects us from insurrectionists. And third, this case illustrates the danger of refusing to apply Section 3 as written, because the reason we're here is that President Trump tried to disenfranchise 80 million Americans who voted against him, and the Constitution doesn't
Or
require that
60
he be given
million,
another
somewhere
chance.
around there.
Thank you. Justice Barrett?
So the general rule is that absent rare circumstances, state courts and federal courts share authority. State courts have authority to enforce the Constitution, but there are certain limits to that, certain situations in which the Constitution itself preempts the state's ability to resolve constitutional questions. And, you know, Tarbell's case is one, and you said earlier that once a president is elected, you accepted that a state couldn't do anything about that. Like Colorado couldn't enact its own, say, quo warranto provision and then
Why not?
use it to get the Secretary of State or the president or anyone else out of office.
Why not?
And I assume that's because of this principle of structural preemption. Am I right?
Yes, Your Honor.
Okay. So I just want to clarify what
This
that
is
means for your
Barrett,
argument.
yeah.
That means that your eggs are really in the basket of the electors clause, really in the Article 1 basket, because you're saying that even though all of the questions that people have been asking have suggested that there's a problem with giving a single state the authority to render a decision that would have an effect on a national election. But you're saying that those structural concerns, which might otherwise lead to the kind of result that you would accept after someone is in office, are overcome by the electors clause.
Absolutely. States run presidential elections. That's very clear from Article 2. Once states have selected the electors and the electors have voted, states have no more power over the candidate who has been then nominated for president. But until then, the states do have the power to adjudicate those issues.
Thank you.
Justice Jackson?
So when I asked you earlier about the uniformity concern and the troubling potential disuniformity of having different states enforce Section 3 with respect to presidential elections, you seem to point to history in a certain way. You said, I think,
We're
that
covering this on
the
locals
framers
tonight.
actually envisioned states enforcing Section 3.
Lawgic.com.
At least in some circumstances where there were insurgents and Confederates. And I guess in my view of the history, I'm wondering really whether presidential elections were such a circumstance, that the framers actually envisioned states enforcing Section 3 with respect to presidential elections as opposed to senatorial elections, representatives, the sort of more local concerns. So can you speak to the argument that really Section 3 was about preventing the South from rising again in the context of these sort of local elections as opposed to focusing on the
6
presidency?
p.m. tonight, live
2
airing.
points on that, Justice Jackson. First is that,
Good
as I
fucker.
discussed earlier, there isn't the same history of states regulating ballot access at this time. So ballot access rules to restrict presidential candidates wouldn't have existed. They wouldn't have been raised one way or another.
Right, but I'm not making a distinction between ballot access and
No,
anything else. Yeah.
Understood, but the more broad point I want to make is that what is very clear from the history is that the framers were concerned about charismatic rebels who might rise through the ranks up to and including the presidency of the United States.
But then why didn't they put the word president
They
in
weren't
the
afraid
very
of charismatic.
enumerated list
Yeah.
in section 3? The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred.
Told
and
you.
president is not there.
At least
And so
7
I
2.
guess that just makes me worry that maybe they weren't focusing on the president and, for example, the fact that
should walk out now.
electors of vice
You should
president and
It's like, my
president
lost
are
KBJ.
there
I'm done.
suggests that maybe what they thought was, if we're worried about the charismatic person, we're going to bar insurrectionist
Stonewall Jackson.
electors,
This is Stonewall
and
Jackson
therefore
talking
that
now.
person is never going to
This came up in the debates in Congress over Section 3, where Reverdy Johnson said, why haven't you included president and vice president in the language? And Senator Morrill responds, we have. Look at the language, any office under the United States.
Yes,
And
but doesn't that at least suggest ambiguity? And this sort of ties into Justice Kavanaugh's point. In other words, we had a person right there at the time saying what I'm saying. The language here doesn't seem to include president. Why is that? And so if there's an ambiguity, why would we construe it to, as Justice Kavanaugh pointed out, against democracy?
Well, Reverdy Johnson came back and agreed with that reading. Any office is clear. The Constitution says about 20 times.
No,
that the
I'm not
presidency
going
is
to
an
that.
office.
So let me just say, so your point is that that there's no ambiguity with having a list and not having president in it.
So I think there's
with having
ambiguity,
a
but you think
history
there's
that
none.
suggests that they were really focused
Okay.
on local
Maybe you're
concerns in
right.
the South.
I disagree with you.
With this conversation where the legislators actually discussed what looked like an ambiguity. You're saying there is no ambiguity in Section 3?
Let me take the point specifically about electors and senators, if I might, because I think that's important. Presidential electors were not covered because they don't hold an office. They vote. And this
No, I'm
court's
talking about the
decision-
barred office part of this.
Exactly. So the
Right.
barred offices, if you want to include everybody, first you have to specify presidential electors because they're not offices, so they wouldn't fall under any office. Second of all, senators and representatives don't hold office either. The Constitution tells us that under the incompatibility clause and refers to them as holding seats, not offices. And so you want to make sure that there's no doubt that senators and representatives are covered, given that the
But there is
Constitution
doubt
suggests
about whether it's the
otherwise.
president.
You have to include that. The Constitution says the presidency holds an office, as do members of this court. And so other high offices, the president, vice president, members of this court.
All right, let me ask you, I appreciate that argument.
Do you?
If we
Probably
think
not.
that the states can't enforce this provision for whatever reason in this context, in the presidential context, what happens next in this case? I mean, is it done?
If this court concludes that Colorado did not have the authority to exclude President Trump from the presidential ballot on procedural grounds, I think this case would be done, but I think it could come back with a vengeance because ultimately members of Congress may have to make the determination
that's gonna happen.
after a presidential election if President Trump wins
that
about whether or not he's disqualified from office and whether
luck with that.
cast for him under the Electoral Count Reform Act. So
vengeance.
President Trump himself urges this court
Vengeance
in the
of a
first few
failed-
pages
of a
of his brief
failed
to resolve the issues
bill,
on the merits,
proposed bill.
and we think that the court should do so as well.
And there's no federal litigation, you would say?
Well, that's correct because there is no federal procedure for deciding these issues short of a criminal prosecution.
Thank you.
Thank you, counsel.
Oh, good. So we can put this to bed forever now. We don't have to
Ever
worry
and
about-
ever and ever. Until next election.
I totally agree with you. I think it's not. I think it's going to be. I think Kagan even
Stevenson?
might come along.
Mr. Chief,
Oh, yeah.
Anderson. No, Stevenson. That's right. I'm sorry.
Mr. Chief Justice, and may it please the court, exercising its far-reaching powers under the Electors Clause, Colorado's legislature specifically directed Colorado's courts to resolve any challenges to the listing of any candidate on the presidential primary ballot before Coloradans cast their votes. Despite this law, petitioner contends that Colorado must put him on the ballot because of the possibility that there would be a supermajority act of Congress to remove his legal disability. Under this theory, Colorado and every other state would have to indulge this possibility, not just for the primary, but through the general election and up to the moment that an ineligible candidate was sworn into office. Nothing in the Constitution strips the states of their power to direct presidential elections in this way. This case was handled capably and efficiently by the Colorado courts under a process that we've used to decide ballot challenges for more than a century. And as everyone agrees, the court now has the record that it needs to resolve these important issues.
No, it does.
I welcome
Not
your
everyone
question.
agrees with that at all.
Is there an express provision with respect to that defines what a qualified candidate is?
No, Your Honor, there's not an express provision. When the Colorado Supreme Court looked at this, they looked at the need to be qualified, plus the fact that this part was.
So what does it say then? If it's not express, how do we get to this issue of qualified candidate?
What the Colorado Supreme Court did, and let me, if I could have a standing objection, I do want to make the argument that you shouldn't review the court's statutory interpretation.
No, I'm just looking at the statute.
What the court did was to say that we have important provisions in this section that show that candidates have to be qualified. First, it requires that under 1203 2A, that a political party that wants to participate has to have a qualified candidate. It also looked at the fact that the comparable write-in candidates also had to be qualified.
No, but this isn't a write-in candidate, so we're actually talking about the participation of a political party, right? We're not talking about the participation of a candidate.
Sure, I think that the fact that the write-in candidate also had to be qualified was confirmatory of the fact that the political party candidate also had to be qualified.
Thanks for covering up my face when you were putting up the racist stuff.
So how is section?
I was never here.
Under the reasoning of the Colorado Supreme Court.
No, just on its face.
A candidate must meet all the criteria for eligibility, and I don't perceive any distinction between meeting the eligibility criteria and not being disqualified. I just don't see any meaningful difference between those two things.
Thank you. You represent the Secretary of State, right?
That's correct.
If you're the Secretary of State somewhere and someone comes in and says, I think this candidate should be disqualified, what do you do next?
Administratively, and what the Deputy Elections Director testified to at the hearing is that if they obtain objective knowable information, the Secretary can act on that and inform the candidate.
So the Secretary at first decides whether that's objective knowable information.
In some instances. In this case, the challenge was actually brought before the candidate's paperwork had even been submitted. And because there had already been a challenge asserted and put into the proper court procedure, the Secretary didn't even make that determination because he didn't have paperwork.
Well, what in another case where that wasn't the procedure that was filed, somebody comes in, maybe they've got a stack of papers saying, here's why I think this person is guilty of insurrection. It's not a big insurrection, something that, happened down the street, but they say this is still an insurrection. I don't know what the standard is for when it arises to that.
I think anything that even presented that level of controversy about one person having a set of facts that they said prove this would send this case to the 113 procedure that we use to resolve ballot challenge issues like that. And if another elector or the individual who brought the information didn't want to bring it, the Secretary herself could bring that action.
Is there a provision for judicial review of the Secretary of State's action, both in Colorado and perhaps what you know about other states?
Well, certainly in Colorado, if any action that the Secretary takes that anyone wants to challenge, they can use the 113 process to do so. I think states have varying degrees of that. There's certainly other states that allow versions of that. And then I don't know whether there are others that don't. I certainly know that there are some that do.
I think we're told that there are states that do not provide for any judicial review of a Secretary of State's determination. Is that incorrect?
No, I think that's right. And I think there are some states that actually have no mechanism to come to, I think, Justice Kagan's point, or there are some states that don't have any mechanism to exclude a disqualified candidate from the ballot at all. And I do want to speak to that for just a minute about the actual.
Well, would that be constitutional if the Secretary of State's determination was final?
I think so. Under Article 2, the Electors Clause, Your Honor, that would be constitutional. States get very broad authority to determine how to run their presidential elections.
Could a state enact a statute that provides different rules of evidence and different rules of procedure and different standards of proof for this type of proceeding than for other civil proceedings?
Yes, Your Honor, I believe it could, under the same Electors Clause power.
That issue would be determined under perhaps a different constitutional provision like the Due Process Clause, correct?
Correct. The bounds of the Electors Clause are other constitutional constraints, which would include due process, equal protection, First Amendment.
What's the due process right? Does the candidate have a due process right? What's the liberty interest?
I think it's not very precisely defined in the case law, but I think there is a recognition that there is a liberty interest of a candidate, and there is some due process interest in being able to access the ballot.
I thought that was for voters. You think for the candidate too, that it would be taking something away from the candidate?
Certainly, yes, and I think a lot of times you see that in the First Amendment context where candidates can have an issue about being on the ballot, but it's sort of a hybrid, oftentimes First Amendment, 14th Amendment, qualifications clause.
You're arguing about the
all
Secretary of State means you don't need a
discussed
14th
Let me
Amendment.
ask you a question
You just
about
say we don't
just
like you.
follow up to Justice Alito. These decisions might be made different ways in different states. Maybe a Secretary of State makes it in one state with very little process, or a process more like Colorado's could be followed by others. Would our standard of review of the record vary depending on the procedure employed by the state?
I think this court has tremendous discretion to decide its standard of review, and it might be based on the process that was employed by an individual state. I think you could exercise the independent review of Bose Corp that Mr. Murray talked about, or you could give deference where you have a full-blown proceeding like the one here that had all the protections of rules of evidence and cross-examination and things like that.
I'm sorry. You think we should give deference in reviewing the factual record, the legal conclusions? What, in other words, we shouldn't undertake a de novo review?
I don't think the review should be de novo. However, I am amenable to the suggestion that the court would do the Bose Corp type independent review that might provide greater certainty to states around the country as to what the court's position is on the factual record in this case.
Of course, if it were not de novo review, we could reach disparate results even on the same record, right?
I think that's possible.
Your position is that this disqualification is really the same as any other disqualification, age or residence or
No,
what
it's the
have you.
Secretary of State can do whatever the hell she wants.
And what if I were to push back on that and say, well, this disqualification, number one, it's in the 14th Amendment, and the point of the 14th Amendment was to take away certain powers from the states. Number two, Section 3 itself gives Congress a very definite role, which Mr. Mitchell says is interfered with by the ability of states to take somebody off the ballot. Maybe number three, it's just more complicated and more contested. And if you want, more political. And why don't all of those things make a difference in our thinking about this qualification as opposed to any other?
And so, Your Honor, I think the trouble with categorizing the insurrection issue as necessarily more difficult is it's just an assumption that's coming up, I think, because of this case. And again, back to the Chief Justice's point, we could have a very easy case under the 14th Amendment with an avowed insurrectionist who, came in and wrote on his paperwork, I engaged in an insurrection in violation of the 14th Amendment. And it would be an open and shut case as to whether or not that person would meet the qualifications to be on the Colorado ballot.
I'm not sure that's true.
With respect to your other questions about the 14th Amendment, my positions are based on the assumption that under the 14th Amendment, the states have the power to enforce Section 3, just like they do other presidential qualifications. And I would defer to the electors' arguments on those points.
Suppose a state that does recognize non-mutual collateral estoppel makes a determination using whatever procedures it decides to adopt that a particular candidate is an insurrectionist. Could that have a cascading effect? And so the decision by a court in one state, the decision by a single judge whose factual findings are given deference, maybe an elected trial judge, would have potentially an enormous effect on the candidates who run for president across the country. Is that something we should be concerned about?
I think you should be concerned about it, Your Honor, but I think the concern is not as high as maybe it's made out to be in particularly some of the amicus briefs. And again, under Article 2, there is a huge amount of disparity in candidates that end up on the ballot on different states in every election. Just this election, there's a candidate who Colorado excluded from the primary ballot who is on the ballot in other states, even though he is not a natural born citizen. And that's just that's a feature of our process. It's not a bug. And then I think with respect to the decision making, and we're here so that this court can give us nationwide guidance on some of the legal principles that are involved. I think that reduces the potential amount of disparity that would arise between the states. And then with respect to the factual record and how that gets issued and implemented, states have processes for this. And I think we need to let that play out and accept that there may
This
be
is why they're
some
gonna have to
messiness
rule
of
to strip
federalism here
states of
because
this
that's
right.
what the Electors Clause assumes will happen. And if different states apply their principles of collateral estoppel and come to different results, that's okay. And
They
Congress
put this whole thing to bed.
can
If
act
they
at any
just say
time
states cannot
if it thinks that
have
it's
no
truly
power to
federalism run
implement
amok.
this on a national election.
Justice Thomas, anything
Mhm.
further? Justice Alito?
Well, just one further question, and it's along the same lines of a lot of other questions. We've been told that if what Colorado did here is sustained, other states are going to retaliate, and they're going to potentially exclude another candidate from the ballot. What about that situation?
Your Honor, I think we have to have faith in our system that people will follow their election processes appropriately, that they will take realistic views of what insurrection is under the 14th Amendment. Courts will review those decisions. This court may review some of them, but I don't think that this court should take those threats too seriously in its resolution of this case.
You don't think that's a serious threat?
I think we have
We
processes.
should proceed on the assumption that it's not a serious threat.
I think we have institutions in place to handle those types of allegations.
What are those institutions?
Our states, their own electoral rules, the administrators who enforce those rules, the courts that will review those decisions, and up to this court to ultimately review that decision.
Justice Sotomayor? Justice Kagan? Justice Kavanaugh? Justice Jackson, anything further? Thank you, counsel.
Thank you.
Rebuttal, Mr. Mitchell?
Both Mr. Murray and Ms. Stevenson rely heavily on the Electors Clause and the authority that it gives the legislature of each state to direct the manner of appointing presidential electors. But that prerogative under Article 2 must be exercised in a manner consistent with other constitutional provisions and restrictions. And Justice Kagan alluded to one of those restrictions that might be imposed by the First Amendment, but there are others. A state cannot use its power under Article 2's Electors Clause to instruct its presidential electors only to vote for white candidates. That would violate the Equal Protection Clause. But nor can it exercise its power in a manner that would violate the constitutional holding of U.S. term limits against Thornton. And they cannot use the Electors Clause as an excuse to impose additional qualifications for the presidency that go beyond what the Constitution enumerates in Article 2. And the problem with what the Colorado Supreme Court has done is they have, in a way, changed the criteria in Section 3 by making it a requirement that must be met before the candidate who is seeking office actually holds the office, effectively moving forward in time the deadline that the candidate has for obtaining a congressional waiver. There has still been no answer from the Anderson litigants on how to distinguish the congressional residency cases, where the courts of appeals, not decisions from this court, but the courts of appeals in applying this court's holding in U.S. term limits have unanimously disapproved state laws requiring congressional candidates to show that they inhabit the state from which they seek election prior to election day. And there still, in our view, is no possible way to distinguish those from the situation below in the Colorado Supreme Court. Mr. Murray also invoked the de facto officer doctrine as a possible way to mitigate the dramatic consequences that would follow from the decision of this court that rejects the rationale of Griffin's case, and that also agrees with Mr. Murray's contentions that President Trump is disqualified from holding office on account of the events of January 6th, and that he's covered by Section 3 as an officer of the United States. This court's recent decisions in Lucia and Arthrex held that officers who were unconstitutionally appointed under Article 2 and that made decisions under the APA that were attacked as invalid, those decisions were still vacated, and this court did not use any variant of the de facto officer doctrine to salvage the decisions that were made by these unconstitutionally appointed officers. There is no way to escape the conclusion that if this court rejects Griffin's case and also agrees with Mr. Murray's construction of Section 3, that every executive action taken by the Trump administration during its last 2 weeks in office is vulnerable to attack under the APA. And further, that if President Trump is reelected and sworn in as the next president, that any executive action that he takes could be attacked in federal court by anyone who continues to believe that President Trump is barred from office under Section 3. I'm happy to answer any other questions that the court may have.
Thank you, counsel.
Thank you.
The case is submitted.
All right. Well, there we go.
The Honorable Court is now adjourned until Friday, the 16th of February at 10 o'clock.
Okay. So we'll start off before there's a whole bunch of things that I plan on covering. A lot of questions that came up, a lot of issues. I think for the first time in my history of ever live streaming, while I was watching this, I literally started like putting stuff in the chat just so I would remind myself to go over it afterwards, because this is a very rich, legally rich case. There's so many fascinating elements to it that I want to try and make sure I cover as many of them as possible, because there's so many things that are confusing and things that were thrown out during the course of this. There were collateral arguments that came into these oral arguments. But I want to start by asking you this: what are your initial takeaways, Kurt?
Well, the aggressiveness of Justice Jackson was pleasantly surprising.
Yeah. She seems very strongly on the side of Trump in this one. No,
if she winds up writing the majority opinion, that will be very interesting.
That would be astonishing, right? If can you imagine how the left would react if they have to constantly refer to this as the Brown-Jackson decision? Oh my gosh, that's
I mean, if she's in the majority, they can force it. So
now since them, it'll be like rank up there with like the Brown-Jackson decision, the Dred Scott decision. It's like that's how bad they're gonna look at it. I mean, and I'll tell you this, this is how much the left is going nuts over the way Ketanji was asking questions. This is my resident lefty here, who basically displayed like everyone in the Democrats that like, hey, if we don't like the way a black person is talking, we're just gonna basically call him out. And
you ain't even black, to quote Joe Biden.
Yeah. I don't honestly, Linda, I'm disappointed. I really am. I was like, I don't think everyone on the left is like this, but it's like as soon as a black person expresses any thought that's not directly that's not in tune with what the left wants them to say, like all of a sudden it's disappointing. Anyway, but I don't allow racism here. I know you might not have realized how that came across, but it came across really, really ugly. But I want to get your thoughts as far as because there's so many different things that were coming up here. It was interesting how quiet they were when the attorney for the Secretary of State was there. Do you think that they had tuned out by then? Do you think that she was making powerful arguments? What did you think about the last of the speakers?
I feel like at that point they couldn't even be bothered anymore.
They were just like, yeah, we're just like, look, we went through all the issues we really care about. That's that, because I was tuning out a little. I was like, all right, yeah, okay, fine, but I mean, the argument that she was making basically came across as, look, states have plenary authority as to who's on the ballot. And to those of you who are unfamiliar with the term plenary, it basically means that they have carte blanche. They could decide whatever they want to do.
Absolute, unilateral.
They have absolute authority, and we can. That's what the Constitution gives states: absolute decision-making power on who's on the ballot. So, if the Secretary of State makes this decision, that's it. But if that's the case, you don't need the 14th Amendment. They could just, according to that argument, taken to the way she's reading it. And I was wishing one of the justices would ask her this question. You don't need the 14th Amendment. You could just say, we don't like Trump and we're keeping him off the ballot. Couldn't a state like, Louisiana come along and say, we don't like Biden, we have plenary authority, we're keeping him off the ballots? Couldn't they do that by that argument?
I also did appreciate that the justices, Justice Gorsuch being most notable, but not unique, in holding the advocates to the questions they were asking.
Yes.
That was nice. It's like, look, this is the question. Don't change the question. Don't modify the question. Answer the question.
It happened multiple times.
I did appreciate them beating down on the advocates a little.
Yeah, and it's so rare to see that. Normally, attorneys, we're used to, like, if we see a question we don't like, It's like, how do what's the most effective way to deflect from that one? And you just sort of like, here's the question you're asking me. That's like basically a bullet that's coming right at my forehead. But like, what about this other way of looking at it?
And the Supreme Court isn't in the mood for tap dancing today.
No, they really weren't. They were like, just answer the freaking question, counselor. He even said, if you don't have an answer, you can just say I don't have an answer. But he's like, I don't think that's what the right answer is. Let me try and pretend I have something here. It was
the problem is because it's based on his position, right? He has this position. It's like, okay, this is automatic self-executing. It happens instantly.
Yeah.
And it's like, okay, well, if that's true, then here's some things that would necessarily result from that.
Right.
And so he's like fighting that those things don't happen. It's like, well, we have checks and balances. Like, no. Like the adjudication of it is different than the fact of it.
Mm-hmm.
So we might have an adjudication later to determine it happened, but your premise is it happened automatically. And so without adjudication, someone can just be like, well, you're not the president anymore. I'm not going to follow your order.
Right.
And what's stopping that? And the answer is nothing stopping that. But he can't give that answer because it exposes the absurdity of his position.
Yeah.
So either he has to accept it and give the absurd answer, or he has to change his position, or he has to waffle. And
that's one of the notes I actually put in the chat where I want to explain the whole de facto officer retrospectively versus ongoing if it's self-executing. And I know that I just threw out a string of words here, which to most of you is just, and maybe even to Kurt, the way I worded it is just gobbledygook. But let me explain to you that basically this is along the lines of what Kurt was just talking about. One of the things they were talking about in the course of arguments when the first attorney against Trump was up there was this concept where he was basically saying that they were asking, okay, if you're saying it's self-executing, now understand, I should explain to you all what the phrase self-executing means for a moment. So when we're looking at this statute and we're saying basically, does this statute, at what point does this statute, would it kick in? Do you have to have a determination by a court that is an insurrectionist?
No.
And, or is it as soon as you engage in insurrection, you're not holding office anymore? And basically, so essentially, what the attorney against Trump was arguing was the moment the insurrection happened, at that moment, that he was a part of it. And let's assume that there was an insurrection. I know that most of you, and I agree with you, this was not an insurrection. You don't have to yell at me that it's not an insurrection, which I'm sure many of you are screaming at your phone or at your computer right now. I'm telling you right now, I don't think it was an insurrection at all.
We're going to accept the premise,
right,
and move on.
We're going to pretend for a moment, pretend that there actually was a real insurrection. Forget about Trump. Let's just put that aside for a moment. Just imagine there's a president, and that president somehow engages in insurrection at some point. Okay, not Trump, but some president 30 years from now actually like goes in guns a-blazing into Congress and says, "I don't like what you guys are doing," and starts shooting the place up. So now, and there's a real indisputable insurrection. So now, is he automatically removed from office, that he's no longer president in the moment that he engages in insurrection? And what this attorney was arguing was, yes, at that moment, you're no longer president. So then they were asking him, okay, well, if that's the case, because it's self-executing, that under this statute here, which says no person shall be a senator or whatever, and they want to include the president in this, and that since he previously took an oath and he's violating it by engaging in insurrection now, that it's self-executing, that immediately, boom, you're not president. Now, that's what this attorney was arguing, which is a little bit of a strange argument, because even if there's no finding of fact, there's no court, there's no criminal charges, nothing's happened yet. He's in the middle of firing off his guns. At that moment, he's no longer president. Now, if that's true, so he says, are you basically saying that as soon as someone engages in insurrection, that any order he gives someone 10 minutes later saying, hey, I want you to fire off, I want you to go to war, or I want you to send this letter off to some foreign dignitary, that person can say, go jump in a lake? Or are they obliged, if they're under his command, to follow his orders? And he basically was like, well, we have a de facto officer concept. So de facto officer is basically like, even if someone is not legally eligible to be there, but since everyone's assuming that they are eligible to be there, in that case, they're in that case, we're going to pretend as if they have the eligibility despite the legal ineligibility. So even though they're legally not supposed to be there, everyone thinks that they're there. So when they're carrying, and they have good reason to think that he's in that position. So when they carry out his commands, they're following orders, and we're going to respect that as if it's given by a legitimate person, even though this person is illegitimate. And the argument that was made back to me, I think it was by Gorsuch, was it might have been Alito, was basically that de facto argument is when we're looking back at how the president's officer responded and saying, was this valid? Are we going to count it now after the fact? Are we going to pretend it was done by a legitimate person? And we'll say, yeah, de facto we will, because that's what happened subsequent. That's because they followed his rules. But he's like, what? I'm not talking about after the fact when we're looking back retrospectively as to the power of what happened there, because that's what happened in the Griffin case. I'm going to explain to you all what happened in the Griffin case, but we'll get to that in a moment. But he's basically saying, I'm not asking about when we're looking back at the person. I'm saying you're now the officer in that position. What are you supposed to do in this position? Are you under what you're saying? Is the person supposed to say, screw you, you're no longer president, even though you were sworn in? Yesterday you fired up on Congress. Now you're no longer the president. I have to listen to you. Do you think he's in a position that he's allowed to say that to the president? And the guy was like, he's like deflecting. He's like, but we have video. Didn't you see the speech at the Ellipse?
Yeah.
He said the word fight 18 times. And it was just like, you answer the question. And he really didn't have anything.
What is some private in the military supposed to do here exactly?
Yeah.
As their commanding officer, is getting orders from the commanding officer, getting orders from the commanding officers, getting order from the presidents. Like, wait a second, I'm not allowed to follow an invalid, unlawful order. So am I supposed to refuse the order of my sergeant, who's supposed to refuse the order of my lieutenant, who's supposed to refuse the order of my captain, and so forth and so on?
This is all flowing down from this illegitimate president. So this brings us, the de facto issue actually brings us to the Griffin case. Those of you who are unfamiliar with the Griffin case. So what happened was this statute is passed in 1868. And after this statute is passed, there is a trial of a guy named Griffin. I think it was murder trial, right? So there's a murder trial of this guy where he's charged with murder in one of the southern states. And the judge who's presiding over it finds him guilty. And after he's found guilty, and the name of the judge is Sheffy. Amy Coney Barrett brought up some of the particularities of this case. So this judge Sheffy had fought in the Civil War for the South. And what Griffin said was, hey, look, I couldn't be found guilty by this judge because under the Section 3 of the 14th Amendment, he's not eligible to be a judge to hold this office because he had been sworn in previously. He violated his constitutional oath when he fought for the South, and anything that he did afterwards when he presided over my case was invalid. And since it's invalid, I can't. His conviction of my case shouldn't take effect. Well, this ended up coming before Chief Justice Samuel Chase, and he wrote what's called the Griffin decision. And this became basically what was accepted, but he wasn't, even though he was on the Supreme Court, it was called a circuit decision. Maybe you can explain historically what a circuit decision is, because I think you probably have a better grip on that than I do as to like how things functioned in 1870. So if you can walk through what's a circuit decision versus what the Supreme Court does.
Right. So this is a time when the Supreme Court is still doing circuit riding. So the justices of the Supreme Court would literally go
and riding mean not WRIT, but riding like not riding like riding like riding a horse. Circuit riding that they ride from circuit to circuit.
Right. Well, within the circuit, they're riding the circuit.
Right.
Because we have these. So we have the same concept today where we talk about the courts of appeal and you talk about it, the Ninth Circuit,
right,
or the Ninth Circuit Court of Appeals. Same concept, right? So anyway, so back then they had it. They still had the circuit courts. They were called circuit courts instead of courts of appeal, and the justices, all of them, would ride circuit. So at the time, the Chief Justice, along with I believe a district judge, where it was a 2-judge panel at essentially the Court of Appeals level. How about that? Does that make it simple?
Okay. Okay, you're
All
saying
right,
that
great.
he has the power of the Court of Appeals, meaning it's considered like one step below the Supreme Court when he
Yeah.
when he issues it. So that's why when we talk about is that case precedential, to attorneys understand the term precedential, meaning you must follow this. That's a precedent, and unless you have a reason to overturn that case, you must follow it. So now the question is, does the Supreme Court have to follow the Griffin decision?
No.
And the legal answer is obviously no. But it is considered very influential in the sense that
it was written by Chief Justice Chase, who was the Chief Justice at the time of the Civil War, and might have some thoughts and opinions as it relates to the 14th Amendment.
And what it meant, and how it's being, and what Congress was doing when they passed it.
He might have some thoughts.
Right. So, and shortly after, now part of the whole issue, as far as like who has power and say over this, is that Section 5 of the 14th Amendment says that Congress shall pass any laws necessary to effectuate the 14th Amendment.
By the way, just as an aside, because I think it's an interesting detail, at the same time that this decision was coming around, or contemporaneous to it, Chief Justice Chase, along with a district judge, were also the trial judges at the Court of Appeals level with respect to Jefferson Davis. So I know none of what I just said made any sense, but you just have to go with me. The Chief Justice of the United States and a district judge are the trial judges of Jefferson Davis, and the trial is occurring at the Court of Appeals.
Okay.
Great.
Yeah, that's
moving on.
All right. Well, anyway, the decision in Griffin that was issued by Chase was basically that this is not self-executing. And he said it doesn't just automatically, as soon as a person engages in insurrection, that they're now disqualified, but they actually have to be found guilty of insurrection. And if Griffin is controlling, in that case, and in order for the person to be invalidated, I think there's also a de facto element that he's like, look, he looks like the judge at the time, so there's a de facto element to it as well. But so when he issues that, no one in Congress was just finished passing this amendment, and he basically says that Congress is the one who has to write laws. This is before they actually wrote any laws that would give enactment to the Section 3 of the 14th Amendment.
That's exactly what self-executing means. You don't need any law because it is the law itself. It tells you everything you need to know. I mean, the Constitution is a law after all. It's the supreme law, to be more precise, but it's a law. So, hey, let's go.
So he said, we need to wait for Congress to write a law. And they did. Shortly after, they wrote laws, which as far as how this whole thing would carry out, and they wrote all these different laws with respect to how they were going to treat the South, within like a year of him issuing his decision, which seemed to be Congress's endorsement. And hey, we need to get moving on this because the Chief Justice just issued a decision saying we need to get moving on this, and those laws stayed in effect. And for one reason or another, they stayed in effect for the next 78 years, and in 1948. They end up basically being retracted and they're no longer law anymore. So
the last remnants of them, more precisely, that parts of it had changed along the way.
Right. So that's why now we're left in a situation where there is no actual law other than one law about insurrection. There is a separate law, which is 18 U.S.C. 2383, which says that anyone, which is basically has nothing to do with someone taking an oath, the way the 14th Amendment is, to uphold the Constitution. But it says if anybody is convicted of insurrection, that they are no longer eligible to hold various offices, and that they are barred from holding various offices. So that's essentially what is and the perspective of the Supreme Court and some of their questions seem to be, that seems to sort of fill that gap. Now we got that there. Why are we worrying about anything more with respect to Section 3 of the 14th Amendment to try and bar people? So, I'm sorry about that. I didn't mean to do that. Yeah, so that was one of the things that I just wanted, so you all have contextual background. And while we're talking about contextual background here, wasn't it great watching Ketanji Brown Jackson become an originalist? All of a sudden, she just started.
Send that woman a MAGA hat, man.
Oh my God, that was so beautiful. It was so beautiful. Someone wrote Stonewall Jackson Rising, and I was like, I don't know if he means Stonewall Jackson. Like the way I took this was, we're going to give Ketanji Brown Ketanji Brown Jackson the new nickname of Stonewall, because oh my God, that was unbelievable.
I want her to write this opinion so bad.
That would be hilarious. That would be friggin' hilarious. Yeah. So I want to explain to you all the difference between textualism and originalism, because whenever legal scholars are trying to understand,
I'll be interested to see how you describe it, because I have my own description of the difference. It'll be interesting to see if we agree.
Okay, so so there's different ways of trying to interpret the Constitution, and we saw this coming up. And one of the things that was frustrating me like hell about Trump's attorney, who I think was the weakest one out of all of them, I actually think the one who I think he was weaker than the petitioners. Well, I guess it's the petitioner, it's the respondent petitioner. Then the anti-Trump attorney. I think the anti-Trump attorney had a much tougher argument to try making, and that's part of the reason he was struggling, is because he has very little legal basis and he's trying to present a legal argument. But I was very frustrated with Trump's attorneys in the way he was presenting his argument, because he seemed very locked into a textualist argument and completely ignoring an originalist argument, even though the justices were all like, go with originalism, go with originalism. What's the difference? So a textualist, when we're looking at a textualist, look at this. New member, lawyer Ron Coleman.
Hey, that's nice.
I'll send you a link, brother. Wow, look at this. You're now a member of the following. Now, the following is not at all a cult type of cult. Okay? So it's
not a cult type of cult. That's good.
It's not at all a cult type of cult. There's no Kool-Aid, no tracksuits that are mandatory, only highly recommended. No spaceships, no self-harm, no harming others, no stabbing yourself in the leg, no squirrel mutilations, no goat sacrifices, no throwing virgins into volcanoes, no blood spattering on the wall. It's not at all a cult type of cult. So welcome aboard. I'm going to send you a link, Ron, if you want to pop in. I don't know if you have time or not. But yeah, so I was talking about the difference between originalism and textualism. So there's different ways when we look at the Constitution, we're trying to figure out what does it really mean when we're trying to figure out parts of it that can be interpreted more than one way, or how broad is its application? Does it apply to give a woman a right to kill a fetus? All these sort of things, like how do we understand various sections of the Constitution? So there are different perspectives as to how we look at interpreting the Constitution. One that the left seems to embrace is that they look at it as a living thing, that they can basically it gives you a framework and you can sort of use that and try and bring that contemporaneous times. They wrote this 100 years ago. How do we understand that today? And when you look at it as a living thing, my problem with that is you can literally take a word that meant up in 1820 or 1789 and say, well, we use the term they find the word bad in the Constitution, which is not in the Constitution. Find the word bad in the Constitution. It'll be like when they said bad, since when we say bad, we're like, oh man, he's so bad, that we mean good. So we can say bad is good because it's a living thing. It's a living thing. That's essentially the flaw in looking at the Constitution as a living thing. You literally can just rewrite the entire Constitution, which is why I personally have major issues with that. The other two most common ways people talk about is textualist or originalist. Now, what's textualist? Textualist is basically we look at the text and we sit here and we try to dissect, why did they use this term? Why did they leave out that term? Why does it start by listing off senator and then representative and then it says electors and then it says or hold any office, civil or military? And when it says under the United States, is that the same thing as saying of the United States, or does it mean because they use the term under, that the term under usually refers to someone who was appointed by the president as opposed to elected to their position? So that's a textualist approach. We're going to look at the actual text of the Constitution and try dissecting it to read between the lines and figure out what exactly the intent is. An originalist perspective is, all right, let's put ourselves in context when this thing's being written, and then try to figure out what the hell were they trying to get done at the time? What were their objectives? What were their concerns of the day? What were their thoughts? What were the major events that led them to actually author this thing? And given that context, let's try to figure out what they were doing when they wrote this, and then apply that in modern times. So a textualist will look at this and tries figuring out the textualist argument in this setting is basically, well, I don't know if this applies to the president. It's very weird that they left out the president or vice president, and they even mentioned the electors of the president, vice president, and they seem to forget about the president. We would think they would be the first person on the list here. Mm-hmm. Or they would look at, and that's how a textualist would try attacking Colorado here. An originalist would say, forget about what the text says here for a second. Since it's not expressly in the text, let's try to figure out what was going on when they wrote the 14th Amendment. Well, we just finished the Civil War. Well, the context is that the federal government basically proved that states, you lose, federal government is what's governing here. You have to bend to the will of the states. Oh, what's another thing that's going on? We're kind of afraid of having all these people who were literally commanding armies against us 5 years ago. After they swore to uphold the Constitution, they're going to be sitting next to us in Congress. I don't really like that idea very much because they already broke their oath to the Constitution once. I don't want them sitting next to me saying, oh, I swear to uphold the Constitution, because why would I think it matters more the second time when it didn't matter the first time? So with that, given that context, so now we try to figure out, okay, if that's where they're coming from, well, now I want to try to understand, why would you leave out president or vice president and you would just have senator and representative? Why would you start the list from below president and vice president? And the attorney for Trump, what was so frustrating to me was like, I don't know, I can't come up with an answer. And all the justices, even Ketanji Brown Jackson, was like, I come up with a ton of reasons why they would leave out the president, the vice president. Number one, he's elected on a national level by everyone, by the entire country. So yeah, okay, you know what? That we might say we're going to keep out someone from this position if the person is someone who a state decides we want to send in send in Jefferson Davis to serve as our senator. It's like, yeah, just because we understand that you love him down there in the South, but if the whole country says this is our guy, that we're going to say no to that doesn't seem to make much sense. That doesn't seem to be the exact same thing. It's not at all the same thing. The entire country says, you know what, we forgive this guy. Maybe he did engage in insurrection, but maybe he atoned, maybe whatever. If the entire country decides to vote the person in, then that might be a little bit different. Another basis is to try and draw this distinction out. So an originalist is basically going to try and understand in the context of, given the events of the day, the thoughts of the day, the concerns of the day that motivated them to write this, what can we deduce about the meaning and intent of it? Very different from looking at the text and trying to parse out the words. It's more a matter of, maybe they wrote it badly, but we can sort of try to figure out what they meant based on the events of the day. That's how I distinguish between textualism and originalism. How would you distinguish? Do you think I did well there? Would you disagree? What's your thoughts?
All right, so I think the easiest way to explain this is by reference to a specific Supreme Court decision, and that's going to be Bostock, which was the discrimination
which came up a lot now. That was supposed. Yeah, go ahead. Then very timely. Go ahead.
Okay.
Sorry.
So Bostock was the case that dealt with discrimination on people in the workplace as it relates to sexual orientation and as it relates to transgender status. So Gorsuch wrote the majority opinion. Gorsuch wrote what I would consider to be a textualist opinion. Kavanaugh and Alito dissented, writing what I'd consider to be an originalist opinion, because that's the tension. So you can see two different conservative ways of thinking about this. All right. So what the statute says is, you shall not discriminate on the basis of sex in employment. Okay. So what basically an originalism is almost a looking at words almost as terms of art versus just the way the words are written on the page. So the textualist says, Gorsuch says, okay, you shall not discriminate on the basis of sex. Okay, does that include discriminating on the basis of someone's sexual orientation? And he says yes. Okay, why? Suppose you have two employees, one of which is a man and one of which is a woman. Both of them are married to a man. You fire the man who's married to the man, but you don't fire the woman who's married to the man. Why? Okay, you're doing it. You say, okay, I'm firing them based on sexual orientation. But actually, you're discriminating on the basis of sex because the only difference is the sex of the employee, right? One is a man and one is a woman. They both did literally the same thing. They both married a man. So you are now discriminating on the basis of sex. You're discriminating on the fact that one is a man and one is a woman. And so that is discrimination on the basis of sex. Sexual orientation, implicitly, you can't discriminate on sexual orientation without knowing the person's sex. You can't determine if someone's gay or straight without knowing the sex of the person you're talking about. You know, is a person is married to a man. Are they gay or are they straight? Without me telling you the sex of the person, you have no clue.
Right.
At which point you're discriminating on the basis of sex. Okay. Kavanaugh and Alito say, okay, look, at the time they were considering this part of the Civil Rights Act, they did not intend to include sexual orientation. In fact, at the time, the sexual orientation was proposed as an explicit term, along with other terms in the Civil Rights Act. It was not adopted. So there was a difference between them, and they obviously didn't intend to include not discriminating on sexual orientation, because no one in 1960 was thinking we want to protect the gays. That's just not what Congress was thinking.
Right.
So when they said sex, they were not intending to.
They were just thinking basic men or women.
They were just thinking men or women.
Right.
So this is, but the thing is, the textualist is saying, look, the term sex itself, just the word by itself, means exactly the same thing in 1960 as it does today. The meaning of the word itself hasn't changed. So do we just go with the literal dictionary definition, the textualist, or do we go with more of an idea behind the intent and purpose behind the thing, which is more an originalist approach? So
Right.
hopefully that explains it better. And between the two, I was convinced by Gorsuch. So I definitely consider myself more leaning team textualist.
Interesting. But in this context over here, I mean, even Ketanji Brown Jackson is like, look, I mean, if you what you're saying here, I mean, based on the arguments that were being made, you can basically make the claim that if a state has the power, think about this for a second. If a state has a power to just say, we think this person engaged in insurrection, therefore they're invalid and we can keep them out, what would have stopped the state of Georgia from saying, we're keeping Ulysses Grant off the ballot because we deem him to be an insurrectionist? There's really nothing that would have stopped them. And based on the argument by the Secretary of State, they don't even need to have the 14th Amendment. They could just be like, we don't like Grant. That guy basically killed thousands of our boys, and we don't like him, and we're not putting him on the ballot because he's a murderer. That's what they would say. So if they had the power, to do it, why didn't they try doing that? Unless everyone recognized they don't have that power. So
and they also have this very unsatisfying thing that was brought in rebuttal. It's like, if states have this independent power, and they also asked, the Supreme Court said, are we supposed to review this de novo? Are we supposed to review this completely from scratch? Everything is de novo just means from scratch. We give no deference to the court below. So are we supposed to review everything de novo? He says, no, you're not supposed to review everything de novo. It's like, okay, so we're supposed to take the record before us as it was given, right? Okay, great. So what happens when different states come to different decisions with respect to admissibility of an expert, with respect to what questions can be asked, with respect to what witnesses can be called? What happens when there's different evidentiary pictures? What happens when a state decides that they want to disqualify Biden, for example? And the only response she can have is, well, I have faith in, the systems, and we got to have faith that they're not going to actually do that. And I'm like, really? Honestly, it's like, seriously?
Yeah, I understand that you and I don't have that faith. The problem is that if you're thinking about it from the perspective of the courts, you got three people sitting on that bench there in Kavanaugh, Roberts, and Barrett, who are institutionalists. They probably do have faith in the system. So
I don't have problem having faith in the system, but I do have a problem believing that, if your reliance is on the state, not going outside the edges and coloring outside the edges, I don't know that you're not going to be able to find some judge who's not going to do that. And then what are we supposed to do after that?
Yeah, I forgot to send Ron his link. I'm gonna do that right now, because I'd certainly appreciate his input if he has the time. If he has the time to join. Oh, that's not it. That's not the right link. Let me just invite copy. All right, it's okay.
And also, it doesn't necessarily require conservative or right-wing people to necessarily be disingenuous to bring such a claim against Biden. For example, it has been suggested that there is an invasion going on with respect to immigration at this time. Now, I'm not sure I necessarily agree with that, but I don't think you have to be bad faith to make that argument.
Right.
So,
and
if you say that's his invasion, and then the Constitution requires the federal government to stop the invasion, then you could say, well, if it's truly an invasion, then that is supporting an insurrection.
Yeah.
That's not a completely illogical line of thinking.
Yeah, and it's a fair. It's based on Colorado's perspective, or the Secretary of State. And they can hold according to the first attorney against Trump, they can hold a hearing and say, yeah, he's totally an insurrectionist here, and look him off the ballot. And according to the second attorney against Trump, you don't even have to do that. You can just be like, hey, we just decided. I'm a Secretary of State. I just decided. We got plenary authority, and that's my decision now. I would love to see that. Oh my God, can you imagine the outcry of such a thing? So
how hard would it be for a right-wing judge to not disingenuously write that Biden is allowing an insurrection to occur because he's allowing paramilitary organizations, drug cartels, and others to invade the United States for the purposes of drug trafficking and furtherance of the paramilitary organizations, and that the countries of those people are allowing it to occur to undermine and weaken the United States. Therefore, it is invasion. Therefore, he's complicit in the invasion. Therefore, it's an insurrection. Therefore, Biden is disqualified. I mean, I don't agree with that chain of logic, but couldn't a Republican conservative judge write that? I think they could.
Yeah. Ron, welcome.
Thank you, Joe. Thanks for remembering to keep your promise. Oath keeping
I'm not an oath keeper.
This was really pretty disingenuous stuff coming out of that Colorado team.
Yeah.
I will tell you something. He repeatedly he went off on a very long exposition where he claimed that there were no due process complaints made by the Trump team. No, that's false.
Right.
There were gigantic problems with there were many objections that were made to the Colorado court that were simply ignored.
I think he was saying on the appeal they didn't really go into the due process.
Yeah, that was not one of the grounds of the Supreme Court appeal, but that's a long way from saying therefore everything was okay.
Right.
It was a travesty. One of the objections was that the court should not in any way be considering material from the January 6th commission, obviously. And that was overruled.
Yep.
It was really true kangaroo courtship, you might say.
Yeah. And also the fact that they had all of 5 days to do this, the short time parameter for them to get their evidence in order, limited discovery. I mean, just there were so many issues where he was deprived of due process in the Colorado hearing that it was almost, if the gravity of the situation weren't so weighty, it would have been comical to say that, oh, you know how we know that he's an insurrectionist? Because Colorado figured that out over a 5-day hearing as one part of their findings of a multifaceted hearing by a first-year Colorado state judge who literally got her position 6 months earlier and issued a wacky decision. But
the argument that Trump got due process is so disingenuous. So he could have called anyone he want. He is unable to identify. It's like in 5 days, a lawyer can't even figure out which end is up, because it's all so complicated.
Yeah,
it's like I can't figure this out. I need time to think about discovery. I need to see what witnesses are available. I'm not committed to a theory of the case within 5 days. Are you out of your mind?
And also like at what point, it's like you can't even figure out at what point, with respect, they didn't get at all into the free speech issues as to the claims of insurrection, which basically ignored his right to free speech, so much of the claim of insurrection and so much of the testimony and issues that came up was really rooted not in stuff that happened on January 6th, but stuff that happened as much as 6 years before. Like before he was president, things that he was saying, they were throwing at him. They're like, oh, he used this word over here, so clearly he means that we should have an uprising. I mean, literally, they were bringing up tweets from before he ever took office and throughout his presidency to establish that the nature of Donald Trump, that we know the nature of Donald Trump and that what he was really saying, even though he said march peacefully, he was really saying wink, wink, wink. That's the code that he was using.
Well, that was a
engaged in
question
insurrection.
on the Daubert
Yes.
hearing. In other words, that you actually admitted an expert's testimony to interpret what Donald Trump meant. Like, what kind of expert could possibly be qualified to do that? It's just so.
He hears all the dog whistles. Did you read that Colorado Supreme Court opinion?
Yeah.
Ron,
Yes,
did you read
of
it?
course.
There was like one great paragraph there where they just laid out this guy and like how he thought about things. There's just one paragraph where it's like this guy hears all the dog whistles. It was one of the favorite things I ever read in recent memory. It was so absurd.
It was like if Trump says anything that could be interpreted at all as being aggressive, he's basically telling you to kill all our enemies. And if he says anything that's peaceful, that's the fig leaf cover
exactly
of him trying to basically pretend that he's not trying to get you to go out there. And
in other words,
and he also said, I'll just finish and let you go. He also said this is how his fan base all interpret him. And when one of the first questions asked by Mark Gessel was, so how many people who went into the Capitol on January 6th did you actually interview? 0. I spoke to 0 of them. I just know what they were thinking. I was astonishing. Go ahead, Ron.
No, I mean it's utterly preposterous, and it would not pass Daubert. And as you guys observed, the Colorado Solicitor General was backed into the corner of saying, "Oh yeah, well whatever the states, whatever their procedure is, we have to trust in the states because." And as I pointed out in the comments before Joe remembered, if you trust the reason we actually don't trust the system to the extent that you want to suggest is because this entire issue comes up in the context of constitutional amendments that were passed after the Civil War. The Civil War was not a particularly good demonstration of the state systems working so fantastic.
Well noted.
There's a balance, obviously. I mean, and listen. What was surprising to me was a lot of people observe this. There are people who are actually figuring on a 9-0 opinion here. It's hard for me to imagine Justice Jackson going against party lines here, but there are grounds for her to do so.
If you heard were you listening to the arguments? Because she was crushing. She was crushing the guy, saying, "What about the inconsistency amongst 50 states? And the fact that they left out president." She sounded very, very right wing today.
Well, I don't know about right wing, but
very in Trump.
You sounded like a judge, perhaps.
Yeah. But I mean, one of the things also on the originalist argument that that he seemed to completely miss is if we look at contextually as to what's happening here, where the North just basically like fell on a sword to say that states don't have the right to do whatever they want. They don't have the right to just walk away. They don't have a right to pass whatever laws they want. So that's the context in which they're writing the 14th Amendment, is that, and they, in fact, they want to punish them for taking that stance and dragging us into a war. So now that the federal government has won that, according to the state of Colorado and the petitioners who are trying to remove Trump, they're saying, so then they wrote this statute, which was designed to say that any individual state has the power to affect a federal election. Think of how backward that would be. Think of how asinine the claim even is. That what they really were saying is now that we showed that federal is what is definitively has supremacy over state power. Now is when we're going to tell you that you individual state can decide a federal election and who can be on a ballot and who cannot be on it. What an asinine claim that is.
That's a little problematic.
I mean, it's you didn't have that power before, but now we're going to put it into an amendment.
Right, exactly. Yeah, no,
it's so stupid.
But I think, I mean, from a cultural and media point of view, it is astonishing how many experts were handicapping this to go the other way. I mean, no
Really?
one. Yeah, I mean, they're out there, and in fact, I'm on a mailing list of First Amendment lawyers. I don't want to mention the name of the organization, but a number of them very confidently, well, of course, Trump. These arguments are so ridiculous. Of course it's self-executing, of course, but we've reached this point where people aren't even. I mean, lawyers. I'm speaking to two lawyers here, right? We're supposed to be able to understand our adversaries' arguments in order to effectively respond to them.
Yeah.
I think we're reaching a point where people are so unable, like when you're at a stage where two doesn't even equal four anymore. The only thing I will just add is that it does seem that the Supreme Court more or less works. They unfortunately don't take nearly enough cases. But this could be the beginning of something significant. I mean, this is a relatively trivial. Unfortunately, I don't think they're going to rule on the question of whether there's whether the determination of that the constitutional use of the word insurrection does or does not include what happened on January 6th. They could, but they probably won't, given the incrementalist approach that the Roberts Court is famous for. But he certainly had what to say today. Got to give him credit for that.
Yeah, indeed. Steve, welcome aboard.
Hey, I just popped in here for lunch. Could you guys give me a summary of what happened here?
So there was a hearing in Colorado. Wait,
there was something going on at the Supreme Court? No, I missed the OA, so maybe you guys could summarize what the OA. I've been reading a little bit, and I just come on for lunch, and I wanted to hear what y'all are having to say.
Yeah, well, when you say OA, you mean overall, like
oral argument? That's what the cool kids call.
We lawyers call things.
I've never heard it called that ever, Steve.
Me either. That's a new one. But you know what? But the guy who's actually argued in front of the Supreme Court here right away recognized it as being an oral argument.
Let's get this clear. I did not, as much as I like to. I was at counsel table. I was counsel of record, but my partner at the time argued this Lance case before the Supreme Court.
Bastard. Stole your thunder.
He's a gentleman, and that's why stories I can tell you. But and in fact, I never heard during that entire process, and when I was dealing with scores of professional appellate advocates, I never heard anyone say OA. But
common in our office.
Today I saw someone referring to it on Twitter, and I first thought, well, maybe it means overall.
That's what I said.
No, I didn't think that, Joe. But I get it. I figured it out.
Yeah. So oral argument. So the oral argument, I'll tell you, I was very unimpressed. Not very unimpressed. I was very frustrated. Is the better way to put it, with the refusal of Trump's attorneys to basically give what the justices seem to want to give him. He took a very strong textualist argument. He was rooted, and he pretty much, when they asked him, that they felt like even his textualist argument, what he did was this: he fixated much more, and the justices even pointed out that he fixated much more on the part of him being an officer of the United States, rather than he said this really supports our position much more strongly than the argument that it says an office under the United States. And they're like, you seem to be making a very big distinction between office and officer, that office could be referring to him, but officer is not referring to him. And we're a little confused as to why it is that you think that you're drawing this distinction, that you're being, I mean, he was so deeply rooted in it. They're like, wouldn't you want to take maybe like an originalist perspective here and trying to understand and trying to dissect this? And he's like, well, I don't really see how that supports our argument. I'm like, are you out of your mind?
Well, I do appreciate the problem from the attorney's point of view on when to switch and when not, because you might have a theory of the case and you might have a particular strategic idea of how you want to present it. You may not want the justices get lost in a different idea. So I do appreciate that it's sometimes hard to know when to fold and not.
You can't change tactics during oral argument. Once you make a concession, it's
that's
over.
Rough.
It's
right,
over because then you're winging it the rest of the way. And so that's what you remember at one point where Alito said, stop. Well, I think, wasn't it Alito? Stop changing the hypothetical. I like to do that also.
Mm-hmm.
But you need to answer my hypothetical, because sometimes the only way to beat the simulation is to reprogram the computer, because you can't win.
What Ron is saying here, because first of all, you should, especially Supreme Court, I mean, you should game it out. I mean, when we have an
perhaps 100%,
yeah, when we OA a case in our district, or especially the Florida Supreme Court, we'll have we'll round table it, and you think about what are the points you want to make, what are the concessions that you're willing to give, and which ones not. And I would say that there was a big debate within our office about whether OAs are helpful or not in the Fifth, or at least our district, because what'll happen is, if you're not good on your feet, which a lot of appellate practitioners are not, you will get trapped by tricky questioning and say, well, counsel, you would concede that. And the judges up there, they know what the debate is, and you think the debate is over here, but then you just conceded 3 of the justices on the Supreme Court because you're like, oh, I think the battle's over here, when the judges know where the battle's being fought behind the scenes. So yes, I would agree. You really need to know where your boundaries are. You should not stake out absurd positions, because when you do that, you'll get destroyed by one or the other. You aren't saying this, are you? And they'll take you to the absurdity. So it's a tricky thing. But of course, if you've got a weak case, then you're the one that's tagged to argue it. What is your job there? I don't know. Do you dig in, or obfuscate, or change the hypothetical, or what do you do?
I mean, if you're the if you're representing Colorado or their opinion, you're obviously stuck with what the Colorado Supreme Court has lovingly given you. So I can only try to make their nightmare work. So what do you want from me? It's like, I'm stuck here.
So yeah, and here's the thing though. This is what's so frustrating, is you sort of have to, when you're trying to figure out about abandoning an argument, and I'm in the middle of putting this poll up that you're asking for, Tina. So I'll have that up in a moment after I finish my point here. But what's frustrating is you sort of, once in a while, even as an attorney, I think sometimes we get too trapped in what sounds like a compelling legal argument while ignoring a layperson common sense type of perspective, and the humanity of, like, what type of message are we sending? And I think especially when you're arguing before the Supreme Court, where they have to be cognizant of the fact that this is something that the entire country is going to be trying to understand and dissect.
Well,
so
let me piggyback.
I'll just finish my point, and that is that so now when you're trying to make such a distinction between office and officer, think about how that sounds to anyone. You can make a really compelling legal argument and say, well, based on the Constitution here and there, so when it says officer, it means something very much significantly different from office under the United States. That doesn't sound right. When you make an argument based on the fact that, hey, this when you look at the fact that an originalist argument is something that is people want to look at it and think this makes sense. When they were writing it, this really makes sense. Does it make sense to say that there's a big distinction between officer and office to a lay person? I guarantee you, to most lay people, that doesn't make sense. Does it make sense to, on the other hand, what works for you is when you're making an argument that fits with what makes sense. And like the argument I was making earlier, the originalist argument of, does it make sense that right after the North won the war, they say we want to give much stronger powers now to individual states to control our federal elections? That doesn't seem to make sense. If you're taking the side of common sense, you're starting with a win rather than fighting this uphill battle. And I think you sort of need to recognize that when you're crafting which arguments you're going to be fixating on in something that's going to be compelling.
Yeah, I noticed that a lot of the justices, and look, it's a privilege that you have when you're the panel, when you're the judge. You can step out. You can decide what the paradigm is going to be. So you can do exactly as you just said, Joe, which is ask common sense questions, which you heard the justices doing.
Yeah.
And, you as a lawyer you can, but it entails some risk. Say, well, Judge, think about what you're saying. Or, Mr. Justice, think about what you're saying. That would be so silly because here's why. You have to have a tremendous, there are some appellate advocates who are just so in command of the theater.
Paul Clement can get away with that.
Yeah, and Lisa, my dear friend
Blatt.
Lisa Blatt, who practically talks down to the justices at this point.
Yeah, I noticed that. Yeah.
But as a general rule, but that's why you moot court. That's why you have practice arguments, let me
piggyback what Ron had said a few moments earlier, and that is about our failure to recognize the strength of the other's argument. And that is an art. And I think that's the key to effective lawyering. If you have to, on the one hand, identify the strengths of your case and go with your strengths, and you think this is where I'm going to win. But then you also have to say, all right, well, what are the strongest rebuttal arguments and how do I counter those and work through those things? And a lot of times, and I agree that, I don't know, it's a youth thing. So I'm not sure if it's just because you're seeing younger lawyers or it's a cultural thing that we're getting more polarized. But it's definitely a weakness, I believe, for a lawyer to be ideologically grounded to the point that they are not able to understand the other side's argument. And
yeah, you cannot be an effective litigator if you can't remove yourself from, at least temporarily, from your own camp and sort of intellectually just traverse over to the other side and say, if I was sitting there, what are the most powerful arguments I can make? And that way you can fortify yourself against those arguments so you can rebut them as effectively as possible. That's just effective litigation. Ron, when are you debating Shem on bird law? I don't know what that even means, but
yeah, I mean, you should be able to argue your opponent's side, hopefully better than they can, to be able to really be understanding this thing so that you understand exactly how I'd go about making the argument. And I think both Steve Gosney and Ron Coleman are completely correct. This is all what it comes about with prep. One of the nice advantages at the Supreme Court, typically, especially in a high-profile case like this, is you have so many amici briefs. So one of the things that you can do is you can look to them for guidance on various ways to approach the problem, various ways to think about it, various ways to come about the problem. And then, of course, you mute it. You get other people to come in and ask questions that they can think, and you figure out how to respond to those questions.
I'll tell you something funny. Little war story, and I've got a call at 1:30, but I can hang out a little longer. When we were prepping for the slants oral argument, there was one question that was obviously going to be asked, and the partner of so I had handled the oral argument in the federal at the TTAB. Well, there was no oral argument at the TTAB at the federal circuit for the panel, and then en banc at the federal circuit, which was 11 judges, not merely 9, or maybe we even had
a paltry 9.
And not only that, by the time we got to the Supreme Court, it was 8 because Nino had died, and it had not yet been replaced. But plus, Ginsburg was like a Geisis. Joe, you can explain that later. You've heard me talk about this before. But the answer, it was, and it happened to be a very, like, it's a question that really grabbed people's attention, which was, and again, if those of you not familiar with it, why should you be? This is the Slants case where the Supreme Court ruled that the government cannot prohibit the registration of a trademark because it's hurtful.
Yeah,
basically.
A free speech case, basically.
A free speech case arising under the trademark law. So the question was,
it was about, if I'm correct, it was about a rock band that they wanted to copyright that they were trademark the term slants. They
wanted to register,
and that people thought it was racist
trademark
against Asians. That
they wanted to register the trademark, which is an important point. And again, I'm not going to hijack this and talk about the slants.
Right.
But in terms of prep, the question is, well, how is Mr. Tam's First Amendment right being in any way affected here? He can still use the name The Slants for his band, whether he gets a registration or not. And that was the question that we really had a hard time answering.
Mm-hmm.
But I said to my partner, who was the head of the appellate practice at the firm where I was at the time, I said, John, when they asked that question, the answer is, no, Your Honor. Actually, one of the things you get when you register a trademark is 50 state precedents priority, regardless of whether you use the mark in the other states.
Mm-hmm.
By depriving Mr. Tam of that privilege of registration, he, in fact, cannot call his band The Slants if he gets to a state where someone else uses it that he would have been able to prevent them from use. So so in fact, his speech, that was the perfect answer. The problem is my partner, he's a First Amendment guy, and he can rattle off the names of all the First Amendment, but trademark law to him was like, vamos, Joe. It was like he could not get his, just couldn't.
You basically want me to explain every Talmudic term that you've
Nah,
heard.
not you can't. It's just too obscure for him. And when that question was asked, I was sitting next to him at the table. And one of the things they tell you before you go in is,
you jab him the leg. Did you jab him the leg?
Two things you don't do when you're sitting during oral argument. One, there's a big clock above the justices. Don't look at the clock. Never look at the clock if you're speaking. And number two is no note passing to the person who's speaking. So he's fumbling around trying to get up and answer this question. And I'm thinking, oh, John, I told you how to answer that question. So I wrote a note and I put it under his water glass, hoping he would see it at some point before he didn't see it. We won anyway, because and this goes back to a point that you were saying before, which is that sometimes you have to feel for the other guy. The government was in a position of making truly preposterous arguments because they simply couldn't win that. They couldn't win. There's no way that they could win it. And here, the Colorado lawyers, they have some real stinker positions that they're stuck with. And, their job is to just take the heat and, do what they have to do.
Yep.
I have an interesting little, if people are interested in the minutia of oral argument and about maybe looking back at a very interesting case, there's a book called Gideon's Trumpet by Anthony Lewis about the Gideon v. Wainwright decision. And if you read that, it talks about Abe Fortas. Most people know Abe Fortas was the attorney representing Gideon, but people don't know about the state of Florida. And the state of Florida was represented by a fellow named Bruce Jacob, who was actually a friend of mine, who was a dean of the Stetson Law School. And I knew him back in the day, when I was back at Stetson for years. And it's the book, Anthony Lewis's book, Gideon's Trumpet, is well worth it because it talks about, because Bruce Jacob knew he was going to lose when he got that case assigned to him. He was assigned to take this stinker, and he knew which way the court was headed, right? But yet he had to go and argue before the Supreme Court of the United States. And the book does an excellent job of talking about how he prepped and how he prepared. And even though he knew he was headed for a buzzsaw, he did his best for the state of Florida. I'd highly recommend that book for people who are interested in that.
Yeah, as a criminal defense lawyer, nothing you're unfamiliar with, having to try to make the best out of a very bad factual situation, right, Steve?
Occasionally we get it. Yeah.
Okay, so I want to get to some. I'm going to urge you all. Look, I understand. Me personally, I'll tell you, when I'm watching a live stream, a lot of times when they get to super chats, I kind of like zone out. I'm just going to point out to you, there's a lot of great questions that came up here, and some of my own questions that I threw in here. So with respect to this discussion, and because this is such a legally, it's such an enjoyable thing for lawyers to discuss, because there are so many interesting legal issues, which I expect I'm going to be addressing as I'm going through these comments here. So I recommend, look, I understand there's going to be some which are, basically people expressing gratuities, but there's a lot of great questions you're going to hear in here. So I urge you to stick with us as I go through this. So, like this is a question. Some of them were not even super chats. I was like, you know what? I think this is an important question that I want to address, that people are going to, that a lot of people watching are probably wondering this: doesn't an insurrection have to have occurred? And the answer to that is yes, it does. If in order for the 14th Amendment to, Section 3 of the 14th, hold on, I am not finished. This is the start. An insurrection does have to have occurred. The question is, and that Kavanaugh asked correctly, is who's determining it? What yardstick are we using? How do you define an insurrection? And
who decides? Who decides?
Precisely. Do I think an insurrection occurred? No. Do most of my fans believe an insurrection occurred? No. Does anyone on this panel think an insurrection occurred? I'm going to go out on a limb and say they would answer no to that as well. But that doesn't mean that there aren't, a lot of people out there who at least have convinced themselves that there was an insurrection, whether or not one happened. So with respect to that, that's not really a primary legal issue. That's why, with respect to trying to understand this, when the Supreme Court is sitting here, they're not going on a fact-finding mission. And really, when you're asking this question about whether an insurrection occurred or not, they're not trying to sit there. There's no way. Even if they come out 9-0, there's not going to be any opinion, not even a concurring opinion from any one person saying, P.S. Trump, there was no insurrection. You're just not going to find that, because
you might get a footnote if you're lucky.
I mean, as much as we would all love it, we would all love it. I'm sorry, but they might say, go ahead. They might say there hasn't been sufficient. There hasn't been a sufficient determination that's been made, or the different. We can't have to have one yardstick on it. But I cannot imagine anyone going to say this was not an insurrection, because it's not a legal issue. That's a factual issue.
Okay. I'm gonna push back, because this is exactly the type of thing that you might want to moot court, because you're making, and that's a rant. And I obviously agree with you. But how would you respond to this position if I was on the justice on the Supreme Court and I said, well, counselor, isn't that a fact question? And didn't the Colorado Supreme Court make as a finding of fact that he was a participant? And doesn't the appellate court have to defer to findings of fact to the fact-finding court?
That came up. That exact colloquy did in fact take place, because then obviously what would be your Socratic next question? And to what extent do we defer? How about in the states where there is no judicial review? This came up. No judicial review of a decision by the state attorney general
or the secretary of state.
Right. I'm actually dealing with this issue right now in the next death penalty case I'm arguing in Florida before the Florida Supreme Court, because I got called out by the Attorney General's office for misrepresenting facts in a death case that was the last case that I did. And I know as a matter of fact and truth that the facts are not as the facts that were recited by the lower court nor by the Supreme Court. And it's a very esoteric issue, but they're saying, but because do I have now an ethical conflict between saying this case says what the Supreme Court says it says, or the facts that I know them to be, which conflict with the Supreme Court's decision making. So, that puts me in a ethical. I'm having to moot this and really think about my answer, so that if the court comes back at me and says, "Why did you misrepresent the Colley case?" is the case. I'll say, well, Your Honors, it's because you all got the facts incorrect. And the thing is that it's like, well, you have to defer those because we find truth because we write it from our pens. Well, their pens don't determine truth. The facts of the case determine truth. I don't care what you write. I'm not going to misrepresent the facts. And in fact, the what was it? But I don't want to get down in that rabbit hole and distract myself. Oh, Ron.
Yeah, he had to go. He hit 1:30. He had to go.
Oh, I have to go
his
too.
work.
Is it 1:30 already?
1:28.
It's fun.
No.
I should be back. I'm working from home, so I can duck a little bit. But no, so I'm put in this ethical dilemma about how do I deal with it. On the one hand, I want to respond forcefully.
Mm-hmm.
On the other hand, it distracts from my current case if I get wrapped up. So it's like, But the fact is that, well, she should defer to those facts because they were found by the court. But that doesn't mean it's true. You see, it's a screwy. I don't know. I'm going to delete that case from future briefs because I just made the point because it sticks in my craw.
What do you guys think as far as the final termination? I put up a poll as far as 5-4, 6-3, 8-2, 7-2, 8-1. What do you guys think? How do you guys think this will
I'll go 8-1.
You're going 8-1.
I'm feeling optimistic today.
Who's the one?
Sotomayor.
Oh yeah, she was. I actually think it's gonna be 9-0. I mean, she was finished when she was finishing there. She's like, yeah, it sounds like we're gonna have like 50 different rulings if we give states this power, and I think that scares her. I think that scares her. Like she's like, that sounds kind of crazy. When she was getting pushback from the attorney on that, she's like, the reality is that's what we're gonna have. You can sit here saying, hey, we're going to have 50 different decisions if we give states this power. I think they're going to strip state. They're going to basically make an official ruling saying that this is beyond state purview. And secretaries of state can't make this termination. And that they're going to kibosh it that way. Because otherwise they're opening up such a Pandora's box. So that's how I expect this to. I think it's at least 8-1. I think Kagan's going to go along with the majority. And I think even Sotomayor, I'm hoping will come along with it. A 9-0 decision just to put this to bed would be a healthy thing. And I think that might be part of the argument that some of the justices that Roberts might make. Like, hey, look, we're going to have so much division if we don't have the left signing with us on this. So I think they're going to get pressure on that. Zachary, thank you so much for the super chat, my brother. I appreciate you. And it's my pleasure. And I'm going to drop Mary. I'm going to hit up the people who dropped memberships. That was Mary. That was also K-Val gifting 5 memberships, and Bella Stella, who also was just gifting 5 memberships there. Thank you all. Thank you, you guys. I appreciate you in ways I can't describe. Zachary asked this question here. I'm going to hit him with this also. So I got 50 people with. If you drop a 50 on me, I'm gonna give you the war horn. If they allow the states to remove Trump because of January 6th, could they not then bar anyone involved in the J6 protests that they have been rounding up lately to ever run for or hold office in the future, essentially ending the MAGA movement? Well, to answer your question, first and foremost, the text of Section 3 of the 14th Amendment specifically refers to those who have previously taken an oath to support the Constitution. So most people who attended the J6 rally probably have not taken such an oath. So it probably will not apply to most of the J6 defendants. Second of all, it could be that we could see in a ruling here. You're saying if they allow the states to remove him. So yeah, I think that would be the best defense. But what do you guys think about a ruling which basically says that no one can be, instead of taking from the states, alternatively, they could say you have to be convicted of insurrection?
That works, yeah, because that only Congress. Yeah, that works. So Congress, in past iterations, has created enabling statutes that have given power to other authorities, because the language seems pretty universal. Congress, by the Section 5 of the 14th Amendment, Congress, by appropriate legislation, can enforce the articles. So Congress could give the power to anyone they want, pretty much, but they actually have to do it. And in the past have done it. So I think that makes total logical sense. They say, look, this is only for Congress's decision. Congress in the past has given authority to these other people. At one time, I believe a federal prosecutor was able to bring this case. I think at one time even some sort of state official was. It's been a while since I looked into the details. But it's up to Congress to make the law, and they've allowed all the laws except for the Insurrection Act that you quoted in Title 18 to remain. So that's all that's left. And if Congress wants to change its mind, it can. So I think that makes total logical sense.
Although if they were to come to that determination, wouldn't 18 U.S.C. 2383 pretty much swallow up this entire section of because it would be if they come to if the Supreme Court, the question that we're discussing now is a situation where the Supreme Court makes a decision here saying, in order for Section 3 of the 14th Amendment to apply, you have to be convicted of insurrection. If that's the case, though, if they were convicted of insurrection under 18 U.S.C. 2383, that already would invalidate them, and which would make this superfluous, because
I would phrase it slightly differently. I would say, in order for you to be guilty, well, guilty is not even the right word. In order for Section 3 of the 14th Amendment to apply to you, it must apply to you in a way that Congress directs. And the only thing that's left happens to be the Insurrection Act. But that isn't that isn't the only way in principle.
Right.
In principle, it could be anything. It could be a civil procedure. It could be a criminal procedure. It could be a state official. It could be anything that Congress wants it to be. But since Congress has not created that, the only thing left happens to be the insurrection statute. So it doesn't swallow the rule. It just happens to be the only example of the rule at the moment.
Right. V Radio asks, why is the argument not just simple as he was not convicted of anything regarding insurrection? It's like they want to be able to do this with no due process. Now, you have to try and steelman the other side here. The other side would say they had a 5-day hearing, and they determined, they relied mostly on the J6 committee report, but for much of the evidence of him being engaging in insurrection, but there was a hearing, so that's what they would claim is that's how the left claims due process has been satisfied. Many people disagree, including myself personally, disagree with that assessment, but that is what the other side of the argument is. It's like they want
because it's not a criminal process, the due process requirements would be less than in a criminal process. So there's that.
Right, and that answers your follow-up question here, or follow-up comment here. I also made a note here, which I think we already addressed, which was it was amazing watching KBJ doing a better job arguing originalism for Trump than his lawyer. I mean, it was
maybe that was all part of the super secret plan. Maybe they were trying to do it deliberately to bring Jackson onto the dark side. That's good.
Yeah. Dark Lush says, you will never convince me that his lawyer isn't intentionally trying to sing Trump's case. Also, Jackson having better grasp of originalism than this dude. WTF. That was funny. Good Lawgic. Do you think 9-0 is a possibility? Yes, I do. If you ask me, I've said before oral argument today, I think it's going to be 7-2. And someone else actually said that Barnes predicts KBJ vote with the conservatives because of her strong civil rights convictions. He may be right. Could be that. It's civil rights. It could be. It could be pressure from Roberts, because I think there will be pressure, because I imagine how bad this would be politically and how divisive it will be politically if it comes 6-3 with the right versus left and allowing Trump to stay on the ballot. I think that could be potentially
well. Let's talk about that for a second, and I got to get going here pretty soon. But, because Roberts is such an institutionalist, and because I think that he's going to push very hard to get a unanimous decision. And because of that, I think the decision might be very short and sweet and narrow and to the point for something like Trump is not an officer and is not enumerated under Section 3, and just that's it. So case resolved. And then you're going to see us that'll bring everybody on board, and then you'll see a bunch of concurrences that will be basically sound bites for the media from the lefty judges slamming Trump, but saying, but I agree with the judgment. So I think that's probably what you're going to see.
That sounds right.
That's an interesting take. I don't think it's going to be that short. I mean, look, I think they want to get this out quickly because obviously the time sensitivity of all this whole issue. We got March 4th is Super Tuesday. I think it's March 4th, but that's less than a month away. I think they do want to put this to bed. I do expect on the time. What do you guys think on the timing of this thing? You would know this probably better than
It's going to be fast.
It will be,
I think it's
right?
going to be before the end of the month. I think it's going to be fast.
Yeah, it's likely to happen. So Hallie, I appreciate you pointing out Venmo to me. So Hallie asked two things. So first said, I hate that I never catch you live. I also have to search for my answers and I never ever find them. Is it possible to write the judge in the Crumley case and request a sentence that is no jail time? Like on her behalf, the jury got it wrong and the judge added to it. You can write. I don't think that's going to work because I think she'd be afraid she'd be lynched if she did that. So, yeah. And by the way, I just want to mention, Hallie, that I appreciate it. She sends me money on Venmo all the time, just like random thank yous. So I just wanted to express my gratitude for that. She also says, I don't understand why we're having this conversation. As far as I understand it, he's never been convicted of insurrection. Why is this the hypothetical? I'm about 35 minutes behind, so maybe I'll get the answer after. I think we covered that by now. Chugi said, Brian Krasenstein listened to it and thinks Trump will lose. But I'm like, what? I don't feel like we're listening to the same broadcast as him. I have similar questions. I don't understand some of the perspectives I hear, but
hey man, I gotta go. Hey,
later,
it's
brother.
great seeing you, and we need to do a stream sometime soon. All right.
Invite me anytime. I'm there.
God bless you. See you later,
Thank you, my brother. Lisa Franceschi, thank you for the $5 rant of booyah. I'm not sure which point that she dropped that, but I appreciate all the same. Also, I had here Midnight Green saying, was Gesser unavailable to argue for Trump? I thought he did well both times in Colorado. I don't know why he didn't argue. I think he was much better than Mitchell, who argued today. I don't know who Mitchell's first name is, but I heard the justices refer to him as Mr. Mitchell. I did not like Mitchell. I did not like him at all. Chugi asks, well, Joe, you're frustrated with how he did his argument. People on X insist Trump hires the worst lawyers. Was that one of his? That was one of his. He's bad at people selection. I don't know. Look, I've said this before and I'll say this forever. When it comes to him picking lawyers, he has a much more limited selection than most people, because a lot of lawyers would look at it as, if I put on my resume, people and publicly known as Trump's lawyer, that will destroy my career. I'll never get another client.
No, there's some fairly conservative white shoe law firms out there.
There are. This Jay Sekulow is really good about it. Some people are so deeply entrenched. A handful of people are so deeply recognized that they don't have to worry about stuff like that, like an Alan Dershowitz, and even he gets some heat because he defended him in the impeachment. But there's a lot of, no big firm wants to touch him because they're afraid they're going to lose all their corporate sponsorships. All the corporate clients are going to, they're massive corporate clients. So anyone who's representing an international company is not going to want to represent him, because they're like, they are correct in recognizing they'll lose money. It's like, and lawyers, they care about their money. They care about their money a lot, like anyone else. So yeah,
I'll do it. I'll be better than some of these lawyers that Trump has got so far.
He needs to find us. Trump, I'm there for you.
I don't really have any trial experience. I'll still do better. I know what the federal rules of evidence are. I know how to read them.
This is true. Mile High Madam asks, after this, can you talk about whether it would be possible for Colorado residents, such as my stepson, I don't know, to sue the Secretary of State for an attempt to disenfranchise me? I would tell you that is it's very unlikely you'll find a cause of action, even that you could bring that in under. You can't just say deprivation of civil rights.
1985, 42 U.S.C. 1985, try to squeeze it in there
Which
somewhere.
is a very, very broad application of the depriving my civil rights. You're not getting anywhere. You're not. Yeah. You can sue anyone for anything usually. Although, frankly, when it comes to suing a state, you actually need permission from the state to sue.
Sovereign immunity, baby. Sovereign immunity.
So that's one of the trickiest areas. But yeah. And I also made a note here at some point where I was talking about Georgia banning Grant from the election. If we're going to have if you can just basically ban anyone under the way that the anti-Trump people are arguing. There's really no reason that Georgia couldn't. If states have that power, if they have the power to say we can take you off if we think you engaged in insurrection, it's self-executing right away. You can't do it. They had, in that case, you have to ask that means that the United States Congress that had just won the war was giving the state of Georgia, state of Virginia, state of South Carolina, and North Carolina the power to say we are taking Grant off of the ballot. Think of how preposterous this notion is. And that's what Colorado is essentially arguing, that the federal government passed this amendment for the purpose of giving states the power to decide that they can say, we don't like this guy. We think he engaged in insurrection. He shot up all these Americans. You can make a great case if you're sitting there during Grant's election, you're trying to figure, and you want to make a case under the 14th Amendment that Colorado is making. You can make a really strong and compelling argument saying this guy literally butchered tens of thousands of Americans, and he's an insurrectionist, and he has to come off. That they can make that claim and make that finding, and then say, well, he's not on our ballots. I mean, think of how ridiculous that sounds. Could this have potential being 9-0? Yeah, I think it definitely has the potential. Will it be? I don't know, but I think 8-1. I would be voting in my poll up there that's sitting in the chat. I'd be voting 8-1-9-0. Uncivil streams many Supreme Court cases. None of this combative. Do you think this was more combative than most?
I think the bench was definitely hotter in terms of like pinning the attorneys down and really wanting answers. I haven't really seen anyone, even Gorsuch, really like throttle the attorney before them to death that much in a while.
Yeah, all right. Jackie says his Colorado lawyer is Gorsuch former clerk, and he got slapped around by him. LOL. So I wanted to explain all when they were talking about all officers. So I think that's I think that's under Article 2, right? Article 2, they referred to all officers being appointed by the President of the United States.
Mm-hmm.
So
I think that's a fairly weak part of the argument. Definitely would not be what I would pick up on to argue that Trump is not an officer. I think that's not the best way to go about it. Just much better is that the states can adjudicate this.
Right.
That's me. That's my judgment.
But I don't think it's an irrational argument. I mean, when we're looking at this statute here, and they call him an officer, they say all officers of the United States are appointed by the president, and obviously the president doesn't appoint himself. So since the Constitution itself says all officers of the United States are appointed by the president,
I'm aware. Yeah.
That really. So how do you now say that he's an officer of the United States when he's obviously not self-appointing? I think it's an underrated. I actually think it's a little bit of an underrated argument, and it was picked up on by one of the justices. I think it might have been Alito, which is. So that's why I made a note that I wanted to just point it out, because they just referred to all officers and saying, it says all. It might have been Gorsuch. That it does say all, doesn't it? And, he's like, yeah, but we would argue, but whatever. Maybe his counter, I was like, Thank you for letting me ask Mars my question last night. If you have time, can you touch on how judges may rule given the questions asked today? I think we've been covering that. Who's ready for Tucker's interview? Tonight on Locals, I am going to be covering live when it drops at 6 p.m. goodlogic.locals.com. I'm going to be live streaming at 6 p.m. tonight, which is a little over 4 hours. I'm going to be watching that as I think it's happening live, and I will be live streaming it. So there you go. I just wanted to share that with you. That's going to be at 6 p.m. on Locals, goodlogic.locals.com. They lost KBJ. They just lost at it. They just lost. Trump won. Yeah, I agree with you. Losing when KBJ started siding with Trump, I was like, I think it's time for you to just like turn around and walk out of the room. And that's why H. Coffee says if KGB rules in favor of Trump, will we see the media turn on her and point out how she couldn't even define what a woman is? I don't know. I doubt it. I think they're hopeful that they'll bring her back. They'll bring her back and they'll use her at some time in the future. They're very dependent on KBJ at this point. And the list of bar positions, are any of them in line of presidential succession? So, if
Not,
we look-
well, I suppose because it refers to officers, right? And that would include the primary officers are the cabinet, which is necessarily in the, yeah. So yes.
yeah. Hello, thanks for day streaming. You're very welcome. Thank you for the very generous support, Jenny. Appreciate you. Squabob says, does America really want irate Republicans to push taking Democrat candidates off ballots?
They don't. Yeah, one of my criticisms of the left, it seems to be more of a problem on the left, is that they don't really seem to appreciate the Pandora's box they're opening sometimes, even when they're told about it.
Yep.
They somehow think it's not going to come to bite them in the ass, even though it inevitably does.
Yeah, it's
So,
true. There's a lot of short-term thinking. I think states shouldn't have the right to take anyone off the ballot, especially for president.
yeah.
In the Constitution, who can be president? Yeah, well, I
And
concur.
by the way, I was noting this at one of the points of oral argument because they were talking about the Electoral Count Act and like, oh, it would be up to Congress to do this. It's like that's not going to happen anymore because Congress changed the Electoral Count Act. It used to be you only needed one member of the House and one member of the Senate to raise an objection, and then they went into a debate, for 2 hours as to the state. But they changed it. The Electoral Count Act now requires a fifth of each house, which you'll never get, and the grounds to object are explicitly specified. So the Democrats, by their own bill, have prevented themselves from doing anything to not certify the votes in the future. So, okay.
SCOTUS is going to pimp slap Colorado 7-2 and then allow the DC court to punish him for his politics later this year. The stupid case gives them cover. So how do you feel about the whole immunity argument that is the appellate court just decided against Trump? Do you think that? Do you think it's going to come before the Supreme? Do you think the Supreme Court will grant it cert? And
100%.
And okay, so once they do, how do you think they're going to fall on the whole immunity question?
Well, I suppose I should have clarified that. I think they're going to ultimately grant cert, but whether they'll do it now or after the trial's finished is a bit of a question. I found the reasoning to be not particularly convincing, although in the third section of their opinion, it got a little bit better. So there's some stuff there that might be possible. I'd have to go reread it, though, to see what I was thinking.
Mm-hmm.
Give me a second. Let me see if I can find it, and so I can remember what I thought was good.
All right. V-Rated was very offended. I've heard someone else is the resident lefty. You're not sufficiently lefty that you go racist when a black person expresses conservative leaning thought. So that makes you not really a resident lefty. It makes you more of a moderate. I got so mad then I saw my avatar pick and thought, who was robbed my pick? It was some unknown.
Oh yeah. I remember
my face there. That's funny.
Okay, I remember now on the immunity issue because the Constitution itself, as they point out, talks about in the impeachment clause, and it says that, it says judgment in cases of impeachment shall not extend further than to removal from office and disqualification and to hold and enjoy any offices of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So it is clear that, because when you talk about absolute immunity, right, the whole idea behind absolute immunity is that you can't be charged. That's what at least the idea is. So it's not absolute, because if you are impeached and convicted, then you can be indicted. And as was pointed out, I think correctly by the majority opinion, that you are not impeached doesn't mean by logic that you can't be indicted, because it's P, therefore Q does not imply not P, therefore not Q. So if he can, so it implies that it's possible to indict the president without.
Where's the implication?
Trump was arguing for the negative implication. Trump was arguing not P, therefore not Q. He was arguing because it says if you are
if you are convicted, you're convicted by the Senate, then you can be charged.
If you're convicted, then you can be charged. So if you're not convicted, then therefore you cannot be charged. That's the negative implication. Negative implications are always a weak line of argument, just generally speaking, to my mind. So I don't think the negative implication really works. And so therefore I would consider the Constitution silent on the issue. And therefore it's suggestive that yes, he can be indicted. So I thought it was a pretty good line of argument.
Well, if you think that it's a weak argument, why write those words at all?
Oh, it's because you want to make clear the political does not speak to the legal. That's why. Because I view the entire impeachment process as political, not legal. So the rules are made up and the points don't matter. So it just makes clear that the political disposition does not have any impact on the legal disposition. That's why I think that's the point of saying it. So because we've convicted you politically does not speak to your liability criminally. And for the same reason, by the way, I don't think there's a double jeopardy issue because it's not criminal, it's political. So double jeopardy doesn't apply. So yeah, that works for me. I thought that was the other two lines of argument were not.
I agree with you on the double jeopardy issue. The reason I agree with you on the double jeopardy issue is because we actually see that even in criminal, that if it's a different entity that's coming after you, we see that you can be charged for the exact same actions under both state and federal if they're going to
multiple sovereigns.
Since there are different sovereigns, I agree with you that double jeopardy is a relatively weak argument for Trump. And say that because the double jeopardy argument, those of you who are confused by what we're talking about, is he was impeached and then brought for a trial before the Senate, and the Senate acquitted him. Now to try and bring him up on criminal charges a second time would be double jeopardy. You're trying to take a second bite of the apple and punishing him. I think that's a very, very, very weak argument, and I also think it conflicts with the argument of the implication argument because. It's just it does. We see, for example, when I say that it's weak, consider that Derek Chauvin, for his actions with George Floyd, was being charged by the state and then being charged also, even after being convicted, being charged federally for the exact same action because it's a completely different entity that the state coming after him versus the federal coming after him under a different statute, and no one considers that double jeopardy. So that's well established in American history that's acceptable and not a violation of double jeopardy. So to say that an acquittal by the Senate would be now to bring him for a second by the apple criminally is wrong. Seems to ignore the fact that we allow it in a number of different genres. However, I do think that the negative implication makes sense. And while I understand your point saying that this is only speaking to political, I think you're parsing out a lot there when you're saying that, because they're very clearly addressing the possibility of coming after him criminally. You're sure. So to me, the language there, the most common usage of the language to me is to say that they're basically saying the context in which you're able to have criminal prosecutions. And also I think historically, I think we've looked at it that way, but based on your reading,
I agree with you historically.
Based on your reading, no president has ever had any immunity for anything he's ever done. We just happen to never go after him. And now we're going to change that going forward, that you can go after him for anything. Based on this argument, you can go some district attorney from any state can now go after Trump, go after Obama in theory for launching a bomb that ends up killing a 16-year-old. I mean, think of how ridiculous that is. I mean, wherever that missile flew out of, whoever port they flew out of, the district attorney from that area could be like, oh, well, you know what? No statute of limitations on murder. He murdered a 16-year-old. So I'm going to go after him and try and prosecute him as a murderer. I mean, think of just how wide-ranging that is.
As long as you can find a jurisdictional nexus, and I don't disagree with you that those are the implications, which incidentally, the Court of Appeals in their own decisions was whistling past the graveyard because they sort of ignored the implications of the thing. It's like, if I'm right, and if the Court of Appeals is right, then that means that the moment that Biden leaves office, because, he's immune while he's in office, but the moment he leaves office, he could be indicted by the feds, and presumably, because he doesn't have immunity, he could be indicted by any state with respect to any crime that for which they would have a jurisdictional nexus. So the nightmare is immense.
It's so insane that if Biden were to go campaigning for 2024 and make a stop in, I don't know, let's say Ohio, and give a speech there where he says, we all must stop Ultra MAGA right now, at all costs, do everything we can. He could be charged by the local district attorney of the state for inciting insurrection, even if no one does anything, because incitement isn't required. There's no requirement of incitement that anyone takes any action. He could
This
just
is
be
true.
he could be criminally charged because there's no presidential immunity according to the DC Circuit Court. So there's no such thing. So if there's no presidential immunity, he could be charged right then and there. They could arrest him and charge him and say, we're arresting you for inciting insurrection. That's how ridiculous that perspective is to me, and to imply that there's no immunity, which is to me what the implication is.
I agree with your parade of horribles, and it is reason to doubt my view, but it was just something I read and I was like, oh, okay, this is interesting, and I can't beat this right now. So maybe I'll find a way to beat it later. But I read it, I'm like, okay, that's a pretty good line of argument. But you are absolutely correct that if I'm right and the Court of Appeals is right, that yeah, basically the parade of horribles is wide open and we're all going to hell.
Yeah,
yeah,
pretty much.
Yeah.
Pretty much. And and ask yourself this: what president could possibly lead? Like, how could they function when they know some political enemy at some point in the future is going to try and throw them in jail? This is how you turn into a banana republic. This is the road to perdition.
Yeah.
So
this is we're going to turn into South Korea, where for 8 presidents straight, we're just constantly indicting the guy once he leaves office.
Execute him, find him guilty of treason, just kill him.
I know it's not good.
Grimsborough says Senator from Colorado fought for Confederacy. He served in the 1910s. I think they were all pardoned though, so that could explain why he was able to serve. They were all pardoned from anything. There was a grant. There was a broad pardon that was issued to everyone who fought in the Civil War, and that could explain why he got away with that. If Trump is literally Hitler, then any insurrection anything he wanted to be. None of the libs appeared to be TDS sufferers. An easy way to burnish their reputation with conservatives would be to vote for Trump on this one. 9-0. I promised I was going to explain ghost face, which is a term that Ron Coleman used. He said that when he appeared in the slants thing, that RBG looked like a ghost face. Ghost face is a Talmudic term, which is a reference to an individual who is so near death's door that he doesn't have a status of being like a living human. So with respect, like it's like literally like moments. It's like the last gasps of breath from someone who's on the verge of death. So they have a Jewish law perspective, different status than a regular human with respect to how we deal with them and how we treat them, and that status is called ghost face. So he was basically saying that when he appeared before RBG, that's how near death she seemed. When he was like looking at her like, oh my God, if I touch her, that's it. Sorry, I just killed a Supreme Court justice. Any chance of court packing if left doesn't agree? There's always a chance of court packing.
Possibility of that.
Yeah, there's always out there. Side note: why are minimum signature thresholds be put on primary ballot constitutional? When you say constitutional, there's plenary authority for how do you get on a ballot in the first place. I mean, as far as having that threshold, I don't know where in the Constitution it says that you decide to run. I mean, I'm not even sure what that.
Yeah.
You have to. I'm not sure on the basis of why is it, you have to start with why would be unconstitutional.
It'd be unconstitutional, arguably, because to be president, it sets out all the criteria to be president, and one of the criteria is not get a sufficient number of signatures in order to appear on the ballot. So you're basically like
the negative implication, basically. And I think someone from the left can make the argument saying like we have this threshold, so maybe we can have this other threshold that you haven't been ruled out by a Secretary of State. I think you can try to make that argument here. I need to think on this one. This is an interesting question. I want to think on this one.
I'm sure there's case law on point, so
that's probably true too. John Easton's bar trial was a fishing expedition. I didn't see his bar trial, but did you catch any of his bar trial?
No.
All right. What about the fact that states don't choose the president, the electors do, and therefore, so let's play this through. And therefore, what? The Secretary of State shouldn't have the power to decide who's on the ballot. I mean, we know the Secretary of State can rule out some people, right? They can rule out someone who's under 35. So I'm not sure. I'm not sure how that would play in this context. Sherry says, how is 5D hearing valid if acquitted by Senate.
Oh, I don't think anyone's arguing that.
Oh,
I was
5-day
definitely
hearing.
I was definitely not arguing that position.
No, so no, she's like saying, how is a 5-day hearing valid if acquitted by the Senate? So in theory, I mean, as far as the 5-day hearing being valid, the Senate, see, I don't like the whole Senate argument, and the acquittal in the Senate argument is kind of, I thought the attorney for Trump might go there and saying like he's already been acquitted. That's the finding that we have here. To me, it's a very weird thing. The same reason I don't think double jeopardy term applies, because it's a whole different tribunal. I don't really love the whole looking at the Senate hearing, which we treat like it's a real hearing, but their rules for governing their hearings are bizarre to any litigator. I mean, they're really bizarre. The standards that the Senate engages in, I'm sitting there and I'm like, none of this would be admissible evidence in a parking ticket. The stuff that they were bringing in there, and some of it was really just basically, doctored evidence that they're throwing in here. Here's a video of this, here's a video of this, and then we find out later on they literally were like playing with tweets and stuff like that. And there was evidence of that there was some tampering with there was evidence that there had been tampering with the evidence that was presented, but none of the evidence was under oath. Not a single piece of evidence in the impeachment hearing, the second impeachment hearing, was sworn to by any person or given any sort of foundation to establish its legitimacy. And that's why none of it would have been admissible in any court of law. And watching it, I was just horrified. I was like, this is how the Senate engages in a hearing, that they don't make anyone swear to the foundation.
Well, again, when it comes to impeachment, as I say, like, the rules are made up and the points don't matter. That's the thing.
It's so political. It's completely political.
It is completely political by its nature. The House, the Constitution makes clear, the House is the sole body that brings impeachment, and the Senate is the sole judge to impeach, which means any way they want to go about it has to be correct. They can't be wrong. Right. They can do anything they want. They could throw dice. They could do lots. They could have some squirrels fight it out via proxy. I don't know. They could do anything. It would have to be legal. They can't be wrong.
I guess that's true. But my point is, so that's why the acquittal by the Senate to me is very paper thin type of thing, because the yardsticks they use are so bizarre, so unique and different from everything else about how we engage in a judicial system in this country, that it seems kind of weird to me to look to that. I can understand it being a condition precedent, that whatever crazy yardsticks they use are a condition precedent for charging him with a crime. Yeah. But I don't understand using their findings as like any sort of determination as to what actually happened, because their yardsticks are so bizarre.
Yeah.
I don't see the justices writing scathing a concurrence is simply because they require them to recuse themselves from cases that come before the court, especially if Trump is reelected. Justices are loath to ever recuse themselves from anything. So I don't think a scathing concurrence would necessarily preclude them from being able to judge. And if they say, look, we really think that Trump's conduct here was wrong, they're beyond reproach from the president. The president can't do anything to remove them. So it's not like, and they can just basically say that they were talking about that instance. That doesn't mean I hate the guy. I'm simply telling you that what he did there was abhorrent in their personal opinion. And that's it. So that doesn't mean that they have a bias and can't sit on any of these cases. So I don't think that would preclude them from or force a moral obligation on them to recuse themselves from any future cases involving Trump. I don't reach that conclusion on this thing. But I appreciate your support, brother. It's an interesting thought. I like engaging in the exercise, but I wouldn't reach that conclusion. Pop in my super chat. I'm going to give you one of these. To me, it's a big deal when I manage to pop a super chat cherry. And I'm going to warn you, once you pop, you can't stop. It becomes very easy. With my 3 favorite law tubers in one place for enhancement, I understand what's going on in these fascinating times. You're very, very welcome. I appreciate your support. Why didn't the ACLJ give arguments? They wrote a lengthy brief representing the Colorado. I don't know. Do you know how they determine who gets to argue? I think they gave it just to the parties. They gave it to the Secretary of State. They gave it to the petitioners. They gave it to the respondent. They didn't even give Trump. You know, there were two different defendants. Trump was impleaded, and they didn't even give Trump two cracks of the apple. I was a little disappointed by that.
No, this is incredibly political. I can only think of one instance in recent memory where the Supreme Court gave an amici time, who wasn't the Solicitor General. There's only one time in recent memory where have I been alive where and I don't remember the case specifically, but I remember it happened once and I was like so blown away by it. But yeah, typically it's only the parties and the Solicitor General. That's it. That's just how it goes.
Yeah.
There's no answer beyond that.
It's true. Eurythmic dropping a rant saying, got here late. Any chance you'll be summarizing a bit at the end? I will. Before I wrap up, I'll give you my overall thoughts and perspectives on what we saw in like a brief 3-minute synopsis. So for those of you who joined late and are curious as to what my thoughts are on what we saw. Tina says the appellate judges didn't even sign off on their own written decision. Weird. No,
that was written as a pure quorum. It was a little weird, I guess.
Yeah. Impeached and convicted double jeopardy is moot. Well, no, the point is you have to be
it wouldn't matter either way. A double jeopardy would apply regardless of whether you're acquitted or convicted.
Right.
That's the whole nature of double jeopardy. So if you're acquitted, you can't be tried again. So but then it's not criminal, so double jeopardy doesn't apply, so it doesn't matter. Yeah.
Precisely.
Yeah.
Kamakuma says, long-time lurker of Law 2. First super chat. Wow, I'm going to get you one of these. Just want to say, keep doing what you're doing. Good Lawgic. Love you, Kurt. Hope you enjoyed Texas, brother. Thank you so much, Kamakuma.
I'm moving to Houston, by the way, for those of you who have not been aware, I'm moving to Houston at the end of the month, so 3 weeks. So for those of you who are in H-Town, if you want to meet up, I'm coming your way. I'm going to be your neighbor.
Sweet. That's just a stone's throw from Jersey, where I am. So,
and indeed,
yeah,
right across the river.
It is right across the river. Allegan says, is the state truly sovereign if it cannot leave the federal? Just like in the state courts, you cannot charge both a municipal court and state court. Yeah, but they're still considered different entities.
Sovereignty is complicated.
Yeah, because of federalism, but there's no federalism between state and the city. So,
right, exactly. For legal purposes, cities, states, and cities and counties don't exist because the state is God, right? Because the state can do anything. It's like, how about that city? How about it doesn't exist anymore? That county, we don't like that county. It doesn't exist anymore either. Yeah, so they're all at the whim of the state's machinations.
Yeah. So I guess you're saying we have 50 gods, not.
Yeah.
And that what you're trying really to say is Gavin Newsom is actually Satan. That's essentially what you're trying to say. He's the
I'm not beyond this, but I did a mistake of watching it. I watched a 3-hour deposition yesterday from the Satanic Temple versus Boston, and I don't recommend watching it. It hurt my legal brain.
What do you think about the legal arguments that are coming up with respect to tearing down that statue that was in the city hall or whatever, that the satanic, you heard about this, the satanic statue that they had up there, which was taken down? So that they say it was a violation of I think they wanted it charged as a hate crime because
you'll get lost.
I think that's what they're being charged. They're being charged with a hate. I think they actually are being charged with a hate crime. The ones who tore down the satanic statue.
It wasn't an official action.
No.
Okay, then it's a hate crime. Okay,
it was put up by the state, and
some random person tore it down. Okay, that's a hate crime. All right, fine. Yeah,
you think that's a hate crime?
Oh hell yeah!
Really?
It's on the basis of religion. Why not?
I don't know that anti-religion is a religion. I mean, do you think that atheism, that if someone did something, if there was some sort of atheist type of statue, do you think that someone who tore that down, that would be considered a hate crime?
There is some case law on point on this issue, and it's been a long time since I've read it, but basically, it can be viewed as a hate crime too, for the same reasons that it gets this sort of quasi-religious protected status, because the First Amendment is about freedom of religion, your ability to choose. So your ability to choose is obviously your ability to not choose, because you cannot choose many things, and you can obviously not choose anything. So yeah, the choice not to pick is also protected. So yeah, it would be a hate crime if you could prove it for that reason. Yeah, there's case law on point. I'm comfortable with that.
I don't accept that, because I think that freedom of religion doesn't mean that you have that doesn't mean you have the same freedom to claim that freedom of religion is you can find whatever way you want to worship God. That's not the same thing as you have a freedom. The same way you don't have the same freedom of, we don't look at you having protected freedom to let's say believe that glass is actually plastic, right? It's not like that's a protection. You're protected. That no, I believe glass is actually the same exact thing as plastic. There's no freedom from persecution for that. Freedom of religion and protection of freedom of religion is the state cannot punish someone who refuses to, who embraces their worship in a different form. That's very different from saying that there's no such thing as worship. That's like a different realm when you're saying there's no such thing as worship.
I mean, you'd be committing the crime because to you the premise is that you're doing it for this reason, obviously, but that to you this person is a heretic, an apostate, a person that is all the rest of it. So your motivations are religious in their nature.
Yeah, but I'm not persecuting them because of their religious beliefs, because they don't have religious beliefs. It's the same way if I persecute someone who said that glass is plastic. So I'm persecuting someone who's saying there is no God. Neither of them are that person has a religious belief. They're rejecting the concept of there being any sort of God. So that's not a religion.
I think I would argue that you're persecuting them because their belief does not align with yours, which certainly has been known to happen, right? If a Christian were to attack a Jew because their belief didn't align with theirs, then but
I think you're ignoring the question. I think you're dodging the question. I'm going to hold your feet to the fire like I'm Gorsuch here. Okay, if someone makes a claim that coffee it tastes terrible, and I'm going to persecute anyone who says that coffee tastes terrible. So it's not a hate crime.
Well, let me answer your answer back this way. I believe it is true that the Mormons believe that coffee is a sin. So
Okay.
if there was a Mormon who attacked a person who drank coffee because they believed that it was a sin, and that's their motivation, then at that point it would be a hate crime.
No, I don't think that's right. I think you're mistaken. Maybe I'm wrong on the law, but I'll tell you this much. There's a difference between my motivation being religious and you being the target because of your form of religion. When you're comparing Christians coming after Jews, what you're basically saying is that the reason it's a hate crime is because a Christian is attacking the person because that person has a different religious belief, as opposed to a Christian attacking someone who's failing to properly recognize Christianity. So now that's a different. That's the motivation of the actor, as far as it being like, as opposed to the belief, the person's belief, religious beliefs, that they're being punished for their religious beliefs. So, okay, Muslims. Okay, well, Muslims don't drink alcohol. Okay, so
yes.
if a Muslim basically went out and attacked someone who just came out of a bar. So they're motivated by their religious beliefs, but it's not that because the other person is not a Muslim. If it's not because the person's not a Muslim, they could be a bad Muslim. They could be a sinful Muslim. It's not so they're just a sinful Muslim, but their motivation is their religion. But it's not that the person is now being attacked because of their religion. They're being attacked because of their failure to adhere to it. So that's similarly over here. If we're talking about the coffee thing, the coffee thing, or whatever, the alcohol thing. Or we come back to atheism, right? So someone who's attacking an atheist, that since that's not a religious belief, they are not being persecuted for that any more than their belief that alcohol is something I can drink.
I think I understand the distinction you're trying to draw. I'm not sure I buy the distinction. If you want me to elaborate further, that's fine. Or if you want to just press or just go on other things, I think that's fine. But I'm not sure I buy the distinction.
I think we're flying a little bit afield from the topic of the
I don't
day.
mind. I don't mind whatever we're discussing. That's fine. We're just having an interesting discussion. I don't mind.
Yeah.
But
yeah.
I just like, okay, I think we disagree. Do you want to press further or do you want to move on?
No, that's maybe we'll come back to it a little bit later.
Fair enough.
Let me get some of these chats. The whole debacle has weakened the seat. That's a fair point. The left operates under the concept of rules for thee, but not for me. So they feel like the absence of presidential immunity would only apply to conservatives, and frankly, it likely would only be applied that way. But that's a political comment. Charge Biden for gross negligence for allowing fentanyl criminals into our country, causing the death of thousands, manslaughter, crumbling. And I think that's the point that Gosney made, that or Ron made, that you can call. Oh, you did, right? That you can call this an invasion, right? You did that.
I think it would be intellectually reasonable for someone to consider it possibly an invasion. I don't think I would necessarily agree with it, but I think you could get there.
And that he's failing to protect us, and that he's insurrecting by failing to uphold his. He's certainly breaking his oath to uphold the Constitution. Argument of double jeopardy is dumb. Should be argument to remove immunity. Impeachment is the process. I agree with you. Philosophically, it makes more sense. Hate crimes equal protection issue creates class. I'm not sure where that lies in our disagreement. Do you think the Hawaii Supreme Court gets bitch slapped down over the latest 2A ruling?
I haven't read it, but sounds probably yes. What did they say?
I don't know. I didn't even know they came out with an issue.
All right, I gotta read new Hawaii Supreme Court decisions. Oh, that's fun.
Yeah, that is interesting. My religious belief is that believing in gods is retarded. If you attack me for that, it is attacking me because of my religious belief. You can call something a religious belief. That doesn't make it a religious belief. I can call my opinion that the Yankees are the greatest sports franchise in history a religious belief also, but that doesn't make it a religion. So
that's true.
So the hate crime comes from attacking the religion itself, not from the aspect of said religion. Not right, exactly. From the attacking the religion or the adherence to the religion because of their adherence to the religion, rather than your motivation is your own religion. So that's what I would argue. But apparently, is communism religion? Is anti-communism hate? See, that's what I'm saying. You can call any belief system religion if you want to. That doesn't. And I'm saying there's no difference between. Let's say someone attacks someone because they're a communist. Would that be a hate crime?
Well, typically no, because we would say that's a political, not religious belief.
Right. Okay.
And then you're going to ask me what's the difference.
But doesn't religious belief imply a belief in God?
I think a religious belief implies a view about God.
A view about God, not a belief in God.
Yeah.
Okay, and that's really the key line. Okay, that's really what this ultimately. I think you hit the nail on the head with that last comment. If you look at religious, if you look at freedom of religion as being a belief about and a perspective on God rather than a belief in God, that's everything right there. That's the entire question right there. A perspective, whether you're the persecuted person has a belief about the ideology that you're espousing is a belief about God rather than the existence of God. That right there. That's the whole thing. We read these words differently from the current United States Supreme Court. We hold that in Hawaii. There is no state constitutional right to carry a firearm in public. Oh, that's a quote. We read those words differently than the current United States Supreme Court. Really? That's what they wrote? They wrote that?
That can't possibly be true. They can't possibly have read that. There's no way they wrote that. I gotta see this. Hold on. I gotta speed read this thing.
There's no way they wrote that. Wow. That's insurrection right there. That's insurrection.
They wrote it.
Did they really?
It's right at the top of their opinion. It's literally the first sentence of their opinion. Article 1, Section 17 of the Hawaii Constitution mirrors the Second Amendment to the United States. We read those words differently than the current United States Supreme Court. We hold that in Hawaii, there's no state constitutional right to carry a firearm in public. Well, okay, actually, they're not wrong.
There's
Okay,
no state
I get.
constitutional right.
Okay, they are not wrong. Okay, so where do we even begin? All right, so many states have provisions which parallel the federal constitution, and some of the time they use literally the same words. But even where they use literally the same words, because it's in the state constitution, as to the state constitution, the state Supreme Court is the ultimate authority as to what those words mean. So they can disagree with any other court's jurisdiction when it comes to their own state law. Now, that, of course, does not mean that they can ignore the federal law interpretation, but it does mean that they can say there's no separate state guarantee, if I made sense.
But I don't know.
So,
I don't understand why you would need a state guarantee when you have a supremacy clause and you have the federal guarantee of a right to carry a firearm in public.
well, sometimes, because sometimes the state, even where it is the same words, will sometimes interpret it broader and give more rights than the U.S. Constitution.
But this seems to be limiting.
Well, yes. I mean, it does go both ways. But the reason why you'd want to do it in principle is because it gives you an independent state cause of action. And to the degree it provides you any more coverage than the federal Constitution, then that's great.
But I don't know how you could read something and say, so now you have a more limited right. And whereas you can be like, I don't care about the stupid state right. I have a federal right to carry a firearm in public.
Yeah, I'm not sure why this is a
And you're reading
issue
this on
under
the fly.
state. I mean, I'm not sure why we're arguing this specifically under Hawaii state specific law, but I'd have to read it. So yeah, okay. So I'll get back to you.
Yeah, interesting. I appreciate you calling that to our attention, William, because I hadn't heard about that case either. But he has, to me, he looks like he's Hawaiian, so maybe that's why he's more attuned to what's going on. We're in the contiguous states here, so we sort of look at Hawaii as, yeah, I guess you're a state. I guess you get 3 electoral votes that you're gonna basically use to piss on us and annoy us. But yeah, you gave us Tulsi, so I guess she's interesting.
I like Tulsi. She's fun.
She's interesting, you know. So
she'd be an interesting cabinet pick for Trump. That'd be cool.
That's not gonna. I doubt. I mean, who knows? Who knows? He. You never know. He's such a wild card on who he picks. Belief systems rather than religion. Would that be the First Amendment covered? Also, why do you hate the Irish? I don't know what that means. Hate the Irish. What? Oh, because I talk about alcohol drinking. Yeah. So that's what I was basically trying to say, that atheism is a belief system, not a religion, much like communism. And Kurt was responding that since it's a belief about that relates to God, that now all of a sudden gets that earns it freedom of religion perspectives. I don't think I respectfully disagree with him. And the reason I disagree with you is because ultimately communism, baked into communism, is a belief about rejection of God. So you can say, well, communism, that's part of it. So now if you're persecuting me because of communism, that's a persecution of my religious belief.
Well, I think that you can have a component of a belief that's religious without the entire thing necessarily being religious, especially to the extent it's not speaking about God. So you have a view about God, and then you're arguing that some other stuff that's kind of not neither here nor there when it comes to your belief in God. So, okay.
Mm-hmm. You think an originalist would agree with your take that atheists are protected? Or I think because you're a textualist. Is that what's happening here? That I'm originalist and you're a textualist, and I'm like endowed by our creator with certain inalienable rights, and you're saying there is no creator?
That's in the Declaration of Independence, Joe.
Yeah, but that was motivation for the Constitution. Come on.
I will remind you, of course, of the treaty at Tripoli, which said that the United States is not and has never been in any sense a Christian nation. There's always that.
Which that's crap. We know that's crap.
Just saying.
Oh, you're saying
it's one of the first treaties the United States ever signed.
Yeah. Okay. All right. Has been and never will be. Everyone knows it's a Judeo-Christian country, and frankly, thank God it is. So, I feel the hate crime regarding atheism is akin to heterosexuals claim protection under a hate crime. I think heterosexuals have more of a claim to it, arguably, than atheists. But it's an interesting analogy you're drawing there, Worcestershire. Didn't atheist Pastafarians win the right to a spaghetti strainer on their head for their driver's license?
I believe in some jurisdictions that's true.
Really? That's funny. The statue was destroyed by a politician because it was satanic. So because of the religious belief, it was destroyed, thus a hate crime.
I'm comfortable with that. I have no problem with this.
And I'm disagreeing with that because I'm saying that you cannot have a hate crime for religious freedom when the person is rejecting religion altogether.
And what you may or may not know is that neither the Satanic Church nor the Satanic Temple actually believe in Satan as a literal deity or literal entity. They don't actually believe in a literal Satan. They are both atheistic in their nature.
Right. So
there's that
if they believed in Satan, which I don't even know what that means, because I think Satan is like basically the anti-God, and you're saying the anti-God is God. I don't know what that means, but yeah, I don't. What I'm saying is I don't understand how atheism can be deemed a religion. That seems, and it's interesting. And I know that some of you might think that I'm talking that there's a little bit of doublespeak that I'm engaging in here, and that I'm certainly not trying to engage in doublespeak. And the reason I bring that up is because during my 24-hour stream, I had a guy on who was an atheist, and I was basically saying to him that to be atheistic, you need to have a stronger conviction to your atheism than any religious person can possibly have to God, because of the levels of a belief that you have as to how humankind was formed are, and that you're positive that there is no God is stronger than any individual could possibly actually believe in God. But so you might assume, so I look at it almost as if it's, it's such a religious devotion to atheism, but a religious devotion to something doesn't make it a religion any more than love of the Yankees makes the Yankees a religion. So that said, I think hate crimes are stupid. The reason you assault me shouldn't matter. Just the fact that you assault me, no one should be special. I agree. I find myself leaning that way a lot more and more. And Irish Representative Joe does not hate Irish. He loves us after Jews. Oh, of course. Please, obviously.
I'm not really sure if I agree with you in your proposition about atheism, because I think I don't know, but I think most religious people would say that belief in God is an act of faith.
Everyone says that, yeah.
So it is simply, faith is by its nature a willingness to take a leap in the absence of logic. It's like, it's the fuzzy, step two.
I don't have proof of this. Faith
step
inherently
one
implies.
Yeah.
I
Step
don't
one,
have
blah,
evidence,
blah, blah. Step
but I
two,
just
question
have
mark.
faith.
Step three,
Right.
Step three, underpant gnome, right? So it's question two is underpant. So the atheist is simply saying, well, I'm not willing to take the leap. And I don't know that requires more belief.
No. That's an agnostic. The way I define agnostic.
Oh, you mean it's sort of a positive thing? Oh, okay.
Yeah.
Then I understand. Fine.
Right.
All right. Fair enough.
Treaty of Tripoli was signed and ratified by the First Continental Congress, our founders. Yeah. And that's correct. And no one uses that as, and yet no one quotes, no one understands that to take it as if they rejected the existence of God altogether, which is how it gets twisted sometimes. Jackals Terra Gentum says the Church of Satan argues that abortion is a religiously protected practice, a blood right for
the
them.
Satanic Temple does. I don't know about the Church of Satan. Maybe they both do.
The U.S. has never afforded 1A protections to cults that practice blood rights, wreck all their idols. So yeah. Okay. I think. Oh wait, I had over here in locals that Johnny Reb said. So I'm at work and randomly I see this thumbnail pop up on my coworker's phone. Matt sent to him by a separate friend. Wow. So my thumbnail just popped up on your coworker's phone. That's kind of cool. That is kind of cool. Thank you for sharing that, Johnny Reb. I appreciate that. That's so weird. Because I always assumed that no one ever hears about me, like ever. Prerequisite Satanism. By the way, if you're here, if you could please like and subscribe. This is how day streams seem to be the only way I can ever actually find new people. So if you can like and subscribe, I would be much, much, much obliged. Prerequisite Satanism, acknowledgement of God. I think that depends on which Satanist you ask. Do you believe in Marduk? I don't know what Marduk is. Do you know what Marduk is?
It doesn't matter. I think it was just a point to point out that you don't believe in something, and therefore the atheist just believes in what, as Ricky Gervais once pointed out, it's like, you don't believe in 999 gods. I just don't believe in one more, you know? So that kind of thing.
Right. Yeah. But that's a fallacious argument.
You think so?
Yeah, I think it's a completely fallacious argument.
Okay.
Because there's a difference between saying, so if someone comes along and says that there's, people say, I don't think any organized religion has it right, but I can accept that there is a God out there. That's a different, which is that would be aligned with that argument. But just saying, but in order to come to a conclusion that there's no intelligent design at all, so you're basically subscribing to a belief that it was pure random chance that enabled all these ecosystems to just randomly materialize into something that was coherent, despite the fact that entropy insists that things break apart. So
in the long run, they do. Yeah.
Yeah. But somehow our ecosystems, which are all interdependent and form naturally of their own volition without anyone overseeing it, seems to me to be such an incredible leap of like the one in a quintillion possibility, which I think is far less than 1 in quintillion. I think it's probably 1 in quintillion squared. But possibility that we can't that ecosystems and oxygen and would all just form on their own. I think it's a much farther leap of faith than saying that squirrel outside created everything.
I'm not so sure, because as complex as the universe is, any god sufficient to create it would have to be infinitely more complex, and that god would have had to come around if you believe that god is eternal, then that god just exists. So somehow this being, which is infinitely more complex than the universe he created, just exists. So the idea that the universe itself could just exist when it is necessarily less complex than the God that would create it is not like ridiculous.
There you just explain faith.
Yeah.
I think you're just explaining faith. But because you're basically comparing the tangible to the intangible. In that, and you're basically equating them as being the same. All right. We really flew far afield from this, and I promised I was going to give a wrap up as to what happened in oral arguments today. So I want to start commencing that now. If you have any thoughts you want to get to before we start doing this, or if you want to do the wrap up, I'll let you do the wrap up as to what we saw during these oral arguments.
I wasn't here for the whole thing, so you're better equipped to do it.
Okay, so oral arguments. I'm going to give this is my little 3-minute wrap up here, and go. So today we heard oral arguments wherein the issue was whether or not Section 3 of the 14th Amendment gives Colorado or any individual state the ability to remove Trump from the ballot. First up, we heard from Trump's attorneys, who did, in my opinion, a fairly poor job in presenting their case and got pushed around a little bit by Sotomayor and seemed very rooted in a textualist interpretation of the 14th Amendment as the basis, as the meat and potatoes of his argument, essentially claiming that the language which says officer of the United States, that he has to have previously taken an oath as a member of Congress or as an officer of the United States, that specifically officer of the United States seems to exclude the president of the United States, because all officers under Article 2 of the Constitution are appointed by the president. So in order to qualify as being an officer of the United States, you have to be appointed by the president. Obviously, the president doesn't appoint himself. He's elected. So and that it's a term of art, meaning it's a term that has a definitive meaning in the minds of the authors of the 14th Amendment. And accordingly, when they write officer of the United States, has that you took an oath as an officer of the United States, that no president could ever qualify for for being excluded from the from holding office because of Section 3 of the 14th Amendment. He was being pushed by many of the conservatives, including Ketanji Brown Jackson, who seemed to appear very conservative today.
Based Jackson.
Ketanji Brown Jackson, who seemed to be asking a lot of questions that you would expect Judge Alito to be asking or Judge Thomas to be asking, and being pushed into an originalist perspective to say, hey, doesn't it seem like this is very inconsistent with what the drafters probably had in mind when they first put this in, when they first wrote this, to enable states to have power over federal government, over federal election? And he's like, I don't really see how. The Trump's attorney was like, I don't really think the originalist argument really helps us very much, which was just what? But, and if you were watching me here, you saw me freak out over that. Then we saw the petitioners who brought this, the anti-Trumpers, got up there and spoke, and they got pushed around and by the justices a lot. Alito, Gorsuch were hounding him with different hypotheticals. Amy Coney Barrett, even Ketanji Brown Jackson was basically saying, isn't this going to lead us to 50 different interpretations and leave us open to anyone who basically comes along and says that they think this is insurrection? And he actually fought well. He just seemed to be facing a barrage of attacks that, frankly, likely sink his case. I felt his ability to compose himself and handle these arguments seemed stronger than Trump's attorney, but the level of he's facing atom bombs, whereas Trump's attorney was facing grenades to his case. So it seemed as if even Ketanji Brown Jackson seemed to not go along with some of the interpretations of Section 3 of the 14th Amendment that the anti-Trumpers were presenting there, leading most of us on the panel here to come to the conclusion that she likely is going to join in a majority opinion, which is going to put him on the ballot. Finally, we had the attorney for the Secretary of State who got up there and basically was making the case against Trump, that the Secretary of State and each state has plenary authority, meaning that they can go wherever they want to in determining who's on the ballot. And the justices kind of left her alone. She spoke for a very, very brief period of time, and it was near the very end after we had dealt with over 2 hours of oral argument. It seems as if they had already zoned out. If you ask me what we are likely looking at here, I am very confident that Trump is going to remain on the ballot. And there's a lot of different bases here, because we need to remember, seriously, there's 8 different legal theories that you need to embrace, every one of them against Trump, to come to a conclusion to keep him off the ballot. Okay, and when I kept this up here for a great period of time, just to go through some, if not all, of the different arguments that you need to say, yep, Trump loses on this, yep, Trump loses on that, yep, Trump loses on this. And if he goes 1 for 8, they have to put him on the ballot. And those arguments include whether this refers to what office can be held. And this is one of the things the justices brought up, is they said, so I think it was KBJ who brought this up. She's like, the way I understand it is we're dealing with what office you're being barred from, what oath the person has to take, which is the second bar, who having previously taken oath to support the Constitution of the United States, whether that's the language of the oath or it's some different oath. And also, if you fall into this, in order to be disqualified from these offices, I mean, this is a list of the offices you cannot hold. If the statute applies to you and you fall into the statute, here's a list of offices that you're no longer able to hold. Then this other section here, which we talk about as a member of Congress or as an officer of the United States, or member of any state legislature, etc., that at the time that how do you get into that qualification? How do you get into that classification? Well, you have to be one of these people. And whether or not that would apply, those people who can fall into it includes the president. Each time we're trying to get the president in here, or the petitioners who are trying to keep Trump off the ballot, try to say this applies to Trump, this applies to Trump. So it seems to really exclude, in this list of people here, of which offices that you can hold, it leaves out president. Doesn't say president expressly, doesn't say vice president. Ketanji Brown Jackson seemed to have a very big issue with this. of having the president lumped into hold any office, civil and military, under the United States, that somehow they seem to very expressly leave the president and vice president out of this list and start with just senator and representative in Congress or even elector, and that to lump him in there seemed to her to be bizarre. She seemed to really struggle with this. So this is one issue. This is the first issue is, does this bar someone? If this whole thing applies to someone, would that stop you from becoming president? If you made an oath and you were a senator and you made an oath, would you be allowed to run for president or not? And the first argument is, even if you were not able to run for senator, you still be able to become president because it's not applying to the president. That's one. Second argument is, does the oath that he made, which was to defend what's the oath of the president? To defend and protect the Constitution rather than support?
Yep.
As opposed to the language over here of an oath who has taken an oath to support the Constitution of the United States, that the oath he took doesn't really apply. Frankly, me personally, I'm not a big fan of this argument. I think that you look at this language of support, it really could be read to interpret any type of support of the Constitution and protect and defend with full classification. But that's a second argument that has been made. Third argument that has been made is that in order to qualify, that you would be barred by this statute, that you have to be that seems to say that you have to be a member of Congress or you have to be an officer of the United States. And this is the argument that Trump's attorneys were really latching on to, that when you're president, you cannot fall into this classification because it only could apply to an officer of the United States, and officer of the United States is defined in Article 2 as someone appointed by the president. And obviously, he's not appointing himself, so it doesn't apply to him. That's the third argument. Fourth argument is when you have an issue as to shall have engaged in insurrection or rebellion. What is an insurrection? Who's determining what an insurrection is? Does the state have the authority to do this? At what does a person have to be convicted of insurrection? It doesn't even get into whether or not incitement. They didn't even talk about this. This issue did not come up, which did come up in the hearings, which is, does inciting, which arguably is what their claim is, would incitement of an insurrection be considered engagement in an insurrection? Which that's another argument that Trump potentially has. If you don't think incitement is engaging, then this whole thing doesn't apply to him, and Trump's back on the ballot. Any one of these arguments that Trump wins, he doesn't have to win all of them. He needs to win any one of them, and he's on the ballot. And finally, with respect to, is this self-executing? Do states have the authority to basically sit here and interpret this and then have a Secretary of State knock you off the ballot? That's not finally. There's another argument also. Meaning, is this something that only Congress can effectuate? Is this something that every state can decide for themselves? Furthermore, you have the issue of due process. How do we determine that he's an insurrectionist? And this is something that Amy Coney Barrett seemed to make a big deal about due process here, that we can't deprive someone of the right to run for president when it doesn't seem as if there's going to be any sort of opportunity for him to show that he's not an insurrectionist. There's no finding by a jury of his peers that he's engaged in insurrection. And yeah, again, any one of these arguments he wins on. And if this wasn't an insurrection, which that itself is a big question, I think many of my most loyal fans, and myself included, would say this was not an insurrection.
With respect to Trump in particular.
Right. I don't think the siege on the Capitol was an insurrection personally, but I personally would define it. They keep using the term riot at the Capitol.
I like riot. I use riot. I called it my Capitol Riot series. I called it riots from the beginning.
Yeah. Yeah, and I think that, and I've heard people try to basically apply the term insurrection to this and say, well, if you're going to call the Whiskey Rebellion, which was a handful of farmers, 200 farmers who were fighting. So then clearly this was obviously an insurrection. It's like, no, you don't know much about the Whiskey Rebellion if you're going to downplay that as 200 farmers, because A, it wasn't 200. There were literally thousands of people. B, that went on for 4 years. And George Washington had to lead federal troops out to scare them, and they literally had their own flag they built during this time. They had different conventions and meetings. It was an actual rebellion. We don't appreciate just how significant the Whiskey Rebellion was. It was a very, very, very big deal in its day that lasted for years, and they labeled themselves insurrectionists. And this is one point that I don't think I've ever made before on stream. I'm not sure if I have, but here's the thing. Because insurrection is a term of art, it's not a scientific term. What is an insurrection? What is not an insurrection? To me, if we're trying to define what is an insurrection, you really need to look at the mindset of the person of, do I believe that I am insurrecting? Because you're sort of embracing the position. If your objective is, I'm trying to overthrow the government, I want to be overthrowing the government. In the Whiskey Rebellion, which they're like, we don't accept this government. In fact, in the Whiskey Rebellion, they even went so far as to say, we want to rejoin. There was arguments in their conventions that we should rejoin Great Britain or go to France. Like, they literally were like, we're not part of this country anymore. That's how strong they were. Nobody on January 6th was making that argument. They were feeling as if the country was taken from them. None of them looked at themselves as if they were engaged in insurrection. They looked at themselves as if they were protecting the Constitution. And because it's a term of art, if the person is embracing that this is who I am, this is what I'm doing, for someone else to say, no, you are insurrecting, even though you think you're defending it, you're insurrecting, and now I'm going to attach that label to you. To me, it doesn't make sense when we're looking at the mens rea of the person, that their objective is that they feel that they're defending the Constitution. That for someone to say that that's an insurrection against the Constitution, to me seems kind of bizarre, especially from people who seem to be very supportive of the idea that you can snap and change your gender just by thinking a certain thing. But these people who don't think of themselves insurrections, other people can assign to them the label insurrectionist. To me, this seems very, very counterintuitive. Anyhow, that is my synopsis over here. As far as my expectations, I am very, 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 very confident that the Supreme Court will side with Trump.
Oh yeah.
And I would not be at all. I expect it to be at least 7-2, and I would not at all be surprised if it's 8-1. Kagan, to me, is a little bit. I can see her going either way. Even down the stretch, Kagan and Sotomayor seem very concerned with the petitioners, with the result that the petitioners would lead to here, and that result being that you could have 50 different states reaching 50 different conclusions as to whether this is an insurrection, and that it will have the effect of making a bizarre election where Trump is on 46 ballots and not on 4 ballots, or on 30. It's like, what's going to happen in those other states? So they'll have no vote at all. They seem very, very bothered by this. So I would not be surprised. Even Sotomayor expressed a little hesitation about that. So I would be more shocked if he loses than if I see a 9-0 in favor of Trump on this. So that's where I'm at on this. If you have any other thoughts as to where you're at on this.
Nope. I'm going to be covering it tomorrow when the synced audio is available with the transcript. So we'll be covering this again tomorrow on my channel and breaking it down as I do. So you can look forward to that. Tonight I have the Thursday Night Thunderdome. That's 7 Central, 8 Eastern, where we try to do a wrap up of the week's news. So that should be fun.
Yeah, and I'm going to urge you all, make sure that you check out Uncivil Law. When it comes to this any issue with respect to the Supreme Court, he really is he's the authoritative source that we all look to. It's like practically an idiot savant when it comes to knowing Supreme Court cases.
Thanks.
And I mean that obviously in the most complimentary way possible. But just phenomenal coverage and analysis of anything related to Supreme Court, as well as trademark, copyright, and 1,000 other issues. And I'm very appreciative. I'm putting links to everyone who appeared on this show as we speak right now. I urge you all, check out Uncivil Law, check out Ron Coleman Nation podcast, Legal Vices, Steve Gosney. At 6 p.m. tonight, I will be live streaming as it drops the Tucker Carlson Putin interview. That's going to be on Locals, which is at goodlogic.locals.com, goodlogic.locals.com. That's at 6 p.m. Eastern time. And then tonight I will be streaming my regular show at 10 p.m. Anything else you want to drop before we let them all go?
No, thank you.
All right. Well, I thank you all for joining me, and I will see you all later this evening over at Locals, goodlogic.locals.com. Please make sure while you're here, like, subscribe, whether you're YouTube, Rumble, wherever the heck you're watching me, on X. Follow me on X, wherever you are. Make sure that you stick around and I will see you all shortly. Stay happy, eat the bugs, and as always, Godspeed.